ಪೇಪರ್ ಬರಬೇಕು ಫ್ರೆಶ್ ಫಸ್ಟ್ ಟೈಮ್ ಫ್ರೆಶ್ ಇಲ್ಲ ಸರ್ ಬರಲ್ಲ. ಸರ್ ನೀವು ತಗೋಬೇಡಿ, ತಗೊಂಡ್ರೆ ನಿಮ್ಮ ಮೇಲೆ ಬರುತ್ತೆ ಇವಾಗ. WP ಫ್ರೆಶ್ ಅವ್ರು ಹೇಳ್ಬಿಟ್ಟು WP ಫ್ರೆಶ್ RF
CPC ಇಲ್ಲೇ ತಾನೆ.
ಹೌದು.
WP ಫ್ರೆಶ್ RFA ಮಾತ್ರ ಕೊಡಿ ಫಸ್ಟ್.
Compliance you ಕಳಿಸ್ತಾರೆ ಬರಲ್ಲ. Day after tomorrow you complaint office will have it day after tomorrow. Put a complaint.
Sir, I will send it, sir. I will send it.
No, see, urgent matter ಮಾತ್ರ ಕೊಡಿ. ಬಾಕಿದೆಲ್ಲ ಕೊಡಿ, ಡೇಟ್ ಕೊಡ್ತೀವಿ. Only if you there is any urgency to move that matter.
I have filed application for vacating in
Right, one by one. Yes. ಕೊಡಿ ಡೇಟ್ ಕೊಡ್ತೀವಿ ಕೊಡಿ. Preliminary hearing ಅಲ್ಲ. Only if there is an urgency you have to move that. Otherwise you will give a date within 2 or 3 weeks.
May seek for
by one ಕೇಳ್ತೀರಿ. Yes. Yeah, all cases stalled, mister. What is that urgency? Huh? Yes, what to do that? All suits. How many suits are pending? All there is an application. Can I have it all this? Yes, if it is. See, if there is no stay, if going to dispose of the suit, then I can. If it is a stay, we'll hear whenever it comes, mister. To do that. Can I do it all the suits here? Yes. 26th. Fresh matter. First time. It is. ಅವಾಗ ಯಾಕೆ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ? 24th. Yes. Fresh matter tomorrow ಕೊಡಿ. Fresh matter will come tomorrow.
May seek for 2:30 for this reason.
Yes.
The Nemotsava has been scheduled day after tomorrow. Day after tomorrow. There was an injunction order operating in my favor before the trial court. They filed an appeal MA. MAs came to be rejected as not maintainable. The matter was heard before the trial court passing orders. No orders have been passed. It has been
Fresh matter.
Fresh matter.
Tomorrow. Yes.
Milord. Tomorrow, Milord.
What is that matter? What is that urgency? Whatever you submitted, there is. Yes, 25th. Yes.
Milord.
25th. Yes.
Milord. Milord.
No. Yes.
Milord.
Let us see. Yes, 25th. Now, have you filed an IA for vacating? Yes, vacating you will take it on 18th. Yes.
Milord, urgency is for the impleading applicant, Milord. Milord, neither the petitioner nor the respondent, they are not interested in this. After the FDP, Milord, in the FDP there was a compromise between the petitioner and the respondent.
Yes.
The respondent and the petitioner signed the order sheet. The respondent sold nine gundas of land to me. Agreement of sale is up to stay. Now nobody is interested in this. I am the stakeholder, please, Milord.
No, which year matter?
2025.
Then
9th, Milord.
yes, 23rd.
23rd. So,
My lordship.
ಏನ್ ಆರ್ಡರ್ ಆಗುತ್ತೆ 12th March?
Please.
ಏನು what is that suit for? Suit for injunction filed by you. What damages we can order, mister? If there is any injunction order, if it is violated, you can file it there only under 39(2)(a). Yes, yes.
My lordship,
There is a recovery suit in trial court, Your Honor. Stay ತಗೊಂಡಿದ್ದಾರೆ. Stay ತಗೊಂಡು I can't pay my payments to my labor.
Vacating ಹಾಕಿದ್ದೀರಾ?
Vacating ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. 8th Friday, Your Honor.
my lordship, this is
17.
vacate trial court ಅಲ್ಲಿ,
Which,
trial court,
yes, which year? Which year? 25, yes, 23rd, yes. 25, yes, 24th.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ವೆಕೇಟಿಂಗ್ ಆಗಿದೆ ಸ್ಟೇ ಮೈ ಲಾರ್ಡ್ಶಿಪ್, ನಾಳೆಗೆ ಬೇಕಿದೆ ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್,
No, madam, fresh matter.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್,
First time.
ಫಸ್ಟ್ ಟೈಮ್
ಕೊಡ್ರಿ, ನಾಳೆ ಬರ್ತದೆ. Yes, sir.
ನಾಳೆಗೆ ಸರ್, ನಾಳೆಗೆ.
Huh? When that interim order is granted?
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಅಲ್ಲಿ ಬರೀತಾರೋ ಇಲ್ಲ ನೋಡಿ.
23 ಅಲ್ಲಿ. Then we'll hear. Yes.
Sir, ಇದು fresh matter.
26th, yes. Withdraw tomorrow, yes.
Fresh matter, madam. GMC fresh
Fresh matter ಕೊಡ್ರಿ, fresh matter. First time matters. No, Mr. First time it is before this. ಕೊಡ್ರಿ, first time ನಾಳೆ ಬರುತ್ತೆ ಹಾಕಲ್ರಿ. Tomorrow. You are for the petitioner or respondent tomorrow, yes. My lord. When the interim order is granted, huh? 25, yes. This matter on 26th, yes.
My lord, matter for vacating of interim order, my lord.
Which year?
24, my lord.
24, yes. We'll have it on 27th.
My lord,
yes.
this matter, my lord, 2026 matter, my lord. This honorable court directed me to serve the copy, my lord. I served the copy, my lord. For consideration in the interim prayer, my building has been stopped, my lord, for that reason.
That,
Construction of the building, my lord.
What is the suit for?
Suit for injunction, my lord. I am the defendant, my lord. In view of the order passed by the trial court, my lord, my building, construction of my building has been stopped, my lord, for that reason.
Yes, 16.
My lord, pending petition, my lord, summoning application was filed, said application was rejected. My lord, urgency is this, my lord. The defendant, my lord, the
Now, which year?
2024, my lord.
24, yes, 26th.
Please, my lord.
First time matter. Tomorrow. Tomorrow we'll have it tomorrow.
My lord, further proceedings state, defendant evidence close ಮಾಡಿ
23 matter. Yes, read this matter on 1st April, yes. Dismissed. Yes, 1st April, yes.
To allow the petition, madam, for the respondent, they have filed for amendment of written statement. We don't have any objection to allow the petition, my lord. Kindly post for tomorrow, my lord.
Day after tomorrow.
Really?
If it is the not deposited, there is no interim order. Go and pursue before the trial court.
Instead of paying the amount, they have approached the
Yes, 23rd, yes.
2024 matter, consideration of interim prayer.
Yes,
ಈಗ ಅಲ್ಲಿ ಅಲಿನೇಟ್ ಮಾಡಕ್ ಟ್ರೈ ಮಾಡ್ತಾರೆ.
26th, yes.
24th.
24 in the interim order ಇಲ್ಲ 26th ಅಲ್ಲಿ what is the time?
ಈಗ ಸೇಲ್ ಮಾಡೋದಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ. 24th.
Yes, 26th.
26th ಹಂಗ ಸ್ವಲ್ಪ.
24th, yes.
My lord, there's an interim order because of which the trial has been stopped for past 4 months, my lord. Any early date may be given, my lord.
Yes, 26th, yes.
It's three connected matters.
Yes, 26th.
ಕಡೆಯಿಂದ ಬರ್ತಾರೆ ಅವರು. ಇದಕ್ಕೆ ಅಲ್ಲಿದೆ ನೋಡಿ.
I will, yes, 27th. Yes. What benefit will get, Mr., if you sending him to that jail? Is there any settlement is possible? Yes. Civil prison alle ನೀವೇ ಕಟ್ಟಬೇಕು ದುಡ್ಡು ಅವ್ರನ್ನ ಜೈಲಲ್ಲಿ ಕೂರ್ಸಿ. Still doing, yes, let us see. Yes, Mr. Yes. At least you are the one counsel who has understand my difficulties. Yes, yes. No, that Friday, any Friday, the 13th. 13th, all RFA in Friday, 13th. Yes, not next week, 25th, yes.
Not the petitioner.
Which year? 25, yes. 24th, yes.
Not the petitioner has taken into civil imprisonment. In execution proceedings.
Fresh matter and
Fresh matter.
tomorrow. What are the fresh matter tomorrow?
Let's,
Fresh matter.
Once before the court.
Yes, yes, third, 27th, yes.
Well, and the written statement of the defendant number one has taken as not filed and posted for judgment on 7th, my lord. It may be taken up tomorrow.
Fresh matter.
Fresh matter, my lord.
Tomorrow. Fresh matter ಕೊಡ್ರಿ ನಾಳೆ ಬರುತ್ತೆ.
Vacating interim order, my lord, 25 matter, vacating interim order.
Vacating interim order. Yes, 18th.
Well, as IA has been filed, this court has passed in direction, my lord. Trial court is not following, my lord, and IA has been filed for direction.
Trial court is not following. What is the direction by this?
Third, an order had been passed for the tenants to deposit the rent directly to the court. Even though it was directed to the trial court to collect the tenant rents from the tenants, they are not following the order, my lord. As such, I filed an IA for direction.
Yes, 18th, yes. Yes, thoroughly. First step.
There is no stay in the writ petition. Some days, 13th, Malad, they took it for arguments of this month.
Yes,
Before
16th,
please
yes.
oblige.
Yes.
Adjournments, if any, list number 1 adjournments.
46, serial number 46, madam. Notice is awaited. Interim order may kindly be extended. Urgent.
46.
Yes, madam.
Awaiting service of notice to R1 to R3. Yes.
Interim order.
May I- Item number 1, my lords.
Yes, one time, yes.
My lord.
Yes, my lords. Yes. I'm slightly unwell.
Yes.
Week after next, my lords.
Yes, at the request of counsel for the petitioner. Is this matter week after next?
96 year, 96 year now.
96. Yes,
2 weeks time, your lords.
at the request of counsel for
Petitioner, your lords.
permitted to withdraw the rent deposited. ಯಾರ್ ಹಾಕಿರೋದು?
It has been deposited.
No, what is their application? Yes, at the request of petitioner, leave this matter next week. Yes,
Not next week, your week after next, 2
week
weeks.
after next. Yes. 100 and? Yes,
My lord, serial number 40, madam.
118 at the request of counsel for respondent, leave this matter after 2 weeks.
Serial number
Serial number
76,
40,
my
madam.
lords.
40, madam.
Serial number 40.
After next, my lord.
Yes,
Personal inconvenience. Week after next.
at the request of counsel for the petitioner, leave this matter week after next.
Mediation
Serial number 76, my
So
lords.
that is, stay is granted, my lord, may kindly be extended to till then.
Yes, have you informed other side?
Yes, sir.
Interim order granted earlier is extended till next date of the.
Serial number 76, my lords. I appear for petitioner. There's an inconvenience today, my lords. Kindly have it any day in the next week, my lords.
76,
Yes, my
you are
lords.
appearing for?
Petitioner.
Yes. At the request of counsel for the petitioner, leave this matter after 2 weeks.
There's
serial
there's
numbers.
an interim order.
Have you informed other side?
Will inform, my lords.
Then mention. After that interim order want to extend, you have to inform that.
Let's serial number 37.
Serial number 62, my lords.
Yes.
Let's avoid service of summons until this. Kindly, meanwhile, I'll comply the.
Getting
office
service of notice. No, what is about the non-compliance, mister?
My lords, I'll comply, my lords.
Pass over, comply it, yes.
That's 37.
You comply it, kudi avunalla, comply madad pass over. Interim order will not be extended, mister, if it is not complied.
37, Milord. Memo for withdrawal filed, Milord. Trial court matter has been settled and disposed.
30,
37.
yes. Memo is filed for withdrawing that writ petition. Memo is taken on record. The above writ petition is dismissed as withdrawn.
Grateful.
Yes. 55. Non-compliance of office objection, 5th time.
The matter is in settlement.
Settled.
Report will be published today. Kindly take us up on 1 o'clock.
At least settled. When do you want?
1 o'clock ತಗೊಳ್ಳಿ madam. Senior.
One more? 1 o'clock. Wait. If you Come, yes.
111, my lord.
2000?
111. In this case, my lord, matter, my lord, I have file ಮಾಡಿದ್ದೀನಿ. Must settle ಆಗುತ್ತೆ. Kindly ಆಗುತ್ತೆ Monday, my lord. ಅವರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
ಒಪ್ಕೊಂಡಿದ್ದಾರಾ? 111.
7, my lord. Monday, my lord.
Yes, leave this matter on Monday.
Interim order is extended.
Interim order granted earlier is extended till next date of hearing. Yes.
Monday.
List number 1 for preliminary hearing, serial number 1 adjourn, serial number 2 Satyanand BS for petitioner, PB Raju.
One, they have taken time, madam. They want.
Date may be fixed as a connected matter, it just pass on the connected.
Yes, call this matter along with that so and so, week after. Yes. Yes, Mr.
Serial number 2 BS Satyanand, PB Raju.
Respondent, my lord, kindly refer to Lok Adalat, my lord. Some settlement is going on.
There is no settlement. I don't have any intimation regarding settlement. ಏನು ಇಂಟಿಮೇಷನ್ ಇಲ್ಲ. ಆದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾತ್ರ ನಡೆಸ್ತೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ದೇ ಗಿವ್ ಅನ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಬಿಫೋರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. My lord, this is a matter where I moved it, my lord, on day for yesterday. Undertaking is given not to precipitate the matter. But there they go and file a memo saying that undertaking has expired, it is not continued. Consequently, my lord, trial court now, my lord, is proceeding further.
Seek time to file a statement of objection, would undertake not to precipitate the matter before the concerned court.
Yes. There they go there and then, my lord, they say that it is not extended.
No, we'll say not to stay of that proceedings, then you settle that.
Kindly pass over.
Password.
ಅಲ್ಲ ಪಾಸ್ ಓವರ್ ಆದ್ರೆ ರೀಚ್ ಆಗಲ್ಲ ತಿರ್ಗಾ ಅದನ್ನು ಹಂಗೆ
verify whether if it is settled that matter, it is.
ಅಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ನನಗಂತೂ ಇಂಟಿಮೇಷನ್ ಇಲ್ಲ. Kindly let that undertaking continue whenever whatever date, my lord, is required. One ನಿಮಿಷ.
Yes.
Whatever date is required, my lord, it is before commercial court. 7 Rule 11 application is rejected by the learned judge.
Counsel for the respondent submits that parties are making effort to settle that matter. In view of the above, leave this matter after 2 weeks. Undertaken given by the petitioner dated 25/7/2025 is extended till.
Please.
Yes.
Serial number 3 Chandrasekhar HB for petitioner, Bharat Kumar V. Serial number 3.
The petitioner, my lord, is one of the petitioner in FDP proceedings, my lord. But I just want to draw your lord's attention, my lord. Suit was of the year 1982, which got decreed in the year 1996. FDP is pending since 1996, my lord. But in the meanwhile, my lord, there was one RFA which was filed by the contesting defendant number 1, who is no more. But there was a modification order which was passed by this honorable court. Based on that, my lord, subsequently the FDP started continuing, my lord. But in the interim, my lord, in the meanwhile, my lord, the FDP on account of not taking steps, my lord, got dismissed. My lord, the application was filed for restoration and it got restored. From there afterwards, the petitioner got to know that multiple transactions have taken place. But I just want to draw your lord's attention towards one of the interim order that was passed by the FDP court, which is available at page number 104 at annexure H, where, my lord, an interim order was granted by the FDP court not to alienate any of the properties, my lord. And the respondents are liable to obey this particular order. But in spite of there being an order, not the trial court, my lord, the respondents have alienated the property. One after the other, my lord, I have been forced to file application, or the sellers who have purchased the property have started coming and filing the application. But one such application was, my lord, the 1 Rule 10 application was filed before the FDP court. But I will take your lordship, my lord, to the very order that was passed, which is available at page number, my lord, 90, with regard to one such application which was filed by respondent number 7 and 8.
Before the FDP court, you are the petitioner or?
Petitioner number 3.
You are the petitioner number 3.
But page number 93 may kindly be looked into, my lord. Not in that. Lord, before the order, my lord, 8 lines, my lord. However,
page 93.
It starts with, however, it is. The operative portion is below, not above that 6 lines.
Yes.
However, it is made clear that the proposed parties are not permitted to challenge the entire FDP proceedings. Their interest will be considered while affecting division in Schedule C property. Therefore, this court is of the opinion that for limited purpose, the proposed parties are also necessary parties and their presence is essential. My lord, this particular, my lord, the proposed respondent is questioning, my lord, the validity or otherwise of schedule C, item number 1. My lord, his limited right is only with regard to the property at item number 1 in schedule C. My lord, subsequently, the petition number 3 had filed an application for demarcation of the rest of the other properties, including item number 1. My lord, the report has been submitted by the concerned, my lord, surveyor, my lord, which is available at page number 110, annexure J.
Yes.
And at page number 109, my lord, the trial court has passed the order by appointing the commissioner at 109. 110 is, my lord, the commissioner's report. Lord, in this, I take your lordship to the properties which have been earmarked by the commissioner at page number 112. These are all the properties which have been demarcated. And
Now what is that you are challenging?
my lord, now what has happened is that annexure L may kindly be looked into at page number, my lord, 149, where the entire commissioner report has been lord, now thrown out, my lord, by the trial court, holding that the commissioner report cannot be accepted because the proposed respondent who claims that he has got the right over schedule C item number 1 has questioned the commissioner report. But if that would be the case, it should be only with regard to, my lord, item number 1 schedule C, not with regard to the entire commissioner report. Now the entire commissioner report has been set at naught by the trial court, my lord. This is under challenge, which is at page number 160. Annexure L at page number 149, and the operative portion is at
Yes, you take notice.
my lord, it has been served, my lord, because the only contesting respondent is respondent number 34, who is already on record. Lord, it's been 4th time, my lord, he is not even putting his presence before this honorable court.
Why
Lord,
it is posted in that this
my
thing?
lord, that's the reason I requested on the earlier bench, my lord, where it was purposefully posted to dispose of the matter in the preliminary hearing stage itself.
He is not coming.
He is not coming, my lord. And my lord, my only submission is that my party is age 77. When she filed, my lord, she was 24 years old. And she is at the doors of the justice since almost 50 years, my lord. And one or the other way, they are trying to just drag on the proceedings.
For a contesting respondent, 33 is absent. Release this matter for preliminary hearing. None appear for respondent number.
He is the
33 and
only
34.
contesting respondent. my lord.
Yes, 33 and 34. Read this matter.
Lord, the trial.
Tuesday at 2:30. Tuesday at 2:30 will dispose of.
Please.
Because in that middle, if I start hearing, I will held up in that.
Please.
Court has notified that he is not appearing, therefore it is posted for preliminary hearing.
Please.
Will dispose of on that. Yes.
Please.
Bill number
Great
4,
lords.
Lokesh B.
Yes.
Serial number 4, Lokesh.
None appears. Read this matter of 3 weeks.
Serial number 5, PC Sunita for petitioner, government advocate.
Respondent, your lordship. For the petitioner. Petitioner has filed a suit for partition, madam, claiming 1/6 share in the shoot schedule property and also for mandatory injunction.
Yes.
Petitioner has filed an IA number 9, seeking not to put up further construction, madam.
No, you
Trial
are the
court-
plaintiff.
Oh, plaintiff.
Suit for?
Suit is for partition and separate possession, claiming 1/6 share and also mandatory injunction. Or to evict the defendants. School is running on the premises, my lord. Of item number 1 only, school is running. To if the suit is declared, directed to evict the petitioners, defendant.
Now, what is that order you are challenging here?
Order, my lord, IA number 9, not to put up further construction. I have filed an IA. IA was allowed before the trial court. Defendant number 5 has filed an appeal.
Who is defendant number 5?
Defendant headmaster, my lord.
Yes.
Has filed an appeal before the appellate court, my lord.
is
Appellate court
that-
has set aside the order.
No, that school is in your property.
Please, my lord, it is in our property. There is no title deed, my lord. We have not given, only on the consent, my lord, they have constructed the building.
Yes, so where is that order of the appellate authority?
Lord, kindly first, my lord, order of the trial court, my lord, kindly
I
see.
trial court, but appellate authority could.
Appellate authority.
Why it is reversed?
Your lordship, since from 30 years, school is situated in the same place, your lordship.
I thought
Let
school-
them
He
show the
himself
title
relinquished
deed.
the-
Right,
Please, madam.
School let them there. Don't put up construction.
Ashte.
Your Lordship, repair work is taking place. We have received the funds more than 6 lakhs for the.
No, what is that document to show that you are the owner of that property?
Your Lordship, he himself relinquished by taking 40,000 rupees and even
Where is
revenue.
that document? Have you marked it? Where is your?
Yes, Your Lordship,
written
kindly
statement?
come to the order of 82, page number 82, Your Lordship.
Written statement annexure B, my lord. Kindly see the written statement.
Yes, what is
Written
your?
statement
Your
ನಲ್ಲಿ
Lordship,
para number
kindly
9
come to
ಅಲ್ಲಿ
Madam, ibru argue ಮಾಡ್ತೀರಾ ಹೇಗೆ ಅಂದ್ರೆ
ಇಲ್ಲ
ಆಗಿದ್ರೆ? Yes.
33 written
There
statement.
is your.
Kindly come to page number 82, Your Lordship. There is no any revenue record standing in the name of the plaintiff, Your Lordship.
First, I am asking that, where is your title?
Your Lordship, by receiving 40,000. he
Elli
himself-
documents?
It is not a registered one, Your Lordship.
You without any.
Since
see,
from 20 years, no one questioned, Your Lordship. All of a sudden, after 30 years.
You've taken a counterclaim for an adverse position. Either you show the title deed or you have to claim an adverse position. You can't say that just because you are in a school.
We
you
are
can do-
contesting the main suit, Your Lordship.
You do it, but don't put up construction.
Your Lordship,
You are not obstructing for.
Your Lordship, there are more than 65 students studying in the
Yearly
school,
bidri,
Your
further
Lordship.
construction act.
Kindly come, ಈಗ ಹೆಂಗಿದೆ ನೋಡಿ ಸ್ವಾಮಿ. School situation is roof ಎಲ್ಲ ಹಾಳಾಗಿದೆ.
Yes.
And safeguard the interest of the students, Your Lordship. ಅದು ಗೋಡೆ ಎಲ್ಲ ಬಿದ್ದೋಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ. And even funds, there are more than 6 lakhs funds granted for the repair of the work, Your Lordship.
You.
We'll
file an-
contest the main suit, Your Lordship.
You file an undertaking that if they succeeded in the suit, will not claim in equity and you will clear everything. You file an undertaking and will consider. Give an undertaking, if you fail in the suit, you will not claim any equity and you will also clear entire constructions and give it in a plain land.
I'll get the instruction regarding that.
You give that undertaking,
My
yes.
lord,
You go on
yes.
construction, but should be given undertaking.
1-3 my lord, they have mark ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Your Lordship.
Further construction ಗೆ photos ಇದೆ ಸ್ವಾಮಿ. ಅದು ಏನು
Only repairs,
dilapidated.
we will say that only repairs.
Only repairs only we are seeking for, Your Lordship.
Give undertaking, will
Yes,
give,
Your Lordship. I'll
make
get the
only
instruction
repairs, will not further any construction, only repairs will do. If they failed in the suit, you will not claim any equity and you will hand it over that
Please madam,
place after clearing all.
please.
Tomorrow.
I'll get the instruction kindly next week.
Yes, Monday.
Next week ಬೇಡ
Monday.
ಸ್ವಾಮಿ.
Much obliged.
Monday, yes.
ಸ್ಟೇಟಸ್ ಕೋ ಅಂತ ಮಾಡ್ಬಿಡಿ ಇಲ್ಲಾಂದ್ರೆ
No, Your Lordship, kindly,
delay ಮಾಡ್ತಾ ಇದ್ದಾರೆ
kindly, Your
ಸ್ವಾಮಿ.
Lordship.
Monday
Because-
you file affidavit, otherwise you will fasten as. Yes,
Please madam.
yes.
Serial number 6, Puneet C for petitioner.
Yes.
Lord, annexure, defendant's writ petition. Annexure C and D is challenged before this court. Annexure C is the mediation report and annexure D is the, my lord, order of accepting the mediation report by the learned trial judge.
Yes.
Now, please, my lord, the plaintiff, he files a suit for specific performance. Alleging that, please, my lord, there is an agreement in his favor executed by the defendant herein which is being disputed.
Yes.
He takes a contention that, please, my lord, that there was a sale consideration for a sum of rupees 25 lakhs is concerned.
Yes.
And, my lord, a sum of rupees 20 lakhs is being paid.
Yes.
It is on this ground, please, my lord, he filed a suit for specific performance.
Yes.
My lord, it is alleged that, please, my lord, the matter was referred to the mediation.
Yes.
Before the mediation, please, my lord, the plaintiff says that, please, my lord, that the defendant has agreed to a sum of rupees 60 lakhs agreeable to pay.
Yes.
The agreement is dated 23/2021
Yes.
and the mediation, my lord, is of the year 2025.
Thereafter, what has happened?
Now, please, my lord, it is alleged that, please, my lord, thereafter, my lord, the defendant was supposed to pay, my lord, in the month installment wise. By way of 5 installments is concerned. Now, my lord, my submission would be, please, my lord, 60 lakhs for 25 lakhs, 20 lakhs which is being paid. My lord, he says, please, my lord, defendant agreed to pay twice the amount. 60 lakhs is concerned, which is too much exorbitant. Defendant, my lord, then he never agreed for this particular amount is concerned. Matter was referred to the mediation, please, my lord, mediation, please, my lord, on several dates, my lord, the matter was adjourned due to the non-presence of the plaintiff is concerned. And one fine day, please, my lord, a mediation report is being filed to a sum of rupees 60 lakhs. 20 ಲಕ್ಷಕ್ಕೆ 60 ಲಕ್ಷ.
ಆಯ್ತು, ನೀವು ಒಪ್ಕೊಂಡಿದ್ದೀರಾ ಇಲ್ವಾ?
ಅಲ್ಲ, ನಾನು ಒಪ್ಕೊಂಡಿಲ್ಲ.
ಎಲ್ಲಿದೆ? Where is that? What is that mediation report? Where is that?
Mediation, is at page 23.
Yes.
Page 23 ನಲ್ಲಿ ಅವರು 60 ಲಕ್ಷ 50,000 ಪಾವತಿಸಲು ಒಪ್ಪಿರುತ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. But to which the defendant never agreed.
No, your signature is there, Mr.
That is what, please, this terms of agreement was not at all agreed before the mediation is concerned.
No, is it your signature is forged or what?
It was under the impression that, please, it was to be.
What is that impression? On the basis of your lawyers, it has been.
ಅಲ್ಲ ಅದೇ ಅಲ್ಲ ಆಗಿರೋದು 12 ಲಕ್ಷ 10,000 ತಗೊಂಡು 12 ಲಕ್ಷ 10,000 ತಗೊಂಡು ಅವರು ಏನ್ ಹೇಳ್ತಾರೆ ಸೂಟ್ ನ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. But the thing is, please, 60 lakhs is being agreed to pay in.
No, you are making an allegation against that lawyer. He has been misled. Have you stated in that petition?
ಆಮೇಲೆ page 5 ನಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳ್ತೀನಿ. Grounds ಅಲ್ಲಿ. The plaintiff never permitted the defendant to go through the mediation report and the signature was obtained by the plaintiff from the defendant without going through its contents.
No, your lawyer is also signed, Mr. Lawyer is also saying that without allowing him to read. File an affidavit to that effect. Otherwise, there is no end, Mr. All mediations, settlement, everything you see, this is not that. You file an affidavit to your lawyer, I have not been allowed to read. I have signed it.
May I make a request in this way, please?
Yes.
Page 28 ali, after securing the mediation report.
Yes.
On 9/9/2025.
Yes.
The court has accepted the mediation report. To that extent.
Now accept ಮಾಡ್ಕೊಂತೀವಿ mediation sign ಮಾಡಾದ್ಮೇಲೆ ಇಲ್ಲಿ ಆರ್ಡರ್ ಬರುತ್ತೆ ತಕ್ಷಣ. What is there, Mr. Party has signed, council has signed, what else remains? It is more than effective of the court order. Court order nu ನೀವು ರಿವ್ಯೂ ಹಾಕಬಹುದು. ಇಲ್ಲ ಸ್ವಾಮಿ ಅದು ಇದು ಅಂತ. It has been signed. Yes.
ಇಲ್ಲಿ ಏನಾಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ 60 ಲಕ್ಷ ಅವರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದ್ದಾರೆ ಆಲ್ರೆಡಿ.
ಆಗ್ಲೇ ಬರೋದು ನೀವು ಸೈನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಗೊತ್ತಾಗೋದಿಲ್ಲ.
ಅಲ್ಲ ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್
we are not under sympathy, Mr. And the law say that. Then second thing is, this is nothing but a compromise.
Compromise, please, my lord.
Then you have to go before the same court.
20 ಲಕ್ಷಕ್ಕೆ ಒಂದು 5 ಲಕ್ಷ, that to specific performance.
Second thing is that, then you have to go before the same court. If there is any fraud and all, that is what order 23 rule 3A says.
Lordship may permit me, I'll
not permit. If law is there, you go. Why should I permit?
ಇಲ್ಲ ಅಲ್ಲೊಂದು ಅಬ್ಸರ್ವೇಷನ್ ಯಾಕಂದ್ರೆ ಲಿಮಿಟೇಷನ್ ಬಂದ್ಬಿಡುತ್ತೆ. ಫೈಲ್ ಮಾಡೋದು 6/11ಕ್ಕೆ.
Have you read 23(3)?
Please.
Then you go there. If it is a settlement, Supreme Court said that it has to be go before the same court.
If that liberty is given, please.
Not liberty. Yes, I will dismiss it on merit. If you want to withdraw, you approach appropriate legal forum.
With that observation, I'll withdraw with a liberty to approach the court.
Yes, learned counsel for the petitioner has filed a memo seeking leave of this court to withdraw this petition with liberty to approach appropriate legal forum. Yes.
Court, my lord, by filing an application, by seeking recalling of the order.
Nodri law ಏನಿದೆ ನೋಡ್ರಿ, judgment ನೋಡ್ರಿ, Supreme Court even stranger can also file an application under order 23(3).
Memo. Serial number 7, Sachin PS for petitioner, connected matter, Prasanna K.
Give it to respondent.
Please.
Yes.
I'm the owner of the property to registered sale deed. Revenue entry also stands in my name.
Yes.
1986 is the sale deed.
Yes.
For 38 years, my lords, after registration, 2024 a suit was filed by me for bare injunction.
Yes.
Lords, my adjacent property holder is different, my lords.
Yes.
He was trying to interfere with my property. That is the reason why I filed a suit.
Yes.
Ex parte TI was granted. Temporary injunction was granted. Ex parte TI. Thereafter, my lords, on objection filed by defendant, my lords, instead of granting TI, my lords, status quo order was granted.
Yes.
Being agreed by the status quo order, my lords, I preferred an appeal.
Yes.
Because I needed temporary injunction order because he was taking the benefit of status quo order saying that
yes,
he is in possession.
Yes.
My lords, he also files a counter appeal for against the grant of status quo order.
Yes.
That's how the two writ petitions are filed before my
yes,
lords. My lords, the appellate court has reversed the order of status quo and allowed the appeal filed by the defendant.
No, defendant appeal for what?
My lords, against the grant of status quo, he prefers an appeal. Against non-granting of temporary injunction, I goes in appeal.
Yes.
Two appeals was clubbed together.
Then
the appeal filed by me was
application under 39(1) and 2 is rejected now.
Yes, it is rejected.
Yes.
And his appeal is allowed.
His
No, as
appeal is
on today-
allowed means that has been rejected is the allowed because he can't grant any injunction.
Yes.
He's a defendant. Yes.
That's how my lords, 2 writ petitions are filed.
Now your application under 39(1) and 2 has to be whether you are entitled for.
Yes.
Why the trial court has.
My lords, trial court says that the identity of the property is in dispute.
Hmm.
He is denied the title deed. That is the reason why 2 grounds under which my lords, the appellate court reversed the order.
What are the document to show that?
My
you
lords,
are
the
in
best piece of evidence which I produce is title deed and RTC. It's the
as
best
on
piece
today
of
it
evidence,
stands in your-
RTC.
Yes,
My lords,
Mr. What is the document to
my
show
lords,
that you are?
one submission. My lord, status quo order is granted. I have no difficulty in granting status quo order. My difficulty is that the status quo order has to be clarified. You should not change the nature of the property.
Both
and
of
not,
them, that is what the meaning of the status. quo.
yes, my lord, not to change the nature of the property, not to cut the trees. There's only the.
This matter, my lords, I need some time to hear. I need to complete the pleading by filing objections also.
Until then,
My lords,
whatever the status,
no,
you
my
maintain
lords.
that.
My lords, for this reason, that matter was listed before 3 roasters, my lords, much before listing of this, before this roaster. None of the roasters have granted the interim order, though it was heard.
Why?
Adjournment takundu. I'm sorry, sir. Should
I'm
not
sorry,
make
it
such
was
a.
not on the count of the respondent, the adjournment was
taken.
taken. On the last occasion also, my lords, when the matter was listed before the previous roaster, it was adjourned to today on the guise of the petitioner.
No, that doesn't mean that this court has no power to.
Indeed,
grant
no,
stay.
indeed, my lords, I'm only,
Want to
I'm
go
only
before the
request.
same court, I will.
Indeed
send
not,
it.
my lords, I'm only requesting this honorable
Want
court.
to go before the, you argue on that merit. I
That's
have my own right.
Yes, my lords.
Unless there is an order from that other court, I can grant an
Indeed,
interim
indeed.
order.
My lords,
If you say that, you go before the same court or I will grant an interim order. This
my
is
lords,
not. the-
only, my only request before this, I
As an
bow down, my
counsel,
lords.
you have to argue on the merit.
Indeed, my
Don't
lords.
on all this.
Indeed, my lords, I
Or
bow
if you
down.
want to go before the same court, I have no.
Indeed,
objection.
no, my lords. No.
Yes.
I bow down to my lords, my lords, and my apologies.
Yes,
My
yes.
lords, yenandre, I need to complete my pleadings. I may be given at least 1 week time, my lords. My lords,
As it is status quo, what is the difficulty for you to maintain
my lords,
status
or else it may be passed over, my lords, I shall argue, my lords.
quo?
It may be passed.
Yes, possible.
Serial number 8, Kulkarni Mamata Guru Rao for petitioner, R Nagabhushan.
And
I undertake to
for
file
the
wakalat
petitioner, your
notice,
lordship.
Yes.
point number 2.
Filed an application seeking protection, police protection at the time of execution of the order by the Tahsildar. That was rejected on the ground that Tahsildar has not requested any police protection. Hence, police protection will not be given to petitioner also.
No, what is the suit for, madam?
Suit for partition, your lordship.
You
Was
are,
decreed.
suit is decreed.
And
then-
on an application, Tahsildar was appointed as per page number 48, your lordship.
Next week, I lords, I am filing wakalat today, lords,
Yes.
for respondent number
Yes,
2.
madam.
Next week, I'll
Yes.
go ahead with the arguments.
You are appearing for whom?
Lords, respondent number 2, lords.
Yes.
Only police
Also-
protection during,
At the request of counsel for the respondent, leaves this matter on 11th.
Very well.
Serial number 9, HS was for petitioner, connected matter, Jwala Kumar.
Yes, Mr. Yes.
For the respondent, plaintiff.
Ready? You are ready?
I'm ready.
Yes, Mr. No, beginning that he is looking at you that you might have been consulted before that for something. Therefore, I asked him.
No, the suit was filed by respondent's clients.
Yes.
Respondent's mother and the defendants, the
Yes.
present appeals filed before your lordships
No,
are
you-
the
you
brothers.
are the
and
defendant.
sisters. We are the defendants. It's a
Defendant.
defendant's appeals.
Yes. Suit for?
Suit filed by them for
Yes.
bare injunction.
Yes.
Suit properties were purchased in the year 2008 in the name of the mother of the respondent. There is no dispute over that.
Yes.
The defendants and the mother of the plaintiff are the brothers and sisters.
Yes.
She was living in Bangalore
Yes.
at Mattikere,
Yes.
and properties are in Devnalli. They were living there, my client's defendants. They were taking care of the properties, and it is alleged that it was a joint family property. In fact, a suit for partition was also filed. It is still pending consideration.
Yes.
Now, this present suit was bare injunction filed by them. Where they sought for an injunction order was refused by the trial court. On the other hand, an injunction order sought by these defendants appellants were granted by the trial court with a detailed order.
Yes.
they filed an appeal.
Yes.
We also filed an appeal. But where our application, our appeal, sorry, their appeals only. Their appeal was allowed and an injunction order was liquidated and then granted the injunction order by the first appellate court. Now we are before this honorable court. There was a detailed, of course, my lord, admittedly, title is in the name of the mother of the. Now it was given to her only because by later it was a gift deed by the mother.
Yes.
No documents is standing in the name of my clients.
No, you have sought for an, what is the relief you have sought in that IA?
Well, not to interfere with, because they are looking after the properties from 2008.
You are a defendant.
I am a defendant.
Yes.
No, in the same suit, my lord, a defendant can also maintain an application.
No, that 39(1), you cannot. 2 you can.
Yes. Your lordship.
Is it 39(1) or 2?
I will.
Two.
Lordship, sir.
Yes.
Two.
Can.
Only
Yes.
2 can be made.
Yes.
Now this is the situation.
IA is maintainable.
But one
Then
more
that,
thing.
what is the reason for reversing? Who is
Reversing,
the-
my lord, said the title deeds are with the.
No, what is that revenue record stands in whose
No,
name?
all are in their name. There is no.
Then
dispute.
what is that to say that?
Now
Is there any possibilities of settlement?
that my learned
Only
friend has
brother and
explored.
sister.
No, my lord, one more thing has happened subsequently. When the matter was listed before.
What is this, house properties or?
No, agricultural lands.
Hmm.
When the matter was listed on 18th of February, before Justice S.R. Krishna Kumar, of course, His Lordship Justice said that there was a status quo. My learned friend was not present. But anyhow, I'm not going to harp on that.
Yes.
On the very same day, it appears the respondent have sold the properties to XYZ.
But less pendency, he will not get.
Yes,
He will not get any rights at
yes.
all.
Therefore, my submission to let there be an order of status quo as on today, and your lordship can
Who
dispose
is
of the
there in the
later.
position?
I am in possession, my lord.
No.
When maintain status quo, will say
Well,
that maybe dispose of.
My lord, this is a suit for bare injunction. My mother has acquired the property under the registered sale deeds. In turn, my mother has gifted the property by executing a registered gift deed. Immediately, revenue records were transferred in my name. My name is mutated. I am paying the tax. I am in possession.
Then status quo is benefited.
Why, my lord? It is my suit.
No. If status quo is granted, how it will affect your
Hello,
rights?
my lord.
Is it try to interfere after the status quo?
That's the you see. Whole difficulty for me is that since I'm stayed at Bangalore, they are at local place. They are interfering with my property.
No, where is the property situated?
Devnalli.
Devnalli.
Yeah, that's why-
Devnalli is also local to Bangalore. I saw.
Like, even then, my lord, see, my lord, law is very clear, my lord. My mother's property.
What is there in that property?
The agricultural lands.
I have cultivating.
Yes, their contention, contention, my lord, is that I have my mother has executed an agreement and there was a Odambadike Patra. On those 2 documents, they have not initiated any legal action.
There is a suit for partition also. It is still pending.
That is partition suit we can
That
get
is-
and not to alienate. But injunction is
When it
concerned.
here, the trial court.
Sale
when-
deed and all documents.
No, I'm not disputing.
That's what you are.
I'm
fairly
not
sub-
disputing it.
Now that
When a trial court order says, clearly mentions that we are in possession with a detailed order.
on what basis? trial
That's
court has-
what, because we were in, here in, they were in Bangalore. And then the way in which the.
No, if the person is far away, they are not cultivating, then we are also losing our land, Mister.
No.
We are in Bangalore, our property is.
No, we are in Devnalli, adjoining to the properties.
No, that's
Defendants.
true, whether you are cultivating or not.
Yes, we are cultivating.
What is
even
the
today.
documents, Mister? In revenue record stands in their name.
Yeah, all revenue record stands in their name.
Hmm,
May
then-
take your lordship to the trial court order.
Yes.
So Marchip are hearing today, my lord, otherwise on some other day, any day,
Yes,
can
we
be.
will hear. Yes.
Let them not do anything in the meantime, my lord. Now they have sold it. Other person should not
No,
interfere
not
with
to
it.
alienate, that will make it clear.
I already sold it, my lord, what I learned.
Whatever made it, that person is under the risk.
That's why.
Further alienation will stay there.
Please, my lord.
Yes.
Not in this suit, my lord. They have filed a suit for partition. Let them approach the court in the set.
No, in this case also,
Yes, my lord.
parties are directed not to create third party interest.
Party interest.
Yes.
Please.
Then we will dispose of the case to trial court to dispose of the suit itself. What else remains?
Not in this, my lord. Suit is for partition suit is pending. They have filed the suit. Whatever the interim order requires, that has to be adjudicated in that compliance suit, not in this suit, my lord.
No,
But-
even this
Well,
also,
this is only
why
a
are
bit-
creating third party interest?
Like this is bare injunction suit, my lord. That's why.
You are already sold. You
Yes,
are
ma'am.
washed off your hands. Why do
Yes.
you worry that?
Yes.
Yes, further don't do that. Yes. Kali. In this writ petition, petitioner What is the
ಹೇಳಿದ್ದಾರೆ. ಅದೇ ಒಂದು ಅವ್ರದನ್ನ appeal na first appellate court allowed and granted the injunction order, where my appeal was rejected, or my the application.
Yes, we'll club together and pass an order. Yes. We'll dismiss it, but not to create third party interest and direct the trial court. What is the stage in the suit?
No, it is in the trial side.
We'll fix some time limits.
But-
and yes.
Paragraph 15 of the page 30, my lord.
No, I'm not entertaining that treatment. Yes. Only think that parties, you should not be third parties misleading and purchasing. Tomorrow they will land in the.
When the matter was listed before this, my learned friend already entered the caveat. On the very same day they sold the property, my lord, having taken the injunction order, waiting for all these years.
Yes, in these petitions, petitioners are called in question. At the elder of the prayer academy. The respondent plaintiff has filed a suit for bare injunction.
When injunction was refused to the plaintiff,
Yes.
injunction was
Along with
granted
that-
in favor of the defendant.
Along with that, plaintiff has filed an application under Order 39 Rule 1 on 2 seeking an injunction. The respondent, defendant, the petitioner defendant is also filed an application under Order 39 Rule 2. Order 39 Rule 1A, 1B. Yes, the trial court, after hearing 39 1B, hearing the parties, allowed that application filed by the petitioner defendant.
Page 92, my lords. Page 92, the operative portion of the order of the trial.
And rejected the application filed by the plaintiff. Being agreed by the same, the plaintiff has filed an RA, MA before. MA before the principal senior civil judge JMFC at Devnalli in MA number 12 of 2024 and MA number 13 of 2024. By order dated 5th January 2026, the first appellate court has allowed that appeal filed by the plaintiff, and application filed by the plaintiff under Order 39 Rule 1 and 2 is allowed, and application filed by the defendant petitioner was rejected. Being agreed by the same, the petitioner is before this court. The suit is only for the bare injunction between the sister and brother.
Please.
Sister and brother.
Sister and brothers.
Now, pleadings are complete. In the interest of justice, the parties are directed not to create third-party interest in the suit scheduled property, and the trial court is directed to dispose of the suit as expeditiously as possible, not later than 1 month from date of receipt of the copy of this order. Yes.
Please.
The order passed by the appellate court is confirmed, and yes.
Both writ petitions are
Disposed of. Common order. Yes.
Great.
Serial number 10, Sundararaman ME for the
I appear for the petitioner. Because I'm led by senior counsel in this matter, my lords. I may request for Monday or Tuesday, my lords.
Yes. Tuesday. Tuesday.
Wednesday.
Yes. Please.
Serial number 11, HK Kantaraju for
I am for the, I am for the.
Passover. Yes, Mr. Passover.
Passover, it should be reached rather not.
ಅದು ಅವ್ರಿಗೆ ರಿಚ್ ಕಾದು. If they want to take Passover, we don't know whether it will reach or not. Yes.
Moreover, your lordship is not maintainable, it is infectious. That's the reason why.
What is that in why infectious?
Because they already been completed, whatever the challenge before the Honorable Court, your lordship.
What is that he is challenging here?
Challenging the possession of the property after the disposal of original suit and also execution proceedings, your lordship. And the Kate and everything is changed in the name of the plaintiff.
Execution case pending in the file of the so-and-so Madhur. It's necessary directed to quash that.
All the entries are also changed in the name of.
Anyhow, let him argue. Yes.
I have a copy of the memorandum. Sale deed along with the
Then we will have
RTC and mediation register.
Monday.
On Monday.
Monday.
ಅಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಇವಾಗ ಶನಿವಾರನೇ ಇದೆ ಅದಕ್ಕೆ ಸ್ಟೇ ಬೇಕು
ಅಲ್ಲ ಪೊಸಿಷನ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು.
ಪಾಸ್ ಮಾಡಿ ಸರ್.
Yes.
Serial number 12, V Shivakumar.
Plus one submission. Serial number 10. Manoj, it was posted to Wednesday. May I request Thursday, Manoj?
Thursday. You just inform other side. You are there. Yes. Thursday.
Serial number 12, V. Shivakumar.
Independence petition, my lord. The plaintiff filed a suit for partition, for a permanent injunction against the petitioner. The trial court is rejected the 39-112 application.
Why?
I am the defendant. The first appellate court is allowed the appeal.
First appellate court is
First
allowed.
appellate court allowed the appeal.
Why? On what ground it is allowed?
The ground, you may not kindly see the annexure. Yes, my lord. In page number.
What is your defense before the trial court?
I am the absolute owner of the suit scheduled property. I am purchased through sale deed. You may kindly see.
Issue notice. Parties are directed to maintain status quo in suit scheduled property. Yes, till next date of hearing.
Serial number 13, Patil GS for petitioner.
For the petitioner,
Yes.
suit for declaration, the present petition by the plaintiff, Lords, IA 14A, filed under section 11 clause 2 of the KCF Act, by the defendant came to be allowed.
No, suit for?
Suit for declaration, Lords.
No, you are the.
I have contended that the lands are
You are
agriculture.
the plaintiff.
Plaintiff, Lords. I have valued the suit under section 24B, read with 7 clause 2, as a revenue land,
What
and
is
paid
the-
a court fee of rupees 675.
What is the order of the trial court?
Well, the order of the trial court is at 165. The defendant's application has been allowed by holding that I have to pay a court fee at the ad valorem, at the market
160?
value, 165 minutes. They have filed 4 separate applications, my lords, under 711A, B, C,
Hereby
D.
allowed. I have filed by the defendant court fee, which is hereby allowed. Plaintiff is directed to furnish that valuation certificate from the concerned sub-register with respect to the suit scheduled property and directed to pay the court fee of the suit scheduled property which are converted for non-agriculture purpose. Yes, you have
Well, in
produced
my
that value.
complaint, I have specifically pleaded that it is an agricultural land. I am in the possession of the property.
Land is not converted.
Land is converted by the defendants, my lord. Subsequently, I have challenged the said conversion order before the.
Then you have to pay the court fee, mister.
My lord, this subject, my lord, it may be made as an issue. And if the court in the end of the, my lord, after if a court commissioner is appointed.
No, if court has no jurisdiction. that
Because I have taken a specific contention that it is an agricultural land and I am in possession and I'm cultivating the land. I produced the RTC, my lords, wherein the land is shown as an
No,
agricultural
you
land.
are admitting that the defendant has converted. Then it's enough, mister. You pay the court fee and proceeding. Otherwise, that suit will be pending like that only. What is the benefit you will get it?
That issue may be made as an.
Yes, you take notice. Yes.
Serial number 14, Punit C for petitioner.
Yes.
That plaintiff's writ petition against the order of issuing emergent notice. My lord, my memo of documents filed on 23/2, my lord, for a moment. My lord, scheduled property, my lord, measuring 2 acres of agriculture land was granted in favor of the husband of the first plaintiff and father of the petitioner number 2 to 4. My lord, Saguvali chit at page number 3 of my memo.
No, your suit is for?
Declaration and the declaration of title.
No, what is that order you are challenging?
My lord, order of issuing emergent notice.
On what?
There is a registered sale agreement executed by the defendants.
No, on what that emergent notice? Have you filed an application?
Yes, please, my lord, I had filed an application seeking, my lord, ad interim order. Trial court, my lord, issues an emergent notice without considering the, my lord, the fact that there is a registered sale agreement executed by the defendant number 1 to 18.
What is the threat for you?
My lord, there is an alienation. There is already a registered sale agreement.
Who is alienating that?
Defendant number 1 to 18 are threatening, my lord, at any time they may execute a registered sale deed.
No, that you have filed a suit for declaration on the basis of?
My lord, my father's property, by virtue of my father's property.
What is the defense of the defendant?
Defendants, please, my lord, they said that there is a family partition, to which, please, my lord, plaintiffs are not parties. What the defendant, my lord, first defendant claims.
Issue notice. Parties are directed not to create, not to alienate that suit scheduled property till next date of hearing.
Yes, please.
Serial number 15, Subbareddy KN.
Lord, serial number 15.
Yes.
The respondents have obtained a compromise, a fraudulent compromise deed over my property, my lord. Property belonging to my father. So therefore, my lord, I have challenged that compromise deed in a suit, and that suit is pending. In the meantime, my lord, in order to get some title over the property, they have filed an injunction between themselves. The persons who are the beneficiaries of the compromise decree. I have filed an impleading application. Court has rejected it. The court
Where is
could
that
not have
order?
rejected it because it was dependent upon the substantive suit of challenge to the compromise decree.
Now your application for impleading is dismissed.
Is rejected.
Now you are challenging the compromise degree in respect of very same property.
Very same property. Yes, blood, please.
Yes.
Please.
No.
And next matter also is connected, blood. Because two
What
suits
is
have
that?
been filed by them, beneficiaries. I filed impleading in both the suits.
In both it is dismissed.
Yes, blood. In both the cases it is dismissed.
Yes. Or issue notice. Stay of further proceedings in OS number 25976 of 2024. Pending in the file of Additional City Civil Judge Nehal, Bangalore, annexed till next date of hearing.
Please, blood. Oblige.
Number 17, Prasad B for
Second matter.
Petition on this case, my lord.
Second matter, what is the suit?
That this suit for partition.
Wait. Adರಲ್ಲಿ OS number 25983 of 2024, pending in the file of Additional City Civil Judge Nehal till next date of hearing.
Serial number
Yes.
17, Prasad B.
For the petition on this case, my lord.
Yes.
My lord, the suit for partition.
Yes.
My lord, I am the bona fide purchaser.
Yes.
I purchased the property on 29/1/2007.
Yes.
But the suit was filed on 3/12/2007.
312.
3/12/2007.
Yes.
I purchased the property on 29/1/2007. My lord, the suit came to be dismissed because of the reason, my lord, the suit was
Suit for partition.
partition.
Dismissed.
Please. Then again appeal was filed. The appeal was allowed. Later, my lord, the present respondents filed FTP before the FDP court. My lord, meanwhile, my lord, I'm not aware of the proceedings. On 9/8/2023, I filed application for impleading. But my lord, after a lapse of 3 years, the respondents filed objections, stating that they are only denied the whatever the.
No, what is the property you have purchased is the part of that
Please, my lord.
partition.
Please.
Then why your application for impleading is rejected?
My lord, I'm not a party before the trial court. I'm not before the party before the appellate court.
That's why you have filed an application for
Please.
impleading in the table.
Please, my lord. But the trial court was rejected my application, stating
Then-
that, my lord, in the page number 21, 21,
Yes.
in FDP number 21, 2021, that in the paragraph number 8, ಪ್ರಸ್ತುತ ಅಸಲು ದಾವಾ ಸಂಖ್ಯೆ 660/2007 ವಾದಿಯರು ಪ್ರತಿವಾದಿಯರ ವಿರುದ್ಧ ಭಾಗಂಶಕ್ಕಾಗಿ ದಾವೆಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು, ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ಸದರಿ ಅಸಲು ದಾವಾ ಸಂಖ್ಯೆ 660/2007 ವಜಾಗೊಳಿಸಿದ್ದು, ನಂತರದಲ್ಲಿ ವಾದಿಯರು ಮೇಲ್ಮನವಿ ಸಂಖ್ಯೆ 162/2016 ಅಂತೆ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿದ್ದು, ಸದರಿ ಮಾನ್ಯ ಮೇಲ್ಮನವಿ ನ್ಯಾಯಾಲಯವು
Stay of further proceedings in FDP 20 of 2021, pending in the file of Principal Civil Judge JMFC Chikbolapura till next date of hearing. Yes.
Grateful.
Number 18, Subbareddy KL.
Lord, serial number 18, Lord,
Yes.
suit is of the year 2015, Lord, filed by the
Yes.
plaintiff. I am the
Yes.
defendant number 1, Lord.
Suit for?
There was a settlement that was arrived at, registered settlement deed,
No,
in the
suit
year
for?
2013 itself.
Suit for?
Now, Lord, what has happened? The
Agreed.
defendant number 2, by
No,
virtue of page
Mr.
77,
Reddy, suit is for what?
suit is for partition, Lord.
Yes.
Filed in 2015. Matter
Yes.
was posted for arguments, Lord. Defendant
Yes.
number 2 has adopted the written statement of D1, Lord. Kindly see page
Yes.
77, Lord.
You are the defendant number 2.
I am the
Yes.
defendant number 1. D2 had adopted the written statement of D1.
Yes.
In the meantime, in February 2025, D2 died, Lord.
Yes.
The children of D2 filed
Yes.
an independent written statement by by trying to withdraw the earlier admission made. The matter was posted for arguments.
Yes.
At this stage, the court has permitted him to file an additional written statement not an additional written statement, a fresh written statement, Lord. Lord, the LR is bound by the statements made by the parents.
They cannot,
The
no,
parents
is there
have
any
accepted-
contradictory? Are
Yes,
they
my lord,
taking
it is
any
contradictory. Yes,
What
my
is
lord,
that,
because they have admitted the settlement deed arrived at prior to suit, registered
Yes.
settlement deed. The D2 had admitted.
Yes.
Now they are going contrary to that, and they are saying that that settlement deed is not proper. The executor himself has admitted the settlement deed.
Yes, heard.
And
Issue
at the
notice.
stage of arguments, the court permits the additional, the fresh written statement.
Yes, stay of further proceedings in OS number 10095 of 2015, pending in the file of 49th additional city civil, 59th additional city civil and session judge, Bangalore till next date of hearing. Yes.
Please.
Cell number 19, yes, Rajesh.
Please, my lord. Oblige.
Respect, my lord, the respondent number 1 to 4, my lord, have filed a petition before the honorable tribunal, my lord, for seeking compensation, my lord. My lord, the petitioner has appeared and filed a wakalat, my lord, but failed to file a reply statement.
No, that where you have filed this thing?
My lord, this matter pertaining to MUC, my lord.
Why it is classified as, that's what I'm, yes. Office is directed to. Yen challenge madidira?
My lord, execution proceedings, my lord. I filed a miscellaneous petition before the honorable trial court, my lord, for restore the order, my lord. Thereafter, my lord, similarly.
See, MEC court has passed an award.
Award, my lord.
You are, who are you?
My lord, I am the owner of the vehicle.
Of the vehicle.
My,
They have filed an execution petition.
Yes. My lord, in the execution petition, I filed an application for stay the execution proceedings. The execution, the honorable tribunal has rejected my application. Then, my lord, the miscellaneous petition is pending before the same court, my lord. In the said court, my lord, the matter posted for evidence, my lord. In miscellaneous petition.
You have filed an application for stay of that.
Stay of the application.
That is dismissed.
Dismissed.
Yes. What is that miscellaneous application is filed?
Pending, my lord. Matter posted for evidence, my lord. Evidence kide swami. In the similar, my lord, execution alli arrest warrant issue agide. And evidence kuda ಆಗ್ತಿಲ್ಲ swami.
ಅಲ್ಲ ಅದು ಸರಿ, ನೀವು miscellaneous application ಏನಕ್ಕೆ ಹಾಕಿದ್ರಿ?
Restoration of the MSc, my lord.
No, that is your stay application is rejected.
Rejected.
You have not challenged that order.
That order has been challenged before this honorable court.
IA.
Yes.
Then it will be before this court only.
Yes.
It will not go to that MEC court. Yes. What is that award passed by the tribunal?
My lord, page number 41, 44, my lord. 44, my lord. My lord, the honorable tribunal has allowed the petition and directed to the petitioner and respondent number 5 pay the compensation jointly and severally, my lord.
No, insurance company ilva?
Illa, sir. Lapse agide.
Lapse agide. Then
But my lord, I have sold the vehicle before accident, my lord. I produced the said document, my lord. Page number.
Who is the RC owner? That is the law on that point.
ನನ್ನ ಹೆಸರಲ್ಲೇ ಇತ್ತು ಸ್ವಾಮಿ.
You go and recover against that person who has purchased that.
ಅಲ್ಲ, ನಾನು ಆಲ್ರೆಡಿ ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ ಸುಮ್ಮನೆ ಅದು.
ಆಯ್ತು, ಆಮೇಲೆ ನೀವು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ವೇರ್ ದಟ್ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಇಶ್ಯೂಡ್ ಇನ್ ವಿಚ್ ಕೇಸ್?
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ.
ಹೌದು. ಅದು ನಾನು ಸೇಲ್ ಮಾಡಿರೋದಕ್ಕೆ ಸೇಲ್ ರೆಸಿಪ್ಟ್ ಮತ್ತೆ ಡೆಲಿವರಿ ನೋಟ್.
ಆಯ್ತು ಸರ್, ಯು ಡಿಪಾಸಿಟ್ ಸಮ್ ಅಮೌಂಟ್ ಮಿಸ್ಟರ್.
ಸ್ವಲ್ಪ ಒಂದು.
ಅದರ್ವೈಸ್
ಅಲ್ಲ, ಇದರಲ್ಲಿ 50%, 50%.
You see, because of this fault, what is the fault of that person who has met with an accident, Mr.
Yes.
Claimants is unnecessary suffering.
ಅಲ್ಲ,
can't recover against them. You have, as on today, you have not filed any case against that person.
ಅದರಲ್ಲಿ 50% ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ನನಗೆ.
ಇನ್ 50% ಯಾರಿಗೆ?
ಅವರು ಇನ್ನೊಬ್ರು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 ಸ್ವಾಮಿ.
ಅವ್ರು ಯಾರು?
ಅವರು ಅವನ್ ಪರ್ಚೇಸರ್ ಮಾಡಿರ್ತಕ್ಕಂಥವ್ರು, ನನ್ನ ವೆಹಿಕಲ್ ನ ಪರ್ಚೇಸ್ ಮಾಡಿರ್ತಕ್ಕಂಥವ್ರು.
ಅವ್ನಿಗೆ ಹೆಂಗ್ ಮಾಡಿದ್ರು? ಅದು ಬರಲ್ಲ. ಇಲ್ಲ ನಿಮಗ್ ಮಾಡ್ಬೇಕು, ಇಲ್ಲ ಅವ್ರಿಗೆ ಮಾಡ್ಬೇಕು. ಹೌ ದಟ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಸೆಡ್ anyhow you have succeeded in 50%.
ಅದರಲ್ಲಿ ನಂಗೆ ಒಂದು 10% ನಾನು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ ನಾನು ಮಿಸಲೇನಿಯಸ್ ಎವಿಡೆನ್ಸ್ ಕೊಡಕ್ಕೆ
13 ಲಕ್ಷ 14 ಲಕ್ಷದಲ್ಲಿ ನಿಮಗೆ 7 ಲಕ್ಷ. 7 ಲಕ್ಷ ಅಂತಂದ್ರೆ at least you deposit on 5 lakhs before this court. What to do then? What about
20% ಮಾಡಿದ್ರೆ ನಂಗೆ ವಾರೆಂಟ್, ಅದು ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆ. ಅದು ನನ್ಗೆ ಇದಾದ್ರೆ ನಾನು ಮಿಸಲೇನಿಯಸ್ ಎವಿಡೆನ್ಸ್ ಕೊಡಕ್ಕೆ ಸರಿ ಹೋಗ್ತದೆ.
Yes. You pay 4 lakhs, Mr. Yes.
On 2 lakhs. 2 lakhs.
ಸರಿ, ಅವ್ರ ಹೆಂಗ್ರಿ ಸರ್ವೈವ್ ಆಗ್ಬೇಕು ಹೇಳಿ ಪಾಪ.
ಹೌದು.
First fault is that you have not changed your RC. Yes. Where is that, when that order has been passed for arrest warrant, Mr.
My lord, on
6/8/2025.
ಹೌದು ಸರ್. ಅಲ್ಲ
Actually, allow that.
10/9/25 ಸ್ವಾಮಿ.
Huh?
10/9/25 ಪೇಜ್ ನಂಬರ್ 88 ಸ್ವಾಮಿ.
Page number
88.
ಎಲ್ಲಿದೆ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್? 88
ಹೌದು ಸರ್.
ಯಾವತ್ತು ಡೇಟ್ ಅದು? ನೀವು ಅದನ್ನೇನು ಸ್ಟೇ ಕೇಳೇ ಇಲ್ಲಲ್ಲ?
ಕೇಳಿದೀನಿ ಸ್ವಾಮಿ. ಅಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಸ್ಟೇ ಕೇಳಿ.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಸ್ಟೇ ಮಾಡಕ್ ಹೆಂಗ? You go ahead with that execution. Yes, heard. Issue notice. Stay of. ಎಲ್ಲಿದೆ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಅಂತ ಎಲ್ಲಿದೆ ರೀ? ಟೈಪ್ ಕಾಪಿ ಹಾಕಿಲ್ವಾ?
87 ಪೇಜ್ ನಂಬರ್ 87.
Page 87 ಅಲ್ಲ?
87
IA is filed by the learned counsel for seeking hereby rejected with the cost. ಆಮೇಲೆ
ನೆಕ್ಸ್ಟ್ ಅದಾದ್ಮೇಲೆ ಇಶ್ಯೂ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಟು JDR.
ಎಲ್ಲಿ ಅದೇನು ಓದಕ್ ನಮಗೆ ಕಾಣಿಸಲ್ಲ. ಟೈಪ್ ಕಾಪಿ ಹಾಕಿದೀರಾ? ಎಷ್ಟನೇ ಡೇಟ್ ಹೇಳಿ?
87 ಸ್ವಾಮಿ. ಲಾಸ್ಟ್ ಅಲ್ಲಿ 22/8/25 ಆಗಿದೆ.
22/8/25. 25.
ಹೌದು.
ಏನದು ಓದಿ? ಏನದು ಫಸ್ಟ್ ಇಂದ ಅದು ಏನ್ ಬರೀತಾರೆ ಒಂದು
PF paid issue arrest notice to the JDR.
PF paid
ಹೌದು.
issue arrest notice to DR. Yes. Stay of order dated 22/8/2025 in respect of issuing warrant, arrest warrant to that appellant till next date of hearing, subject to condition appellant has to deposit. ಆದ್ರೂ ನೀವು ಅವತ್ತಿಂದ ಇವತ್ತಿನವರೆಗೂ ಸಿಕ್ಕಿಲ್ಲಲ್ಲ?
ಅಲ್ಲ ನಾನು ಮಿಸ್ಲೆನಿಯಸ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದೆ.
Yes. Subject to condition deposit 4 lakhs before this, before that executing court within 2 weeks.
3 lakhs ಸರ್ ಆಗ್ಲಿ. ಅಷ್ಟು ನಂಗೆ ಒಂದೇ ಸರಿ ಇದ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತೆ.
No, I will give 2 weeks time to 2 lakhs, another 2 weeks for another 2 lakhs. 2 lakhs, 4 lakhs out of that 2 lakhs has to be deposited. What is the date?
Sir, ಇವತ್ತು 4.
Has to be deposited on 18th. Another 2 lakhs has to be deposited by end of March. Yes.
Much.
Serial number 20, Deepak Wagle.
Appearing for the petition, my lord. In this matter, my lord, execution petition, my lord, court commissioner was appointed to identify the property, my lord. The court commissioner, with the help of surveyor, prepared a sketch and filed his report. In that report, to that report, I have filed objection, my lord. Without considering my objections, court commissioner report was accepted. Now that in the court commissioner report, my lord, kindly see at page 57, my lord, at the sketch.
Yes.
And there is and now kindly see at page 21 that boundaries, my lord, first. I'm sorry. Boundaries.
What is the degree? What is the degree, Mr.?
The suit for declaration and possession, my lord, that was decreed. I am the defendant. I am the judgment debtor now. Kindly see page 21 that decree boundaries, my lord. I'm sorry.
26.
21. Boundary.
Yes.
The unredeemed Sagu Jaga of 4.22 acres of survey number 155/1 with the land revenue assessment of rupees so and so and bounded on the east by survey number 150/4 and 155/56. Although 150/4 is not mentioned in that sketch, my lord. Nowhere it is mentioned. Kindly see at page 57. And any boundaries are not tallying with that boundaries mentioned in the decree, my lord. That is my objection.
Where is that order? Rejection order ಎಲ್ಲಿದೆ?
ಇಲ್ಲ, accept ಮಾಡಿದ್ದಾರೆ. Accept ಮಾಡಿದ order kindly see at page order sheet starts at page 9, my lord. That operative portion is at page 18. Page 18, last para order. The report submitted by court commissioner marked at exhibit C1 2 3 is hereby accepted. Issue delivery warrant if PF is paid. The court bailiff is hereby directed to execute the delivery warrant to the extent of decreased property.
Further
Other than
proceedings in 52 of 2012 pending in the file of pending in the file of Senior Civil Judge Madikeri till next date of hearing.
Great.
Cell number 21, Syed
I appear for petition.
Yes.
The second defendant's writ petition, Lord, filed application order 6 rule 17, Lord, seeking amendment of Lord writ petition at para 13, Lord. Wanted to brought to the knowledge of the court, Lord, the scheduled property is executed, Lord.
You are the defendant.
I am the defendant.
Suit for?
Suit for specific performance filed by the first respondent plaintiff.
What is that order you are challenging here?
Order, Lord, and a rejection of Lord order 6 rule 17 application. Lord, the trial court has not passed any speaking order, Lord.
Where is that order?
Order starts from Lord annexure D, page number 33. And only 2 paragraph, Lord, at page number 40 is the consideration. But the present suit is filed for the plaintiff. Merit that, Lord.
Yes, read.
Present suit is filed for the plaintiff against the defendant for the relief of specific performance of contract. When upon the pleadings, it pertains to note the defendant have admitted partly the sale agreement entered between the plaintiff and them. Hence, now said defendant cannot go beyond written statement which is already filed by them. Therefore, but this reason my application came to be rejected. Where, Lord, I filed an application to Lord bring to the notice of the court that Lord the suit schedule property is already.
What is
sold.
that amendment now you are seeking?
I am seeking, Lord, the amendment, Lord, at page number 26, my IM, Lord. To add para 13 after para 12.
What is that?
It is that, Lord, I have sold the property, the defendants have sold the suit schedule property to some third person, but prior to filing of the suit itself, isn't it?
Yes.
That is what the amendment I wanted to brought it.
Or issue notice. Stay of further proceedings in OS number 1042 of 2025. Pending in the file of 5th Additional Senior Civil Judge JMFC Mysore till next date of hearing.
Cell number 22, A. Abhinav Ramanand.
My lord, yesterday I got an hand summons, my lord. Today I need to attend the court like that. I didn't got a time to keep lawyer or my lord. Actually, the OS is already in the trial.
You want to engage the lawyer or you want to argue that?
And my lord, I need to engage the lawyer
tomorrow.
Prima facie, the OS.
Two things. You want to argue your case or you want to engage the lawyer? If you want to engage the lawyer, I will grant any time.
My lord, I need to engage the.
Tomorrow.
I need to engage the lawyer, my lord.
Yes, tomorrow.
No, my lord. My lord, actually, tomorrow I have jurisdiction in JMFC court at Pavgada, the court.
Day after tomorrow. Day after tomorrow.
My lords only say that the hand summons is served on the parties.
Yes,
Last
yes.
time hand summons are made.
Yes. The 14 person appear before the court.
For the respondents.
Respondent.
Which respondent one? Respondent one, my lord.
Nivena or Magana?
Maga, madam. My lord.
Yes. Respondent number 1, Srimati Puttama's sons. What is your name?
Adarsh Kumar, my lord.
Adarsh Kumar is present before this court. He prays 2 days times to engage the council. Is this matter day after tomorrow?
My lord, but on March 6th, we have court at Pavgada, JMFC court. Still the hiring is not yet started, my lord.
No, that is not the case. Now you day after tomorrow you engage the council. Lawyer ne appoint ಮಾಡಿ.
ಮಾಡ್ತೀನಿ my lord, but 6th ಅಲ್ಲಿ ಕೂಡ court ಇದೆ my lord.
ಇವತ್ತು ಯಾವ ವಾರ?
ಇವತ್ತು 4th my lord. Day after tomorrow ಅಲ್ಲಿದೆ my lord.
Monday.
7th.
7th. 7th
Oh,
is
sorry.
Saturday.
Monday.
ಖಂಡಿತ.
Grateful. I have served it on the council for the plaintiffs. I will file it in the registry. Acknowledgement.
Yes.
Grateful.
Grateful.
Cell number 23, Patri Vishal for petitioner Srikanth.
Previous matter, Lord, notice to R2 to R6 may be dispensed. Previous matter.
Yes.
R1 is continuous.
Yes, petitioners. Yes.
The advocate for the respondent.
Defendant's writ petition.
Yes.
My lords, suit for bare injunction filed by the plaintiff.
Yes.
Now the allegation, my lords, in the plaint at para 6 at page 86.
Yes.
They claim, my lords, ownership over survey number 48 measuring 30 guntas.
Yes.
At para 6, they say, my lords, plaintiff submits that the defendant herein has no manner of right, title, interest or possession of any kind over the scheduled property, that is survey number 48. And the defendant has purchased various properties situated on the southern side of the suit schedule property And the said portions are the portions of the land bearing survey number 48.
Yes.
The defendant, my lords, claims ownership of 7 odd acres in survey number 47.
Yes. Yes.
The para 6 indicates, my lords, that on the southern portion is the survey number 48.
Yes.
At page 89 in the boundaries, if your lordship sees,
Yes.
it is described as survey number 47 being on the north side.
47 is north side.
It is on the north side. The allegation is that south side there is some disturbance.
Yes.
So we appeared, my lords, we filed a detailed.
Your property in 48 only.
My property, my lords, is in 47.
No,
I have no interest in survey number 48.
no, that you said that you have a 7 plus
17 acres
in 48 only.
in 47, my lords.
47.
In 47.
Yes.
They claim ownership of 30 odd guntas in 48.
No, anyhow, you are not concerned with 48.
I am not concerned with 48.
Now, where they said that disturbance is only from southern side.
The para 6 at page 86.
Yes.
And then at para 7,
Yes.
next page at page 87, the
Yes.
plaintiff submits that the defendant has entered into certain transactions with owner of portions of land bearing survey number 48 situated on the southern side of the suit schedule property, and under the guise of the said alleged transaction, defendant and its men attempted to interfere with peaceful possession and enjoyment of suit schedule property by the plaintiff, and also attempted to put up construction over the suit schedule property in order to dig
What is that
foundation, etc.
injunction granted?
Now, injunction has been granted, my lords, in the year 2023.
What is that injunction?
At page 111, we preferred an MA, my lords, before the first appellate court. At page 111 is the MA order.
No,
That is
what
not under challenge, my lords.
No, what is that order passed?
The order is not to put up construction.
No, that injunction order has been granted. You
Granted.
challenged in that MA.
Howdu.
MA it is set aside.
No, my lords. MA nalli it confirmed the order of the injunction.
Injunction.
39(1) and 2.
Yes. Now that
Now,
what is
please.
that injunction order passed by the trial court?
Trial court, my lords, at page 110. In page 110, operative portion of the order,
Yes.
the defendant is hereby temporarily restrained by an order of temporary injunction from putting up any construction over the suit schedule property till disposal of the suit. This was confirmed by the MA.
Yes.
Now, my lords, in 2025,
Yes.
2 applications came to be filed.
Yes.
That is IA number 3 and 4.
Yes.
IA number 3, my lords, was under 39(2)(a),
Yes.
alleging contempt of the order,
Yes.
and IA number 4 seeking police protection under section 151.
Yes.
Now, these 2 orders, my lords, have been passed where it has been allowed.
What is that finding?
Finding, my lords, is at page 11. Sorry, page 19.
Yes.
Relevant at page 20. Orders on IA number 3, where it says register, my lords,
Yes.
because that's the procedure. 39(2)(a) hakid mele, first thing they say is register.
Yes.
Technically, my lords, not much grievance. The only grievance is at page 124, if your lordship sees the application.
Yes.
Relevant, my lords, at page 127, paragraph 8.
Yes.
5 lines, my lords, they say on 19/10/25, and
Yes.
they have put up compound wall in my property in this regard is the allegation.
Yes.
And at next page, paragraph 9, page 128, they take one name, my lords, which is 3 lines from the bottom at para 9.
Yes.
He, my lords, is the legal officer. I mean, my grievance is that he is a legal officer of the company, and they've made personal avata on papa Mysurnalidda. Against a legal officer, my lords, it may not be required, would be my respectful submission. They also say Gunda's elements, all that, my lords, and it is registered as a miscellaneous case.
newly appointed manager is
Ah.
in a civil prison, not exceeding the 6 months for having violated that. Who has violated?
They say, my lords, this
That has to be
person-
decided now that.
That has to be decided, I understand.
They,
my
they
own-
may say that nobody has violated. Why can't anticipate it now that.
Correct, my lord. That's why I said it's on a weaker footing there, but it's only legal anta, we can go and agitate the issue there.
Yes.
Now, insofar as police protection, my lords, at page, the impugned order, at page 21, ink page 21.
Yes.
The finding, my lords, is at ink page 22.
Yes.
And at para 10, my lords, the next page.
Yes.
The crucial question for determination before this court is whether police protection can be lawfully provided to enforce the temporary injunction order passed by the civil court. In this context, it is pertinent to refer to the ratio laid down in so and so case.
Yes.
Then after laying down the ratio, my lords, at next page, at para 11, in the instant matter, the temporary injunction was granted after hearing both the parties on merits. The defendant was specifically restrained from putting up construction of a suit schedule property. Despite such restraint, it is alleged by the plaintiff, though a sworn affidavit, that the defendant continued to interfere with his peaceful possession and enjoyment of the property. Para 12 is important, my lord.
Yes.
When a temporary injunction is granted and subsequently disobeyed, so therefore the court comes to a conclusion, my lords, that there is disobedience. It is imperative that the order be enforced strictly to uphold the rule of law and to safeguard the rights of the party.
Now,
in whose
only
favor-
your apprehension is that this will come in your way of that another application.
Contempt, my lords. That is one apprehension. The second, my lords, is through the guise of this order, if the police comes and oversees it, my lords, there should not be technically anything grievance from my side. But now with the police coming there, the plaintiff, who's the respondent here, is saying bring down the compound wall, which is impermissible, my lords. If that can be clarified, I think nothing will survive.
It can never be anybody's case that the police must come and do something. Police can only come
Police
and
cannot.
assist.
Police cannot.
I have, in some cases, I have clarified. Now, what has happened? Injunction order will be granted. Even though parties are not in the position, some on the basis that court will grant an injunction order.
Correct.
He is not in the position. Taking that,
They will
police cannot
to evict.
dispossess them.
Other problem.
That's what I said. Police has to see whether violated or not. If it is violated,
I
has
am
to
not-
report to the
I
court.
am not a fan of police protection.
No, no.
Order is there. If this is the apprehension, we will also clarify. Police cannot come and
that's
put up a compound wall. But if there is violation, police will definitely.
Police can supervise and see if there is any violation, report to the court saying that this is the violation.
Perfect.
Or if there is any physically this thing, they can restrain.
They
Perfect.
cannot put down the compound wall, nothing of that sort.
Yes,
That's all.
yes, sir.
Perfect. That's all. Adu one clarify arbitrary, I think that's
Yes. In this writ petition, petitioner
You know what, Stella?
called in question, order dated 6/2/2026, passed by Civil Judge JMFC Bangalore Rural District on IA number.
IA number 3 and 4.
3 is only
That's
registered
right.
to a
No, no.
case.
Yes, IA number 3
Facts.
and 4. The plaintiff has filed, plaintiff respondent has filed in a suit for
Injunction.
Injunction.
along with that they have filed an application under order 39 rule 1 and 2. The trial court by order dated
5/1/22.
5/1/2022 has granted a temporary injunction restraining the defendant from interfering over the peaceful possession and enjoyment of the property bearing survey number 48 measuring 30 guntas scheduled property. Being agreed by the same, the petitioner defendant has filed an MA before 4th Additional Senior Civil Judge Bangalore Rural District in MA number 49 of 2022 by order dated 16th March 2023. The order passed by the trial court has been confirmed. Thereafter, plaintiff has filed IA number 3 of 2025 under order 39 2A. On the basis of that application, IA number 3, the same has been registered as a separate miscellaneous case. The same has been consider as it has been registered as per the law. There is no error in passing an order registering that IA number 3 as in a separate case. Therefore, the prior in respect of that IA number 3 is dismissed. In respect of IA number 4 is concerned, it is filed under section 151 of CPC seeking a police protection. Only apprehension of the petitioner that by impugn order passed on IA number 4 and strictly uphold the rule of the safeguarding right of petitioner that the taking an help of the police, they may demolish the compound wall. Karnataka Senior Counsel.
No, that is
already been demolished. His apprehension is that the police will erect the compound wall.
Yes,
No, there is a compound wall now. It's not demolished. The allegation in the contempt is that I have built a compound wall.
Yes.
So therefore, there is a compound wall now.
The apprehension is that police, instead of police has in supporting that plaintiff for alter the possession of that suit scheduled property. Learned counsel, senior counsel appearing for the plaintiff has submitted that the police protection is been obtained to see that order should not be violated by the parties. With the help of the police, they will not make any alteration. In view of the above, there is no order required on IA number 4. It is made clear that police has to only given a protection to see that order of the court has to be implemented and not to support making any alteration. If there is any violation of the court order, the police has to report the same to that court. With that observation, the writ petition.
Great.
Great.
Yes.
Great. Fair.
Great.
Number 24, Venkatesh S. Sarapatti.
Yes. Yes, Mr.
Without an application on record.
Yes.
For the respondent. And without not an affidavit in accordance with law, the learned judge of the commercial court would allow the application filed by the plaintiff.
No, that another dispensed with production of certified copies of the Annexure A.
Yes, ma'am. Annexure A, ma'am, is the impugned order.
Impugned order.
I
Yes.
produced the e-courts.
Yes. What is this suit, Mr.?
Suit for suit in relation to intellectual property rights protection.
No, you are the.
I have filed counterclaim lot for a larger sum.
You are the defendant.
I am the defendant. I have filed a counterclaim also.
Yes.
But after not pleadings were completed, issues framed, the learned trial commercial court was pleased to post the matter for trial. The plaintiff filed a memo. Kindly come to Annexure D, page 89. The counsel for plaintiff submits here as under. It is humbly submitted this on court by its order dated 12 January 26 was pleased to grant liberty to plaintiff to file an application seeking appointment of an advocate commissioner for the purpose of recording evidence. It is humbly submitted that the notarization of the application and signatures were procured on 29 January and 2nd February from Mr. So and so. Copy of notarized document is produced hereto as Annexure 1 to show bona fide of the plaintiff. It is humbly submitted that the plaintiff has next proceeded to seek appointment for apostolization of the documents. It would take about 30 days time for notarized apostolization of the document and thereafter for such document to reach Bangalore, India. It is humbly submitted that in view of the bona fide circumstances stated here and above, the plaintiff requires a period of approximately 30 days to file the aforesaid application before this honorable court seeking appointment of advocate commissioner. Hence requesting for adjournment 30 days. Next page, my lord, is the photocopy, scanned photocopy of the application. The page thereafter is the scanned photocopy of the affidavit, which is submitted to the court along with this memo. Kindly see, my lord, the dates also. And the learned commercial court, my lord, passes the Annexure A order, page 16. Case called out in open court, counsel for plaintiff.
Yes. Yes.
Counsel for plaintiff present and file memo with soft copy of application IA number so and so filed under order 26 rule so and so for appointment of recording of evidence of plaintiff witness through court commissioner. Copy served Sri GKS advocate Sri VSA for defendant present and submits no objection to allow the application with a direction to the plaintiff to adduce evidence, heard and peruse the records. Plaintiff has filed the suit for permanent and mandatory injunction in respect of infringement of trademark along with the recovery of money. Records reveal that the matter has been referred to BMC but returned not settled. This is a case of the year 23. Hence, considering the facts in IA number 11 is allowed. Commission fees fixed at rupees so and so for filing memo of instruction. Without an application under, in fact, my lord, kindly see, my lord, the application.
You said you have no objection.
Lord, it is recorded as such. My lord, there is no such no objection. Lord, how
Have you
can I
stated
say?
in the petition you have objected for that?
My lord, for the respondent, my lord.
Wait, Mr. Lett, please. Have you stated in the petition saying that you have not given the consent?
My colleague appeared. But even if I do not object, but based on a memo, Lord, along with an unsigned, Lord, and undated, kindly, Lord, see page 91.
No, that is different.
Yes.
We'll come to that.
Yes.
Now that whether you have given any consent. Yes, Mr. You sought for any time, but court has fixed that for pass an order on that this thing.
My lordship, court was convinced with the bona fide of the document I have.
No, what is that relief you have sought?
In writing, I have sought, my lordship. Orally, I have sought like if my lordship.
How can that, Mr.
My lordship.
To sought in a time 30 days to get an original copies and
yes, my lord.
when you sought in a time, court go on beyond that and appointed in a commissioner. How can that be?
My lordship.
That too on the Xerox copies.
My lordship, court was convinced with the notarization in the photocopy. My lordship, as an officer of the court relied on my representations. I have the originals before me here, my lordship. My lordship may kindly peruse that.
No, you file an application now.
Exactly, my lordship. Before that, the petitioner has come here and filed.
No, I will.
My lordship, the mere intention is, my lordship.
I will set aside that order. Please. I will permit you to file in a fresh application
Much
along
obliged,
with that
my
all
lord.
documents. Let them consider and pass an order.
Much obliged.
I have stated some para 8.
Para?
Para 8 of the petition.
Yes.
In page 8 and para 8 of the petition.
Yes.
About 5th line. Further, the learned
yes
judge of the commercial court grossly erred in taking no objections of the petitioner
yes.
to the said application.
Will set aside. Yes. Where is his page number or his application?
Application, Lord, is filed along with the memo, annexure D at page 91.
30 days to filing. He sought for a time, but court has
allowed the application. Gone ahead.
Yes.
My lordship, my humble submission is I made oral submission having court verified the bona fide, even though if it's a scan copy, I'll file the originals in the next hearing date.
No, even you can trust it, but we have to do it in accordance with law, is it not?
Much more. My lord, my lord, even the court does not require a scan
now,
copy.
anyhow, you have all the copies. You file an application and take an order for court commissioner. Yes, there is no problem in that.
The original copy of that same photocopy is here with me right now. My lordship may kindly see that as well.
No, Mr. Counsel, you have filed a memo stating that I have not yet obtained grant 30 days time.
Yes, my lord.
In that memo, court has taking and pass an order that appointing a commissioner.
My lordship,
no, you want to file a fresh application or you want to argue on that?
I want to file a fresh application.
That is better. Otherwise, if I stay that, then your suit will be stayed for. Yes. Then they have taken note that advocate has said no objection. He has filed an affidavit saying that he has not. Then it has to be inquired. Then it will be take time. Better if file. Yes. Yes. Called in question. Order dated 4/2/2026 passed by 87th Additional City Civil and Session Judge Commercial Court, Bangalore, allowing that memo filed by the advocate for appointment of the court commissioner to record the evidence of witness in OS number 670 of 2023. Respondent plaintiff has filed a suit for
infringement, my lordship.
Suit for infringement of
trademark and recovery.
After the appearance, defendant has filed their written statement
along with counterclaim.
Along with that counterclaim, the plaintiff has filed, the counsel for the plaintiff has filed a memo by Annexure D on 4/2/2026, seeking time for filing an application for appointment of advocate commissioner in the above case. On that memo itself, court has passed an impugn order appointing the court commissioner on the ground that the defendant petitioner has no objection. The defendant petitioner has filed this petition, has taken a specific contention that they have not given any no objection to allow that memo filed by that counsel for the petitioner.
Memo ga no objection is there. That is for adjournment of 30 days.
Yes.
IA ge object.
Yes.
IA ge, because there is no IA,
Yes.
so he would not have said.
For that adjournment, they have no objection. But without filing an IA enclosing that certified copies of that documents, he has an objection for allowing that. It is wrongly noted that advocate has no objection for that also. Be that as it may.
My lordship,
the
one humble
memo-
submission. In the order, it is stated no objection to allow application with the direction to the plaintiff to adduce evidence.
No, they said they have not given that. That is what that affidavit filed. That is
So,
wrong.
what was the objection is, like, if the originals is provided, I don't have any objection. That was.
Now that you file an original, then they will, yes.
There is no.
Yes. Be that as it may, the memo is filed only for seeking in a time to file an application for appointment of the commissioner after securing all necessary documents. Learned counsel for the plaintiff respondent has submitted that. Now they have secured all original documents.
The original documents is.
Yes. And he may be permitted to file a fresh application along with the documents, please, for appointment of advocate as a commissioner. In view of the above, the impugn order so and so is set aside. The plaintiff is permitted to file an application for appointment of advocate as a commissioner in accordance with law. If such application is filed, the same may be considered in accordance with law and pass an order. Yes.
His name may be noted.
Oh.
Cause list does not show his name.
Yes. So what is your name?
have,
So
Indra
and so
name.
is undertake to appear for respondents. Office is directed to.
Please.
Yes.
Bill number 25, Jayasham Desi Mana.
Yes.
Suit for permanent injunction, my lord.
Yes.
The plaintiff is before this court.
Yes.
The grievance, my lords, of the plaintiff is the ex parte injunction was not granted and emergent notice was issued.
Yes.
Title is not in dispute. My lords, may kindly take page number 47 of my petition. Photographs have been annexed, my lords, where the defendants in fact damaged the fencing around my property.
Suit for injunction.
Suit for permanent injunction.
Permanent injunction. Yes.
Please. 47 onwards, my lords, I have annexed the photographs where he demolishes the fencing around my property and he.
Has he filed ex parte you have sought for?
Yes, my lords.
Where is that order?
My lords, the impugned order, my lords, is at page 70. Is the order sheet, my lords. 71, your lordships would get the order. Emergent notice is issued.
When?
Lords, it is issued on 12/2, my lords. 12/2/2026. Lords, if there is no protection that is given to me or to my property, my lords, the suit itself would be rendered infructuous.
Yes. Or issue notice. Parties are directed to maintain status quo.
Lords, one difficulty, my lords, with status quo. He has now, my lords, demolished it. I'll also have to maintain it in the same way if your lordship says status quo.
But you don't want to go and construct till that notice is to be served. Mr.
I don't want to construct anything.
But what will you do?
Let him not come and.
No, that's what
further
status
cause-
quo. He can't come now. Status quo is there.
ಅಲ್ಲ ಅವರು ಕಲ್ಲು ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು, whatever he has put up, let it be there as it is. Neither you remove it or he is remove it. After his presence, we'll decide that. Yes. Parties are directed to maintain status quo in respect of suit scheduled property till next date of issue emergent notice. Yes.
My lords, in that case, my lords, the applications before the trial court may be directed to be disposed of.
Presence should be there, mister.
These, my lords, he has now put up a fence over there.
No, you don't want any interim order, then I will direct it to dispose after.
Very well, my lords, because status quo, but the only problem is, if I may impress upon your lordships,
Yes.
he has put up some fencing over there.
Yes.
That creates an issue, my lords. Then I will have to maintain that as it is.
Yes.
In my property, this title is not disputed.
Yes.
My possession is not disputed.
Yes.
In that case, my lords, I will have to bear with his illegal trespass.
No, because you have sought so many relief. Therefore, I said, if you are not pressing all this, you are only seeking to direction to dispose of your application, I can.
In fact, my lords, my relief, my lords, is to seek your lordship's indulgence in granting an ex parte injunction itself. But my lords, the problem is, since your lordships would be.
No, that I will record and direct it to dispose of your, yes.
Very well.
Within 30 days, they have to deposit, yes.
Very well.
Yes. Even though petitioner sought number of relief in this petition, counsel for the petitioner submit that he will not press for the same. He seek only direction to dispose of his application, IA number
1, my lords.
IA number 1 filed under Order 39 Rule 1 and 2. Submission is taken on record. Petitioner plaintiff has filed a suit for bare injunction. Along with the suit, he has filed application under Order 39 Rule 1 and 2. The trial court, where is that order sheet?
Page 71, my lords.
On 12/2/2026, has refused to grant any ex parte interim order and passed notice on the IA. No, issue summons to the defendant returnable by 12/3/2026. Therefore, the petitioner is before this court. Be that as it may, when petitioner has filed an application, IA under Order 39 Rule 1 and 2, the trial court is directed to consider the same and pass an appropriate order in accordance with law within 30 days from date of receipt of copy of this order. With that observation, writ petition is disposed of.
Cell number 26, Madhukar MD for petitioner. Harikesari KK.
Defendant 26. Yes.
Lord, by this
Permit me
petition,
to
my lord.
appear on behalf of the council, my lord. My
Yes,
colleague,
yes, yes.
is my colleague.
Anybody can appear. I want assistance, that's all.
He's my colleague, my lord. I have not.
Yes. Earlier, there was a judgment saying that unless you are not on the records, you have to file in a memo for appearance. Yes.
My lord, suit for simple recovery was instituted by the plaintiff, my lord.
Yes.
Then defendant appeared and he filed a written statement.
Yes.
One of the contention raised by the defendant
Yes.
by filing an application is that
Yes.
the suit is not a commercial suit and
Yes.
it is not a commercial dispute. Then, my lord, issue number 2 was framed. Then I also filed an application for the return of the plaint because there is no commercial dispute involved.
Yes.
There is an agreement between the plaintiff and defendant, my lord. The defendant is supposed to procure the land, and once he procures the land, he is supposed to procure in the sense, my lord, he is not supposed to register in his name. He is only supposed to do the licensing work. And accordingly, my lord, he has procured the land. The details of the procurement, my lords, would get at page number 41. That is part of the plaint.
Yes.
There is a table, my lord, at page number 41. Internal page number 7, my lord.
Yes.
The table, my lords, can see. The table continues up to page number 43, my lord.
Yes.
These are the lands which has been procured, my lord. These lands stands in different person's name, my lord. It won't stand in my name, my lord. I'm only supposed to liaison and they are supposed to get the property registered, my lord. Then what they say that there is certain difference in amount, in payment of the amount to me.
Yes.
That my lords can see at page number 44, third line, my lord.
Yes.
Page number 44. Therefore, it is evident from the account statement of the plaintiff that an amount of 7,24,54,000 was transferred in excess of terms and condition mentioned in MOU as per the demand of the defendant based on.
Yes.
So this is the difference amount, my lord.
Yes.
For this particular difference amount, my lord, suit for recovery has been instituted. My lords can see the prayer at page number 49.
Yes.
The suit amount is, my lord, recovery amount is 6 crore 74 lakh 54,000.
Yes.
Then they say that this is the actual amount which I am supposed to pay.
Yes.
Then, my lord, I filed the return statement. Then my specific contention before the court below is that, my lord, it is not a commercial dispute.
Yes.
Then, my lord, the court, for that I filed an application. That application is at Annexure G, page number 102, my lord.
Where is the order of the?
Yes, my lord. Order is at Annexure A, my lord. My lords would find the reasoning at page number 21, my lord.
Yes.
Then, my lord, at para 21, my lord, the court has called out order 7 rule 10, my lord, return of the plaint. Then I request my lords to kindly take page number 23, my lord.
Yes.
Then, my lord, the court at para number 23, the certain observation has been made that it is a commercial business, my lord.
Yes.
Then, my lord, at para number 25, which continues at page number 24, my lord, there is a reference to one particular judgment of Andhra Pradesh High Court, my lord.
Yes.
Then in that particular Andhra Pradesh High Court, there is a reference to one Ambalal Sarabhai judgment, my lord.
Yes.
That is a Supreme Court judgment.
Yes.
In that particular Supreme Court judgment, my lord, at para number 37, whether a simple suit for recovery can be a commercial dispute. That the court has held that every dispute is not a commercial dispute. In that judgment has been held. But the court has followed this Andhra Pradesh High Court judgment, my lord. Then, my lord, I request my lords to kindly take page number 30, para 26, my lord.
Yes.
Then, my lord, after para number 26, my lord, after referring to the Andhra Pradesh High Court judgment, then the court takes reference to section 21C6, my lord. Then the court comes to a conclusion that it is a commercial dispute. I request my lords to kindly take section 21C6, my lord, of Commercial Courts Act.
Yes.
My lord, the commercial dispute has been defined in section 21C, my lord. Every dispute will not become a commercial dispute unless it falls under any of these category.
Yes.
Commercial dispute means dispute arising out of, I request my lords to kindly take 6, my lord.
Yes.
Construction and infrastructure contracts, including tenders.
Yes.
My lord, this is not a construction agreement, my lord. This is not an infrastructure agreement. The word construction and infrastructure is not defined. Whereas specific relief act defines the infrastructure, my lord. Infrastructure means road agreement, bridge agreements, which are relating to the tender. So neither this is a construction agreement, my lord. This is a licensing agreement. And the learned judge says that it falls under section 21C6, my lord. My submission is that, my lord, this approach is only to overcome the judgment of the Supreme Court as well as this honorable court. This honorable court already in one particular judgment, my lord, has held that every dispute is not a commercial dispute. I request my lords to kindly take the compilation, my lord, which I have filed in the registry, my lord.
Yes. Is the judgment?
Yes, my lord. I have filed it in the registry, my lord.
Yes.
The first judgment, my lord, that is Ambalal versus KS Infra Space LLP, my lord.
Yes.
I request my lords to kindly take the direct para number 37, my lord. That page number, ink page number 19, my lord.
Yes. Yes.
A dispute relating to immovable property. Here, immovable property is not involved, my lord. It is only a recovery of money. Per se may not be a commercial dispute.
Yes.
There, my lord, it was a specific relief was sought for. But it becomes a commercial dispute if it falls under subclause 7 of section 21C of the Act, the agreements relating to immovable property used exclusively trade or commerce. Well, if the immovable property is involved, if it is exclusively used for the commercial project, then it becomes a commercial dispute. So that is how it has been interpreted.
Agreement. What is that?
I am supposed to license, my lord. I am supposed to introduce the landowners to he is in a real estate business, my lord, to the who is supposed to procure the land, and then they will transact and they will purchase the land.
Yes.
And the amount is fixed, my
You
lord.
are giving in commission.
I am getting the commission. I am only interested in commission.
Yes.
The word used exclusively in trade or commerce are to be interpreted purposefully. The word used denotes actually used, and it cannot be either ready for use or likely to be used or to be used. It should be actually used, such as a wide interpretation would defeat the objects of the act and the fast tracking procedure discussed above. So the court in this case, my lord, said that all dispute cannot be a commercial dispute. Now I request my lords to kindly take, after this particular judgment, the Supreme Court recently, my lord, that is next page, page number 21, my lord.
Yes.
In Velayutham versus MR-MGF land case, my lord. This particular judgment, my lord, again, my lord, the commercial dispute was, commercial suit was filed.
Yes.
That was objected, and both the court held that it is a commercial dispute.
Yes.
Then, my lord, para number 5 and para number 6 and 7, my lord, the court considered it and remanded the matter to the trial court to consider the issue whether it is a commercial dispute.
Yes.
This particular judgment has been followed by this honorable court, my lord. I request my lords to kindly take the judgment which is at page number 53, my lord.
Yes.
Then, my lord, I request my lords to kindly take page number 66, my lord, where the discussion with respect of Ambalal Sarabai as well as the other judgment has taken place.
Yes.
Para number 9, my lord, page number 66.
Yes.
My lord, there is a reference to Ambalal Sarabai judgment, my lord.
Yes.
Then, my lord, the court considers the other judgment, my lord, that is Gujarat High Court judgment at page number 74, my lord.
Yes.
That is Maduram Properties versus Tata Consultancy. That is also available in the compilation, my lord. Then, my lord, after considering these aspects, my lord, at para number 10, my lord, page number 77, the recent Supreme Court judgment after Ambalal Sarabai judgment, that is Velayutham judgment, that has been taken into consideration, my lord. Then, my lord, at para number 11, my lord, after considering Ambalal Sarabai's judgment, the court has made the observation, my lord. I will just read it. On a close of judgment rendered by Apex Court and the Gujarat High Court, the agreement between the parties which forms the fulcrum of the lease is required to be considered. The agreement is for the purpose of investment in residential apartment complex that is to be constructed by the petitioners. Since it is a residential complex, it is not for trade or commerce. The option for buyback will not amount to issue becoming a commercial dispute. Though much water has flown from between the parties right from 2011, this court is now required to answer whether this would amount to a commercial dispute or otherwise. Identical agreement and investment were considered by Division Bench of Gujarat High Court, to which I am in respectful agreement. Insofar as judgment relied on by the learned counsel appearing for the respondent, there can be no qualm about the principle laid down therein. The investment in the said case was for construction of mega shopping mall. Shops in the shopping mall would undoubtedly be used for trade and commerce. The agreement executed between the two was clear that when the shops are sold or rented out, the amount of investment would be returned with applicable interest. The said judgment would not become applicable to the facts of the case on hand, as the investment in the case at hand is clearly for a project which seeks to construct residential apartments. Merely because an option of buyback is available to the investor, it does not become a commercial dispute. In that light, the plaint ought to have been returned. Even looking at the plaint averments, the commercial court has entertained the dispute as it runs counter to what the Apex Court has held in Ambalal Sarabai Enterprises Limited case and the Division Bench of Gujarat High Court. In the light, the petition deserves to be succeeded. My lord, I am in a better position in this case. The reason is that, my lord, it is a simple recovery suit for return of the money. Whatever the property, it is between them, and that particular project, it is between them, my lord. And I am only interested in the MOU. That MOU I have produced at page number 54, my lord. There are two MOUs. One is first MOU, it is page number 54. The second MOU is at page number 65. That is only for the, I am interested only in commission, my lord. Yes. So my submission is that, my lord, a simple recovery suit cannot be transposed as a commercial dispute.
Yes. Lord, he admits that this MOU is for a purpose of commission. Now, my lord, he has acted as a liaising person between the landlord and the respondent plaintiff herein. Yes. Lord, kindly see section 2C7 of the Commercial Codes Act. agreements relating to immovable property used exclusively in trade or commerce. Lord, here the purchases made by the plaintiff was for the purpose of trade or commerce for forming a layout for which he was supposed to earn commission.
The agreement between you and that purchaser for trade and commerce, you can approach that. For
For
not
which
for
I have filed a separate civil specific performance suit before the jurisdictional court at Devanagari, my lord.
Yes.
Here, there was excess payment made to the plaintiff, respondent here, petitioner herein.
Yes.
That is why a suit was filed. Now, my lord, the learned friend says that he has raised an objection with regard to whether it is a commercial dispute in his written statement. That was not done. My lord, no objections were raised even at the pre-litigation stage also. There is a PLM report, my lord. There also they did not appear and raise any objection saying that this dispute is not a commercial dispute. So commercial court doesn't have a jurisdiction. In the written statement, they have not filed. Thereafterwards, my lord, statement of truth has been filed. There also they don't raise an objection regarding the jurisdiction of the commercial court to try this suit. Plaintiff has led evidence. Thereafterwards, they have cross-examined the plaintiff witness. PW1 has been cross-examined. At that stage, this application is filed, my lord, which has been observed by the trial court, saying that, my lord, it is belated. If they had any objection with regard to the jurisdiction of the commercial court to try this suit, my lord, they ought to have raised it at the initial stage.
Judgment on that point saying that if it is belatedly raised, even for the jurisdiction.
Section 21 of the CPC itself says, my lord, section 21 may kindly be seen of the CPC.
And what stage that return of the plaint has to be filed?
Lord, return of plaint, my lord, that is the ambiguity, my lord. Section 16 says, my lord, Order 7, Rule 10 says at any stage. But Section 21, my lord, regarding objections to jurisdiction.
Yes.
In CPC, my lord, it says, my lord, may I read the Section 21, my lord?
Yes.
Subclause 1, my lord, no objection as to the place of suing shall be allowed by any appellate or revisional court unless such objection was taken in the court of first instance at the earliest possible opportunity and in all cases where issues are settled at or before such settlement and unless there has been a consequent failure of justice. In this case, my lord, issues are framed.
Yes.
PW1 has led evidence. They also filed the statement of truth earlier to that. Yes. PW1 steps into the witness box. He leads evidence. Documents are marked.
Yes.
Cross-examination has been proceeded with by the defendant. At that stage, they filed this application. That is why, my lord, once they submit themselves to the jurisdiction of the court,
yes,
commercial court, now they cannot raise an objection saying that the plaint has to be returned, my lord, and they have to go before the civil court.
My lord, issue framed by the court, my lord, on the basis of pleading, page number 99, my lord.
What is the date?
The date of the issue raised is 31st July 2025, my lord.
Yes.
The issue is whether the defendant proves that this court has got no jurisdiction to try the suit. So I have raised the jurisdiction as an issue, and on that basis only this issue has been framed.
Then let him show it in his written statement.
No, not the question. If the court has framed the issue on the basis of my pleadings only.
No, it is not that.
No. Let me complete my submission.
Wait. Now, why the court has framed that issue?
That
Issue should be on the basis of the pleadings of the party.
That is not with regard to whether the commercial court has got jurisdiction or not, whether it is a commercial dispute or not. Here he says that, my lord, it is not a commercial dispute. That is why I have to go to the civil court.
No, what is that? Where is that issue?
Page number 99, my lord. It is a composite issue has been framed. I don't have the control over the framing of the issue. The court will frame it.
Yes, wait.
Yes, my lord.
99.
99, my lord.
Which is that? Whether
issue number 2, my lord. Whether the defendant proves that this court has got no jurisdiction to try the suit, comma, there is no cause of action and suit is barred by limitation.
On that purpose.
Yes.
There are 3 issues. No, my lord. My submission is that, my lord, it is a composite issue. My submission is that. Yes, my lord.
Show me in your pleadings.
Yes, my lord.
Have you raised this objection?
My lord.
And you show me that.
Yes, my lord.
Section 21 read with 10A.
Yes, ma'am.
And that Commercial Court Act.
Section 21 is applicable only with respect of place of suing.
Yes.
If I am supposed to file it in Kolar, but I have filed it in Bangalore and I have allowed that particular suit to, it is only with respect of place of suing.
It is jurisdiction.
Yes, my lord. It is a jurisdiction means it is with respect of territorial jurisdiction. Whereas order 7 rule 10, it is a complete code, it governs the entirety.
Yes.
So order 7 rule 10 cannot be made applicable.
Order 7 rule 10 can be filed at any time.
Yes, my lord.
There is
No, because it goes to the root of the matter.
Yes.
7 rule 10 as well as 7 rule 11 can be filed at any stage.
Pecuniary limit of jurisdiction should be allowed by the. No, it is only pecuniary jurisdiction limit.
Yes, my lord.
Yes, Mr.
Lord, that is what, my lord, he has not raised it in his written statement.
If he is not raised,
Yes.
is there any bar not to rise at that any stage? That is what you have to be shown me that.
My lord, kindly see that, my lord, since he has not raised this issue, he has participated in the PLM report also. Then afterwards.
No, that is only a question of law.
Yes, my lord.
Show me that.
My lord, the judgments what he has relied upon of the coordinate bench, my lord, there, along with the written statement, order 7 rule 10 application was filed.
No,
My lord, kindly see this.
no, Mr. Counsel, I am asking simple question. Show me that you forget about the facts of this case. You show me it can be raised at preliminary stage. It cannot be raised at after the issue is framed. You show me any judgment on that point. It's end of the matter.
My lord, he has submitted himself to the jurisdiction, my lord. That is my submission. That is why at the judgment what he has, my lord, I understand your lordship's point, my lord.
Jurisdiction point is concerned. If it is without jurisdiction, if it is order is passed, if degree
It
is
cannot be
passed,
executed, my lord, is my.
Therefore,
Yes, I understand.
if court says that there is a limitation, then that will be, that's what that point you have to say. He has not raised, he is raised there and all. Now, what you have shown 21,
yes,
it is there in for a pecuniary jurisdiction. Is there any similar law or a judgment showing that in case of that, if cannot raised after the issue, then he is out. That judgment you have to find
But
out.
I
on
will
that.
Kindly grant me 2 days time, my lord, on that.
Not that you have
Section
to-
21, I will, whether it is, it
Case-
amounts to only.
No, your case is, first case on strong basis is delay. Point out in a law and.
Yes, I will. At what stage he
Is
can-
what that,
Once he submits himself to the jurisdiction by.
Jurisdiction I can raise any stage, my lord.
Let him produce
Yes,
that. Yes.
my lord, it is set down for the cross examination.
Friday
Court
it
is
may be
day
taken.
to day, it is taking up the matter, my lord.
Friday
Let
you
there
don't-
be some protection. Let him say that he will not insist
Or
further.
else Ninth letter, let it be on 9th, my lord.
Let
we
him,
will
let
not-
him give an undertaking that he will not insist.
But on Friday, don't.
No, it is on 9th itself, my lord, we will not precipitate.
Yes, let his statement may be recorded.
No, if he
I am
said, why are you?
placing-
Yes.
Because the court is insisting for day to day hearing, my lord. That is the difficulty.
Pleadings here.
And last date of hearing also they took the time.
When is the next date?
9th, my
9th
lord.
itself.
We are taking this matter on 9th itself.
Yes.
Yes, if it is insisted, you brought to notice of the. court.
I don't know because the Deshpande doubts my submission.
No, I am not doubting his
Yes,
credentials.
Yes.
Number 27, K. Chandranath Ariga.
Petitioner, my lords. Suit is one for permanent injunction, my lords. My lords may find the plaint, my lords, at ink page number 17, my lords. My
Yes.
lords, if I may read the prayer in the suit, because much before going to the issue, my lords.
Yes.
Listen. My lords,
So you are the plaintiff, defendant.
I am the defendant number 1 and 2, my lords.
Yes.
My
Suit
lords, suit is for permanent prohibitory injunction. My lords may find that prayer, my lords, at ink page number 22.
Yes.
For permanent prohibitory injunction, restraining first defendant from selling A schedule shares. For permanent prohibitory injunction, restraining first defendant from redeeming the B and C schedule mutual funds unilaterally. And permanent prohibitory injunction, restraining defendant number 3 to 5 from permitting the first defendant to sell, redeem A schedule shares, B, C schedule mutual funds. For permanent prohibitory injunction, restraining defendant number 6 from permitting the first defendant from withdrawing the dividends.
Yes.
My lords, here is a case, my lords, wherein daughter files a suit against the mother, stating that allegedly there were certain shares of her father which were being deposited in the accounts of the mother.
Yes.
So which I defend the suit, my lords, by filing written statement. In that suit, my lords, they file an application, my lords, under Annexure D, my lords, ink page number 34. Under order 11 rule 14, seeking an order from the court against the defendant number 6, that is the bank, to produce certain documents on oath. That is, the certain document is none other than my personal account statement. My lords, that application is accompanied by a memorandum of fact, not an affidavit. My lords, thereafter, my lords, the defendant number 6, my lords, on at ink page number 34,
Yes.
ink page number 34, my lord, it seeks time on 4/9/2025. It seeks time to file objections, my lords.
Yes.
My lords, after seeking time, my lords, at page number 38, my lords, on 5/8/2025, without there being any judicial order. On 5/8/2000, counsel for D6 present and filed a memo along with documents. The documents are none other than my account statement.
Who has filed that?
The bank.
There is no order.
There was no order. There, initially they take time to file objections.
Yes.
They don't file objections. Without there being a judicial order, my lords, what they do is that they file my personal statements. My lords, thereafter, my lords, on the basis of this particular document, my lords, the plaintiff, my lords, she files another memo at ink page number 40 annexure F. On the previous occasion, the second paragraphs, on the previous occasion, the plaintiff had sought for complete account extract. Hence, plaintiff prayed to produce account extract from 24/3/2025 till date of filing of the same into the court. Plus, on the basis of, since D6 without a judicial order, it filed a statement, my statement. Certain further statement, the plaintiff proceeds to ask by filing a memo. Plus, on the basis of that memo, now the court passed a judicial order at ink page number 48.
Yes.
The defendant number 6 is hereby directed to furnish the SB account extract from 24/3/2025 till date of the filing of the same as sought by the plaintiff on the next date of hearing.
Yes. Heard. Issue notice. Stay of order dated 10/2/2026. Passed by which court?
The second additional ACJ and JMFC Mangalore.
Additional Civil Judge and JMFC Mangalore in OS number 552 of 2025 till next date of hearing.
Grateful.
Cell number 28, Chandan HP.
For the petitioner in this matter, my lords, the suit is for specific performance and permanent injunction. Lords, I filed the present writ petition with a prayer to direct the trial court to speedy dispose the matter, my lords. It's a only limited prayer. I filed this writ petition.
No, suit
No, my
for?
lords. Suit for specific performance and permanent injunction. The petitioner
What is the
hearing has now, my lords, is posted for cross of PW1 before the trial court.
Yes.
Now, my lords, the petitioner has paid almost more than 47 lakhs
Yes.
to the respondents number 1 to 4. Now, my lords, the agreement to sale, registered agreement to sale was executed in the year of 2022.
Prayer. The petitioner plaintiff has filed a suit for specific performance of the contract in OS number 44 of 2023 before 17th Additional City Civil and Session Judge Bangalore. Learned counsel appearing for the petitioner submits that now that pleadings of the parties has completed and it was set down for evidence of PW1. He sought for early disposal of the suit in view of the above without expressing any opinion on the merit of the case. The trial court is directed to dispose of the suit as expeditiously as possible, not later than 1 year from date of receipt of the copy of this. Yes.
Much obliged.
SG Muniswamy Gowda.
In view of the relief sought, notice to so and so is dispensed. Serial number
29.
Yes, Mr.
Appear for the petitioner, my lord.
Yes.
My lord, this petition emanates from execution proceedings based on a decree that was ex parte. That decree has attained finality.
Yes.
It was a suit for specific performance or return of advance money, which was paid to the tune of 45 lakh. They filed execution proceedings, and on 26/10/2023, IA number 3 for sale proclamation comes to be allowed.
Yes.
And then subsequently, there was a sale proclamation and there was a bailiff's report to the same effect. Those been annexed, my lord. But the learned trial judge reissues the sale proclamation without giving any reasons.
Why that on that day sale proclamation has not taken place?
The bailiff's report has been annexed to that.
Where is that?
It's at page number 113 onwards. That is the first bailiff's report.
What is the report?
Saying,
yes.
Yes. There's a typed copy also, my lord. Page number 119. It stated that sale had taken place and the time was given to the auction purchasers to fill the remainder of the amount. To the tune of 25% was paid, but he did not pay. And on the very next date of hearing, this sale proclamation was reissued. That your lordships will find it at page number. Page number 46.
Yes.
It outlines a sale proclamation. And if your lordship will turn to page number 48, sale proclamation was issued on 30/9/2024.
Sale proclamation proceedings in behalf necessary to
And then on
pay.
27/1, it was accordingly reissued.
Will issue sale proclamation, sale that attachment of the property bearing so and so. It shall be at the spot, not to set the final bid should be offered before the courthouse. The time gap between the first and second bid and the third bid shall not be less than that 15 days. The sale proclamation shall be found in the vicinity of the attachment of the property situated so and so. Then what has happened that?
Then second sale proclamation came to be allowed on 15/3/2025.
Where is that? That is what has happened that?
Page number 50, my lord.
Yes.
Page number 50, sale proclamation came to be allowed and auction took place according to the terms of the proclamation. On 15/4/2025 was the first auction, 2/5 was the second one, and on 3/6 was the final auction. And the auction purchases deposited 25% of the earnest money of the final bid amount. But as per rule 84 and 85, he is required to deposit the remainder of the balance amount within 15 days. If your lordship will notice the order sheet from page number 52 onwards, despite a time lapse of 6 months,
He has not deposited.
this balance amount has not been given. And he has filed application on application under section 151, giving one or the other reason, saying that he could not deposit for so and so reasons. And he's been paying
Now, what
them in
is that order
installments.
you are challenging?
I'm challenging the order dated 15/3/2025, the sale proclamation itself.
Lord, pursuant to action of sale, I met with an accident. My 2 colleagues expired. I have deposited 1,27 lakhs. Total amount is deposited. Today is the date for issuance of sale certificate in favor of me.
No, what is that price amount you have bid?
1,27 lakhs.
1 crore?
27 lakhs.
27 lakhs.
Total amount is deposited.
Now it is deposited.
Deposited. Now he's come before this court. Today case is listed before the trial court for issuance of sale certificate in my favor.
My lord, the mandatory language of a rule 84 and 85 is that 15 days is the upper limit. Upper limit on which the full earnest amount has to be deposited.
Yes.
And no application whatsoever, whether in partial payment or in lump sum, no extension payment can be granted to that effect.
84. Order 21 rule 84. Rule 84.
84 read with 86. '84 is for the 25% deposit as on the sale of date of auction. I do not dispute that. That amount has been paid. But only the remainder 75% of the balance amount has been paid in installments over a span of 6 months.
Let's see, any discretion of the court is there or not?
Please, ma'am.
Order 21 rule 84.
If I may make this submission, my lord, the sale was confirmed, the final sale date, on 3/6/25. The lordships were to 3/6/25, 2025. And they had 15 days. Read with section 10 of the General Clauses Act, it had to be deposited on 18th.
Yes.
And in the order sheet on 26th of June of 2025, the learned trial judge had ordered, if amount has already been paid, please issue sale certificate. But since it was not there, it was on 27th. It has already had to be deposited by 18th. So by that difference of date itself, the learned trial judge could not come to the finding that to issue sale certificate or to check the remainder of the amount.
What is the date he has paid that amount?
25% amount on the sale of date itself.
25% he has deposited.
On that day itself.
He has deposited.
75%, the total amount was paid recently on 30th January of this year.
30th?
January of this year.
26.
More than a lapse of 6 months.
Let us see what is the law. 86.
85, my lord, first 85.
Yes.
If I may read the relevant portion.
Yes.
The full amount of the purchase money payable shall be paid by the purchaser into the court before the court closes on the 15th day from the sale of the property. The proviso that in calculating the amount so paid to the court, the purchaser shall have the advantage of any set of that. That is not my contention in this case. The mandatory nature of the language of this provision, and there's a judgment of this court, this effect, if I may produce the same, my lord. Paragraph 8 of the judgment.
Yes. Yes. Yes, Mr. What is that? There is no such any power for the court to extend.
Lord,
86 says that it has to be forfeited and resell. Unless you show me that law which is permitted for the court to extend the time, we can't do that.
Lord, the whole point is, my lord, he's not a decree holder. He's the owner of the property. Suit is of the year 2017.
Who is the degree holder?
He is not the decree holder.
Who is the degree holder? You are not degree holder. What is
What
your?
I'm the judgment debtor, my lord.
No,
He's
he's
not
the
the
judge.
decree holder. He's a judgment debtor. And he has to pay 45 lakhs along with interest.
No, he is the judgment debtor.
Yes, my lord.
What is your right, Mister?
My lord, my property is being attached.
Your property.
Judgment debtor, my property is being attached. If I may clarify the point, my lord, ex parte decide again.
Non-compliance of that this thing. Degree. Degree. Yes.
Yes.
What is the degree?
The decree is at Annexure B. It was a suit for specific performance or return of advance amount, and it was decided ex parte. Your lordship will find the operative portion at page number 93. Annexure B.
No, that what is that benefit you will get that by reselling it will fetching more money.
Please, my lord, that's my
Now, law is that only for a reselling. You are not in the position to pay that amount.
We will pay that amount, my lord. That's the contention because counsel had not placed it before the trial proceedings, and it's posted for today, as my learned friend has stated. We are ready to pay the full and decretal amount, and that is independent of this contention that the law laid down in 84-85 has not been followed.
That right has been given within 30 days from the sale or 30 days of issuing the sale certificate. No, even
sale, my lord, proclamation.
From the proclamation. You are not made
so my
any
remedy is no application was made to that effect, so that remedy has been barred. But we're still willing to settle the matter and pay the entirety of the decretal amount. There is no qualms about that. But the only main contention, independent of that, is Section 84, 85, 86 read together have not been complied.
May I request my lords to kindly peruse order dated 25/6/2025.
What is
This
that?
is what has happened. May I read, my lord? On perusal, DHR present, counsel present, JDR absent. Final bidder present. Learned counsel for the DHR filed memo of calculation. On perusal of records, the bailiff report, it appears that sale proclamation was being issued on 15/3/2025. As per the order, the court bailiff conducted the first action sale on 15/4/2025. At the spot, the second action was being conducted on 2/5/2025. At the spot only. The third action was being conducted on 3/6/2025. In the court premises.
Yes.
On one, Shri Damodar Reddy was participated in the first action, second action, as well as the final action.
Yes.
The Damodar was being the highest bidder in the final action for rupees 1,27 lakhs. He deposited the 25% of the bid amount through DD bearing number so and so, dated 29/5/2025 for 10 lakhs and 22 lakhs respectively, in the hands of the court. On perusal of the record, the bailiff report, the action bid is lawful and valid. Today, Damodar Reddy is present before the court and is ready to deposit the balance bid amount. Till this date, no objection received in respect of bid or action sale. The JDR not present, and he has not filed any objections to the bid or seeking deposit the decree amount in order to cancel the action sale. Hence, the action sale is hereby confirmed. The final bid and bailiff report is hereby issued. Issue sale certificate pursuant to deposit the balance amount. I met with an
Law
accident.
says you have to be deposited within 15th day from the sale of the property.
I will accept, my lord. I met with an accident. Two of my friends died.
You
In
show
the
me any
accident.
law. If see, unless Law provided for the court to relax. We can't do it, Mr.
No,
Show me any law saying that this period can be, you see that 86. In default of the payment within the period mentioned in the last proceedings rules, the deposit may, if the court think fit, after defraying the expenses of the sale, be forfeited to the government and the properties be resold, and the defaulting purchaser shall forfeit all the claim to that property, and so on. So
As you
unless you show me any judgment interpreting this provision says that court has a power to extend, then we'll see that.
I'll take notice, my lord.
Yes, you take notice, but we'll stay that confirmation of the sale is that. Yes. You verify any judgment on that point.
My lord, because
Yes, court may have sympathy on you, but their law is not provided. We can't do anything unless you have to assist.
my lord, as your lordships rightly pointed out, not only did they not stay the sale or set aside the entirety of the sale process, because they had to reissue this entire sale proclamation because payment was not made in 15 days. They've granted repeated extensions for
No, let
payment
us
in
see.
part.
No, yes.
And this sale cannot even
So
be
is
considered
undertake to
sale.
appear for respondent. ಎಲ್ಲರಿಗೂ ನೀವೇನಾ?
ಇಲ್ಲ, only for respondent number 4. Damodar.
Respondent number 4, issue eminent notice to 1 to 3. Stay of further proceedings in execution number
47 of 2019.
2019 till next date of hearing.
If I may request your lordship for hand delivery of the order, my lord, it's posted for today.
Not my request. The date, my lord. Short point is involved. I will assist the court so that because I have
ನಾಳೆನೇ ನೀವು ಅದ್ರ ಬಗ್ಗೆ ಅಸಿಸ್ಟ್ ಮಾಡಿದ್ರು I am ready.
the Monday or Tuesday, my lord.
Yes. Leave this matter on 16th.
Yes.
Yes.
We'll serve the counsel on the trial court by then, my lord.
Yes, in addition, permitted to serve copy on the council appearing for respondent number 1 to 3.
Seal number 30.
Grateful.
Become Chand as for petitioner.
Appear for the petitioner. Defendant number 1 is before your lordships. In a suit for partition and separate possession, my lords. An application under order 39 rule 2A is reserved for orders without an inquiry, without opportunity to adduce evidence.
No, you are the defendant.
Please, my lords, defendant number 1, taking my objections as not filed, and the learned judge says hearing by the defendant side is not required. Let's have challenged that order, my lords. Page 66 is the impugned order.
Yes.
Matter is called out, plaintiff and D1 present, objection to IA number 7 and 8 not filed. Heard Sri so and so for plaintiff on IA number 7 and 8. Since objection is not filed, hearing by defendant side is not required. And my lords, all of this conspires in within a span of 8 days, my lords.
Order 39 rule.
That's the question of my personal liberty is involved, my lords.
Now let us see what the provision says.
Please, my lords.
Is it required to hear or not?
No, usually, my lords, what happens is a separate miscellaneous proceedings is registered. Thereafter, inquiry has to be conducted and evidence has to be
Not
made.
filed any objection to that IA under 39 1 and 2.
No, my lords, I have filed. Please, my lords. Your lordships may kindly come to page.
Matter is called out, plaintiff, defendant number 1 present.
Let's 2A, my lords.
IA 7 and 8 not filed ಅಂತ ಇದೆ.
ಅಲ್ಲ IA 39 under order 39 rule 2A ಗೆ 2A is breach of injunction. For that, my lords, if your lordships may kindly come to page 64.
No, that injunction has been granted earlier.
Please, my lords, ad interim ex parte injunction has been granted.
Now that violation of
injunction ಗೆ
has to be registered and
it's a separate miscellaneous proceedings has to be registered.
now what the court said.
My lords, the court has said page
For
66.
orders on IA 7 and 8.
Please, my lords.
No, what is that order they are going to? They may be registered that.
No, my lords, if they had been registering, my lords, it has to be done on the very same day. They've posted the matter for objections. Objections not filed under ತಗೊಂಡಿದ್ದಾರೆ. Your lordships may kindly come to page 65.
Issue notice. Stay of order dated 27 to 26 in OS number 95 of 2025 pending in the file of Senior Civil Judge JMFC Nanjangud till next date of hearing.
That's my request that your lordships may clarify that orders may not be passed on 39 rule 2A, my lords.
Stay of that order means what, Mr.?
Very well, my lords. My request for hand delivery, my lords.
This serial number ಎಷ್ಟಿದೆ?
39.
That's the order sheet.
What is
my
that?
lords.
What is that dispense?
That's the order sheet has been produced, online copy, my lords.
You produced,
Certified.
yes,
Please, my lords.
4 weeks to dispense to.
My lords, I'm
And to
seeking
produce.
dispensation of notice to respondent number 5 to 11, my lords.
Why?
My lords, they are not necessary parties with respect to this application. My
Yes, 5 to.
lords. 5 to 11, my lords.
Kodi. Dispense at the risk of the petitioner. Yes.
My lords, I filed a note to that effect below the cost title page.
Memo kodi, yes.
Memo no ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
Yes.
For hand delivery, my lords. I request
Yes.
for hand delivery.
Serial number 31, Vinay N for petitioner.
Here for the key witness.
Yes.
For petitioners, my lordships.
Yes.
This writ petition is filed challenging the order dated 24/2/2026
You are
passed
a-
by the commercial court, my lordship.
You are a defendant or plaintiff?
For defendant, my lordships.
Suit for?
Suit for bare ejection, my lordships.
Suit for eviction. Eviction.
Eviction. Sorry.
Yes.
My lordships. Yeah. The order is in page number 113, annexure P, my lordships.
Yes.
In the middle of the order,
Hmm.
there is a specific observation by this honorable court.
What the order was?
Honorable court in WP number 26714 of 25 dated
ಗೊತ್ತಾಗಿರಾ?
in the middle center portion of the order sheet.
ಮೇಲಿಂದ ಓದಿ. Case called out in that open court. Yes.
Case called out in the open court, parties are absent, counsel present, already heard in IA number 19.
There is that record.
Peruse the records. The counsel for plaintiff has filed present application under section to release deposit amount of rupees 12,50,000 by the defendant on 8/10/2025 for the reasons assigned in the accompanying affidavit stating that as per the direction of the Honorable High Court of Karnataka in WP number 26714 of 25, plaintiff has filed the application to pass necessary orders for release of the said amount in favor of the plaintiff, which has been objected by the defendant by filing objections dated 12/2/2026, stating that the WP is pending for consideration and now the plaintiff cannot seek absolute right before passing the judgment by withdrawing the amount referred supra. It is pertinent to note that there is a specific observation of the Honorable High Court of Karnataka where in writ petition number 26714 of 25 dated 17/9/2025 to the effect that the petitioner defendant has been directed to deposit rupees 12,50,000 before this court on or before the expiry of 3 weeks. There is further observation as it is open to the respondent plaintiff to file necessary application seeking withdrawal of the said amount once deposit is made, subject to the condition that there shall be an interim order only.
Why earlier writ petition?
My lordships, there was an IA number 2, 16 to 18 was filed to recall, reopen and direction to produce GPA.
Who has filed?
We have filed, my lordships.
You have filed.
No, we filed. They have filed. The plaintiff has filed.
ಆಮೇಲೆ
My lords, if I can just explain in a minute. Suit for eviction. What has happened is that he was a tenant under my mother.
My lordships.
My mother under gift gave me the property. I'm only on the facts. I will not say anything more. My mother under a gift deed gave me the property. I filed a suit for eviction. He denies the gift deed. Now, my lords, I had filed an IA number 2 for deposit of the admitted rent amount. IA number 16 and 18 I filed because what happened is that there was a GPA under which I had given to my sister for the purpose of prosecuting the case. That GPA was sought to be marked. Now, the difficulty is that the person who gave the GPA, that is me, the original plaintiff, has passed away due to cancer. Husband and daughter, the class 1 heirs have been brought on record. Now, for all of that, there was no objection. When I filed to produce the GPA, he raised several objections. On that, my lords, an order came to be passed, which my lords will find at annexure K, page 74. That is the order which came to be passed at annexure K.
Yes.
Page 74, my lords will see, that is the order which is passed. My lords were to just come to page 102 for a minute, my lords. That's the operative portion of the order.
Yes. No,
101.
application is rejected, you come.
No, my application is allowed. My application is allowed. I'll just read the operative portion, then I'll read the interim order. My lords, I can confusion agatiಲ್ಲ ಅಂದ್ರೆ ಬರಿ ಅಷ್ಟು ಓದಿದ್ರೆ. Page 101 ತಗೊಂಡ್ರೆ
IN number 2 filed by the plaintiff under 151 CPC is partly allowed. Consequently, the defendant is directed to withdraw a deposit a sum of rupees 25,34,000, which is the amount equivalent to unpaid admitted rent from the date of filing of the suit till up to so and so date, and the said amount shall be deposited within 15 days. Further, the defendant is directed to continue to deposit the amount equivalent to so and so till the disposal of the suit till every month. This is the direction. It is further made clear that the amount so deposited by the defendant shall be directed to be kept in fixed deposit and shall be adjusted towards future and mean profits, if any, awarded to the plaintiff in the final judgment, and the amount so deposited shall be released to the party entitled to the same as per the result of the suit. IN number 16 to 18 filed by the LRs of the plaintiff were also allowed. Consequently, PW1 is recalled for further chief examination, and the LRs of the plaintiff are also permitted to produce the original DPA, keeping open the question of admissibility subject to payment of cost. This, my lords, was challenged by my learned friend. Kindly come to page 103 at page 105.
Yes.
My lords, at 105, my lords, were to see serial number 14, that is the order dated 3/9/2025.
Yes.
List the matter on so and so date. Objections, if any, by caveat on the next date. Further proceedings before the concerned court shall remain stayed on the score that an unregistered document is said to be marked without following due process of law, observing that it would be subject to objections. Then, my lords, next date we say, petitioner is before this court calling in question a composite order which directs deposit of so and so amount and a marking of an unregistered document. This court, in terms of an order dated so and so, had stayed further proceedings on the score that the marking of the unregistered document is without following due process of law. Learned counsel for the respondents now submit that the court had directed deposit of the aforesaid amount, which is not done by the petitioner. In this light, I deem it appropriate to direct the petitioner to deposit 12,50,000 before the concerned court on or before the expiry of 3 weeks from today. It is open to the respondents to file necessary application seeking withdrawal of the said amount once the deposit is made. Subject to the said condition, there shall be an interim order only of the marking of the unregistered document. Now, my lords, I have filed an application. His contention is that, in a nutshell, his contention is that, please see the order of the trial court. Trial court had said that who should get the money will be decided in the end. That is what the trial court's order said. But now, my lords, by virtue of this honorable court's direction, saying that I can withdraw the money, I have filed an application. His thing is that that particular order, the effect of that particular order, which my lords will see at page 101, is gone. Yes. That is the crux of the matter. I have a simple solution subject to what my learned friend would say. My lords, let me take the money. I will give an indemnity, saying that in the event, ultimately, if it is held that I am not the original landlord, and I will return the money back along with bank rate of interest.
Yes,
Please, my lord.
Anyhow, that you can't enjoy that money. It will be in that bank. Let him be given a indemnity bond. If he fails also, he has to give that interest, bank interest.
My lordships,
Instead of depositing that fixed deposit, it will be there in that his hand.
My lordships, I have judgments related to which support my arguments, my lordships. I'll just pass on to you.
Yes.
My lordships, 2008 judgment.
Yes.
Para number 23, my lordships.
Yes.
In that last 6 lines, in that it's been mentioned that in a suit for recovery of rupees 1 lakh, my lordships. 23, my lordships. Last 6 lines.
Yes.
Yeah. In a suit for recovery of rupees 1 lakh, of the court cannot grant a degree of rupees 10 lakhs. In the suit for recovery of possession of the property A, court cannot grant possession of property B. In a suit for paying of permanent injunction, a court can't grant a relief of declaration or possession. The jurisdiction to grant relief in the civil suit necessary depends upon the pleading prayer, court fee paid, evidence let in, etc. My lordships. Here, if the suit is only for ejection, my lordship, in the prayer, there is no other relief sought for. It's only for the bare ejection, my lordships, and there is no court fee paid. And there is nothing that they have prayed for.
No, suit for ejectment, court can direct you to pay that rent. There is
My lords, it is there. Please see page 27.
My lordship,
please see page 27. It says future damages and cost of the suit.
Yeah, please, my lordships. It's subject to the result of the suit, my lordships.
Now that if it is released in his favor, what difficulties will cause to you or what prejudice to cause to you?
My lordships, there is nothing that they have sought for. They have not pleaded anything, my lordships. They have not sought the relief at all in the prayer. So,
no, but this court has directed to file an application.
Please, my lord.
Application has been filed.
Yes.
Court has to consider in accordance with law.
Please,
there is an earlier order that it will be adjusted to that finally. Even if it is released, what prejudice will cause to you? That's what we are asking.
Yeah, there is
this
another
is all not that any law. It is for the discretion of the court.
Please, my
If
lord.
if it is caused any injustice, you point out, then we'll consider. Otherwise, he will take the money. He is ready to give that indemnity bond. It is nothing but any money. What, see, your apprehension is that suppose if you succeed, I have to get back that money, it's difficult. He is
No, he will never get back the money. According to him, I am not the landlord. My mother is my mother is the landlord. So at the very least, he has to pay my mother. My lords, furthermore, why he is not entitled to relief? I'll further say. My lords, there's a direction. Only one part of the direction was state, which is to deposit 25 lakhs. Every month he had to deposit the money. That every month he is not depositing. Now, order was passed in October.
That is for you to pass any degree on that.
No, my lords,
If it is default
kindly see page 101 for a minute. I'll point out that also. My lords, what I'm saying is that why he is not entitled to discretionary relief again. My lords, we have to come to page 101 for a minute, my lords.
Yes.
My lords, this first para is IA2 is allowed. Consequently, he is directed to pay 25 lakhs. Kindly see the further direction.
Yes.
The defendant is directed to continue to deposit amount equivalent to admitted amount rent from 1/8 till the disposal of the suit. Before this, he has not done. Till date, he has not done. When he has not done this, can he is entitled to any discretion from this honorable court?
No,
When
if
he
he is not done, what is the remedy for you?
my remedy, my lords, my remedy is to file appropriate application for contempt, which I will do, my lords. That is not the thing. What I'm saying is he entitled to a discretionary relief if he's saying aggrieved, etc.? The second part of the order is not state.
No. He is not seeking any discretionary relief. That is, you are seeking that
No,
discretionary
my lords,
relief
he's
for
saying
releasing that.
he's not making out a legal case. For he's saying that
No,
pleading.
see, what the court said, you see that you file an application.
Yes, my lords. I filed an application.
Now, what the, you see that order,
Page 105, my lords.
105.
Yes, my lords.
It is open for the respondent to file necessary application seeking withdrawal of the said amount once deposit is made, subject.
This
to
is for the 12 lakhs 50,000.
There shall be an interim order. Yes.
This is
Open-
only for the 12 lakh 50,000.
No, you can file an application.
I filed
Court
an
has-
application.
Court has not directed to release.
Please, my lord, that is the
My
only.
lords,
Trial court has a discretion.
Yes.
But earlier order, you see that what the
Yes.
trial court said. It has to be deposited. It should be adjusted to that payment. It's same when at the time of.
Final.
my lords, this application, this order is passed on my application. Kindly see my application. I fully see what my lords is. Kindly see my application for a minute.
Where is your application?
No, that is for withdrawal. My lords, my application for page 50, my lords. Kindly see my application.
Application for?
My lords, for deposit of rents.
Yes.
Annexure D. Kindly see Annexure D.
Yes.
My lords, Annexure D says, please see the prayer. Direct the defendant to remit the rentals arising out of the scheduled property before this honorable court. No, my lords, when I filed this application, my lords, until he deposits it before this honorable court, I cannot accept it. Why? Because there's a judgment of this honorable court which says that if I directly accept the rent from him, then the court can infer that the termination of tenancy is not valid. So therefore, I have to file an application. Once I file an application, the next stage thereafter would be to file a subsequent application. It is not that the court has debarred it. Court has said, because as on date, my lords, I have not filed such an application. Once I file such an application, that application has to be entertained. On this aspect, my lords, there is judgment of this honorable court. Can
No,
I just?
This annexure D is that application on this basis impugn order is passed.
Yes. No, not this application. Not this impugned order. The original impugned order.
Original impugn.
That order, my lords, will find at 106. Kindly see 106, my lord. Annexure M, page 106.
Yes. Thus, anyhow, that what prejudice will cost to you if it is released to him?
My lordships,
Because
I've just
he is
passed on another judgment, my lordships.
What is that?
And page number, sorry, 2010 judgment, my lordships.
What is there?
Para number 41.
Yes.
Instance abound where observations of the.
41.
Para 41, my lordships. Instance abound where observations of the court reserving the liberty to a litigant for further litigation has been misused by litigants to pursue remedies which were wholly barred by time or to receive or to revive slate claim.
But this is not also not applicable, Mr. Yes.
My lordships, it's on the liberty.
No, you give, huh?
It's only for the liberty, my lordships. There is no other explanation given by the trial court, my lordships. It's just based on once the amount is deposited and they have.
Of difference.
They have not, they need to provide an appropriate application. They need to.
Show me the judgment in suit for eviction. Rent which is deposited cannot be directed to release that tenant. You show that judgment, then he has no right.
No, please, my lord, there is no such order passed by this honorable court to release the rent.
No,
my
there is no
lordships.
such order passed by this court.
Please, my lord.
The trial court has a right to directed to release. You will modify that subject to he has giving an indemnity bond. He can be released, and if you succeed, he has to return with that bank interest. What prejudice will cause? Yes.
Please, my lord. Correct.
Yes. What will be prejudice will cost you instead of that? See, if the court is directed to you deposit, then you can fight that whether I can deposit or you are already deposited that money. Instead of laying in that court, we can say that let him use, but with this a certain condition. Yes, Mr. Anything else?
My lordships, there is a writ petition which is pending before this honorable court, which will be listed tomorrow, my lordships. Can this matter be connected with that? And until then, let the amount be still deposited.
Wow, very good. My lord, this submission was made by my learned friend yesterday, to which he said both are not connected. My lord, they are not connected.
Both
Let
are
me
not
let me
connected,
just
my
be very
lordships.
clear.
They're not connected. I'm just requesting the honorable court to connect the matter, my lordships.
Will dispose of this matter with modification of that order saying that let him withdraw that subject to that deposit.
My lords, can it be made this way? Subject to the result of the final suit.
Yes. If the suit, if he fails,
yes,
he had to. No, one thing is that it will be released subject to indemnity bond as giving. Then if he fails, you have to return with that interest.
With bank interest.
Bank security need to be given, my lord. Bank security, my lordships, because.
Bank security. What bank security?
What security?
Yes.
My lord, with greatest of respect, he has no legs to stand on this to make
Bank
such a
security
statement.
antandre, again he has to deposit that amount in the bank.
Yes.
It is nothing but.
My lord, this is just a tenant's way to harass a landlord. Yes. Just a tenant's way to harass a landlord. I didn't want to say it in so many words. This is very pitiful.
In this petition, petitioner called in question, order dated 24/2/2025, passed by Additional City Civil and Session Judge, Commercial Court, Bangalore in OS number 1575 of 2022. Thereby, application filed by the plaintiff is allowed, permitted him to. Where is that impugn order?
Annexure
Annexure P113, my lordships.
My lords, on the annexure.
Yes, permitted the plaintiffs to withdraw the deposit made by the defendant, sum of rupees 12,50,000, along with that accrued interest. Learned counsel appearing for the petition, that respondent, first respondent plaintiff has filed a suit for eviction. After appearance, the plaintiff, petitioner, defendant has filed a written statement. The trial court by order dated
Lords, 18/8/2025, my lords. That order, my lords, will find at page 74. 18/8/2025.
74 other.
Page 74, annexure K, my lords.
Yes, 18/8/2025 has passed following order, 101 only order questions. Thereafter, the petitioner herein is also filed a writ petition before this court in WP
26714.
714 of 2025. In the said writ petition, liberty has been reserved to that respondent plaintiff to file an application seeking withdrawal of the said amount once deposit is made. Pursuant to that, respondent plaintiff has filed an application for releasing that amount. Accordingly, the impugn order has been passed. Learned counsel appearing for the petitioner submitted that the trial court has passed an order on
101, minutes. 18-8,
18-8,
18-8,
18/8,
25.
25. Deposited amount shall be released to the party as per the result of the suit. Therefore, pendency of the suit, the order passed by the trial court to release that amount is unsustainable. Learned counsel appearing for the plaintiff respondent has submitted that as per the directions of the trial court, the petitioner has deposited how much amount?
12 lakhs 50,000.
12 lakhs
50,000.
50,000, but he is not directing, he is not depositing the monthly amount as directed by the trial court. And he further contended that he will give indemnity bond in case if he fails in the suit, he will pay that amount with the bank interest. In view of the above petition is disposed of. The trial court is directed to release that amount deposited by the petitioner, that is sum of rupees 12 lakhs 50,000, along with that accrued interest in favor of which plaintiff, subject to condition, plaintiff has to give indemnity bond to that amount and with the interest. In case if he fails, he has to pay entire amount with that bank interest to that petitioner hearing. Yes, with that observation, writ petition disposed. Yes.
Please, my lord.
All pending.
Such indemnity bond will be filed within 1 week.
Whenever you file, the amount will be released. Otherwise, it will not release. It is for you. Yes.
Serial number 32.
Please, my lord.
please state it now.
Yes. Yes, Mr.
Matter was settled before Lok Adalat between
Yes.
the plaintiff and defendant. But there was certain errors in the compromise petition which was typed and presented before the Lok Adalat. Parties realized not that it was not in terms their understanding. And not an application under 153 to, because not it results in a decree. The same petition not turns out to be a decree. An application was filed not so that the decree should be corrected in terms of the actual compromise. Because after the application is presented, the defendants also appear before the court and state no objection. Page 29 of page 20, 3 minutes for a moment, para 6. Because the trial judge not says that, no, I cannot alter the decree which has been passed by, which has been exceeded before a Lok Adalat. And
No, where is that order passed by the Lok Adalat?
But the decree, the order which has been accepted, the order sheet not for a moment. Page 50 for a moment. Counsel for plaintiff and
Interim application filed by dismissed with the cost. No, Allah. Whether it is accepted before the Lok Adalat or the court.
50.
50?
Page
50.
Yes.
Yes.
Before Lok Adalat held on 31.
Hmm.
Counsel for plaintiff and counsel for defendant number 3 present. Conciliator of Lok Adalat also present. Both parties have submitted joint compromise petition. Peruse the contents of compromise petition, read over and explain to the party. On inquiry, both parties have admitted the contents of the compromise petition. The Adalat is satisfied with the compromise is best interest, hence so and so on. Then we filed an amendment
According to
saying
the compromise degree in terms of the. No, this is passed by the court after that settlement.
this is passed before the Lok Adalat.
No, if it is Lok Adalat, other member signature should be there. This is what this court said. There could not be any order compromising before the Lok Adalat in the order sheet maintained in the civil court. That compromise itself has to be set aside ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ತಿದ್ದಾರೆ. ಆದ್ರೆ ಅವ್ರು ಇಲ್ಲಿ ಏನೋ
ಪಕ್ಕದ ಪೇಜ್ ನಲ್ಲಿ ತಾವು ನೋಡಿ
ಇದು ಕಾಂಪ್ರಮೈಸ್ ಲೋಕ ಅದಾಲತ್ ಅಲ್ಲ ಆದ್ರೆ ಇನ್ನೊಬ್ರು ಮೆಂಬರ್ ಇರ್ತಾರೆ. ಕನ್ಸಿಲೇಟರ್ ಮೆಂಬರ್ಸ್ ಸಿಗ್ನೇಚರ್ ಬೇಕು ಇಲ್ಲಿ ಹಾಕಿದಾರಾ? Yes, also filed. Yes. Now this can be modified and recalled by that court or it has to be go before the Lok Adalat only.
No, minutes. Lok Adalat is functus officio. Minutes. What happens before the Lok Adalat is only an acceptance of the compromise. Ultimately, minutes, a decree is drawn by the court which accepts it. The decree is drawn. It is not the judgment.
No, degree will be drawn pursuant to the judgment.
Correct.
If there is any error in the degree, it has to be corrected by the same court. Can it be done it
Lok
by?
Adalat does not have the powers. Lok Adalat under the Act, does the Legal Services Authority Act, it does not have the power. Now, I can only go back to the court. The power is only vested under 150.
Let us see you take. Yes.
And defendants is also saying, I have no objection.
Yes, you take hand summons and we'll see. Yes.
Can I take it to the advocate who was representing the defendants before the trial court?
No, suit for?
Partition, internal.
Nim family member ಹೋಗಿ hand summons ತಗೊಳ್ಳಿ. Lawyer ಅವ್ರ fees ಎಲ್ಲ file ಎಲ್ಲ ಕೊಟ್ಟಿರ್ತಾರೆ ಎಲ್ಲಿ ಬರ್ತಾರ್ರಿ ಅವರು ಮತ್ತೆ. Why can't you take an hand summons?
He has appeared, He has appeared. Kindly see page.
Issue emergent notice to respondents. In addition, petitioner is permitted to serve a copy on the counsel appearing for the respondent before the trial court. Yes.
Can a date be fixed?
Yes, leave this matter on 26th. Yes.
33.
Yes.
But an impleading application has been allowed. Kindly see, it's a suit for, it's a plaintiff's petition suit for partition. My lordship will see the place for a moment. It's not at page 29.
Yes.
Defendant number 5, my lordship will see 30. Page 30.
Yes.
It's a family, it's a suit for partition of family properties. Now, children of the defendants intend to come on record. But children of defendant number 5 intend to come on record, claiming that idu namma tande asti. The property.
Tande is already on party.
Mother is already a party there.
Oh, father is no more.
Father is no more. Defendant number 5 is already a party. And defendant number 5 has already filed written statements. This suit has been going on from 2019. And it is, we are past the stage of evidence also.
No, that is true.
We are past the stage of evidence.
No, when the suit is filed, at that time itself, father was there, no more.
Father was dead. Defendant number 5 claims that it is her husband's estate. Plaintiffs claims it is their grandfather's property, which the grandfather is a Dodda Magana Henti Iddoru. She has exchanged in favor of another person. They have filed a suit.
No. That is not. Question is that whether they are the necessary party in that.
Once there is substantial representation, intermedular is already on record.
Let us see.
This is not. That is why once the
issue notice, stay of further proceedings in OS number 50 of 2019, pending in the file of Senior Civil Judge JMFC, plus Anjan Good till next date of hearing. Yes.
Thank you.
For orders, serial number.
We'll come back. Yes.
My lords, on submission, my lords, morning serial number 62, I have complained, my lords. Kindly interim order may be extended and date may be given.
62,
my lords.
Complaint.
Complaint, my lords.
Yes. Cabinet Council for the petitioner submitted that office objection is complied. Office to verify and proceed further. Interim order granted. Leave this matter after 2 weeks. Interim order granted earlier is extended till next step. Awaiting service of notice. Authority. Yeah, then bada. We have complied now.
Yes, my lord.
Yes, awaiting service of notice. Interim order granted earlier is extended till next date of hearing.
Much obliged.
30? 34. Yes, next matter.
Serial number 115.
Non-compliance of that office objection, you has complied. Then what else you want, Mr. RFA, no? Why it is posted now? Only compliance. Yes. Cabinet Council for the appellant submits that.
My lord may kindly order for hearing.
Yes, submitted that office objection is complied. Leave this matter
For hearing.
on 30.
Lord, serial number 115.
Let us see if that is it is admitted, it will goes to that final hearing. Yes.
Serial number 115, my lord.
Or any
The
other
prayer
date you
became.
want. Other than that, next is that 27 to holiday. 27 holiday. 27.
My lords.
27.
Serial number 38. Serial number 34, my lords.
34.
Short accommodation, my lords.
ಅದನ್ನೇ ಅದೇ
Short date may be given, my lord.
ಹಾ?
Short date given.
27th,
Serial number 38, wait of service of notice.
30.
18, wait of service of notice.
Awaiting service of notice to respondent. Yes.
41.
Who is other side? Yes.
I'm for respondent 345,
Hmm.
BBMP.
Yes. Await service of notice to R1 and R2. Interim order granted earlier is extended till next day.
41 and 41.1. Respondent.
Hmm.
Dear judges and today, it was here.
Yes. So.
Next week immediately.
Yes. At the request, you have informed other side.
I texted Mr. Vivek.
Yes. At the request of counsel for the respondent. Leave this matter of.
Next week immediately after 10. We are not seeking to.
Yes. Leave this matter on 26th.
Yes.
115, my lord, serial number.
45, my lord. I am
11.
applying the petition.
Serial number 45.
45, my lord.
Yes. A learned counsel for the petitioner has filed a memo. Leave of the court to withdraw this petition.
My lord,
Dismiss.
serial number 115, prayer become infructuous and other side also present, my lord, settled out of 115, my lord.
Yes. Learned counsel for the petitioner filed in a memo stating that in view of subsequent event, prior sought by the petitioner in this writ petition become infructuous. Memo is taken on record. The above writ petition is dismissed as 116, yes, madam. Notice order agidiyalla. Order agilwa. Why it is posted B group?
ಅಲ್ಲ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ.
Gave it study. They are also wakalat file notice agilwa. Yes, what you want, madam? Please this matter. Notary notice ಆಗಿದೆಯಾ ಆಗಿಲ್ವಾ?
Serial number 50.
ವಕಾಲತ್ notice ಆಗಿದೆಯಾ ಆಗಿಲ್ಲ ಅಲ್ಲ ನೋಡಿ. If it is not, notice is not issued, post this matter for preliminary hearing on Monday. 30. 30. You are appearing for? Inform ಮಾಡಿದಿರಾ petitioner ಗೆ? Yes, at the request of.
36 is concerned, my lord.
92, my lord.
36 is concerned. My lordship may kindly see, we have filed an application to bring the alas. That has been rejected by the FDP
No,
court.
I am asking, he is asking time, you have any objection or not?
Yes, my lord, because it's a small matter.
You
it
have
can be
any
disposed of.
objection?
It can be disposed of, my lord. Yes, my lord, I have, because lot of.
ಅಷ್ಟೇ ಸಾಕು. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇದ್ದಂಗೆ ಇಲ್ಲಿ ನೀವು ಟೈಮ್ ಕೇಳೋ ಅಷ್ಟೊತ್ತಿಗೆ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ನಾನು ಇಲ್ಲೇ ಕೂತ್ಕೊಂಡಿರ್ಬೇಕಾಗುತ್ತೆ. Yes, he has an objection.
Serial number
Unless you are
54, my lord.
ಮತ್ತೆ ನಿಮಗೆ ಇವತ್ತು ಏನ್ ಪ್ರಾಬ್ಲಮ್? ಅವರು ಒಬ್ಜೆಕ್ಟ್ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. Then it is discretion for me to grant it. Day after tomorrow. Day after tomorrow. Yes.
Serial number 54, my lord. 54, await notices, interim order may kindly be extended.
54, awaiting service of notice, interim order granted earlier is extended till next date.
52 also.
11. 118. ಏನಾಗ್ಬೇಕು ನಿಮಗೆ?
ಬೆಳಿಗ್ಗೆ 2 weeks ಅಂತ ಆಗಿದೆ.
ಹ್ಮ್. ಆಯ್ತು. We will have it on 27th. 27th. Yes. 90? 92. 27. Next week ಇಲ್ಲ. ಇಲ್ಲ ಅಂತಂದ್ರೆ ಏಪ್ರಿಲ್, you want any date in that April? ಆಯ್ತು, 27th. Yes.
Serial number 52, my lord. Await summons.
92. 92 you are appearing for? Have you informed other side? Inform ಮಾಡಿ ಆಮೇಲೆ ಟೈಮ್ ಕೇಳಿ. Vacating application ಇದ್ದಾಗ you have to inform and then mention. Otherwise I will urgent, but I will not extend that interim order. Which one you want? ಮಾಡ್ಕೊ ಬನ್ನಿ 2:30 ಗೆ.
Serial number 61.
60. 16, huh? Yes. Which respondent? 2 to 18. Yes. So and so has submitted that has filed an wakalat for respondent number 2 to 18. Office is directed to show his name. Yes. Awaiting service of notice. Compliance of office objection, Mr. Yes. Yes, awaiting service of notice. 61, which year?
61 ಅಲ್ಲ 60.
60. Yes, 2026 da.
sir.
Yes, we'll have it on second. This is
ಫರ್ದರ್ ಕ್ರಾಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ ಇರೋದು.
ಡೈರೆಕ್ಷನ್ ಮ್ಯಾಟರ್
Alla again, what is that you want, Mr. Next week?
ಶಾರ್ಟ್ ಕ್ವಶನ್
Entry order ನಿಮ್ who is the plaintiff? ನೀವೇ plaintiff. ಅದಕ್ಕೆ ಅವ್ರು ಎಂಟ್ರಿ ಮಾಡರ್ ಇದ್ರೆ ಅವ್ರದೇ ಸೂಟ್ ಡಿಲೇ ಆಗ್ತಾ ಇದೆ. Yes, when do you want? Next week? Yes, at the request of respondent. Leave this matter on 16th, Mr.
My lord, serial number 48, your lordship can grant me 1 week time, your lordship.
Interim order granted earlier is extended.
48, your lordship.
Yes, 48.
Next week, your lordship.
48 at the request. 48. 48. Is there any interim order?
Yes, your interim order is in.
You have not filed any vacating. You file any vacating, then you will give a priority. We'll have it on 16th.
Very well, madam.
Yes.
Interim order. Interim order may extend it.
16th at the request of petitioner. Interim order granted earlier is extended till next date of it. Yes, 52. Avoid no non-compliance.
ಪ್ರಿಯಾಂಬಲ್ ಲಾಸ್ಟ್ ಅಕೇಶನ್ಸ್ ಅವ್ರು ಓವರಲ್ ಆಗಿ ಹೇಳಿದ್ರು ಅದು ಓವರ್ರೂಲ್ ಆಗಿಲ್ಲ. ಪ್ರಿಯಾಂಬಲ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ಸಪೋಸ್ ಇಫ್ ನೆಸೆಸಿಟಿ ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ದ
Yes. Waiting service of notice. Interim order granted earlier is extended till next date. 117. Yes, Mr. At the request of counsel for the petitioner, leave this matter next week. I have informed other side. Yes, interim order granted earlier is extended till next date. 65.
You have served the counsel in the trial court, my lord, stated that there will be
serial number 65. Want to file wakalat behalf of respondent number 8.
How many respondents are there? 16 ಜನ ಇದ್ದಾರೆ. ನೀವೇ ಹಾಕ್ತೀರಾ ಎಲ್ಲರಿಗೂ? ಅದಾಯ್ತು, ಈಗ ನೀವ್ ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀರಾ ಹೇಳಪ್ಪ? Respondent number 8. So and so has undertake to appear for respondent number 8. You have to pay that PF today itself, Mr. ಅವ್ರು ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ ಈಗ? You have to comply office objection and PF today itself, otherwise if interim order will not be extended. No, that interim order granted earlier is extended subject to condition. Petitioner has to comply office objection. What is that office objection? ಅಷ್ಟೇನಾ, ಬೇರೆ ಏನಿಲ್ಲ, ಬೇರೆ ಏನಿಲ್ಲ.
It is not.
Wait. As to directed to pay, subject to pay that PF during the course of the day.
By tomorrow, madam.
Yes, you paid today itself, Mr. Yes, Mr.
Serial number.
Your name, show that so and so name as in respondent number 8. Yes.
Serial number 58, my lords.
Yes,
I
interim order
appeal the
extended till
petition.
next date of it.
Next week sometime. It's 58, serial number 58.
58, I'm appearing for the respondent.
Next
Vacating
week.
application also. The suit is in the
Vacating application and only a small interim order has been passed, not in the connected matter.
Where is your vacating application?
I have served in another
ಇಲ್ಲ, ನಮಗ್ ಕೊಟ್ಟಿಲ್ಲ.
similar order
he has served copy.
What you
also.
want, mister?
Next week, my lord, session. Next week
Learned
or 2
counsel
weeks.
For the respondent submitted that as
2
filed
weeks.
an IFR vacating.
Please.
Office to verify and put up the same. Please this matter on
2 weeks.
17th. Yes,
17.
next week 17th.
7. Interim order may kindly be
No,
extended.
that office objection you have not complied.
Not
No,
complied by two
none the
times
office
it has been-
objections. I'll comply it. If
No,
it is-
interim order granted earlier is extended subject to condition. The petitioner has to comply office objection. If it's not complied, then we'll dismiss.
Much obliged.
65 ಏನಾಯ್ತು? ನೀವು ವಕಾಲತ್ ಹಾಕಿರ? Yes, yes. ಬಾಕಿದವರಿಗೆಲ್ಲ ಹಾಕಿ ಅಲ್ಲಿ ಮುಗ್ದೋಗುತ್ತೆ. If you undertaken, then I will say that you will file an wakalat instead of paying the PF. ಎಲ್ಲರಿಗೂ ಹಾಕ್ತೀರಾ? Yes, so and so is undertake to ಅದು to pay PF ಬೇಡ. Undertake to appear for respondent number so and so. Copy ಕೊಡಿ ಅವ್ರಿಗೆ, copy ಕೊಡಿ. Yes. Read this matter on 25th. Yes. Interim order extended till next date of hearing. Yes. Yes.
Sir.
ಈಗೇನು ಆಗಲ್ಲ ಸರ್, ಇಷ್ಟೆಲ್ಲ ತೆಗೆಷ್ಟರಲ್ಲಿ ಲೇಟ್ ಅಲ್ಲಲ್ಲ.
Sir. Number 42. Number 42. First 230 list ತಗೊಳ್ಳಿ.
Sorry for the interruption. Asil, ಆ ಕಡೆನೇ ಕೇಳೋಣ.
ಬನ್ನಿ ನೋಡೋಣ ಅಲ್ಲಿ ಏನಾಯ್ತು ಫೈಲ್ ಇದೆಯಾ ನೋಡಿ.
ಚೀಟಿ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ ಮಾಡಕ್ಕಾಗ್ಲಿಲ್ಲ ಅದು ಬಂದ ಆಮೇಲೆ ಬನ್ನಿ ಸರ್ 2:30 ನಾನು ಇಲ್ಲಿ ಎಲ್ಲಿ ಎಲ್ಲ ಮಿಕ್ಸ್ ಆಗ ಎಲ್ಲ ಬಿಟ್ಟು ಇಲ್ಲೂ ಇಷ್ಟೊಂದಿದೆ ಇರೋ ಸರ್ 2:30 ಬನ್ನಿ 2:30 ಬನ್ನಿ 2:30 ಬನ್ನಿ ಸರ್ ಈಗ ಆಗಲ್ಲ ಈಗ ಇನ್ನೂ ತೆಗೆಯೋದು ಜಾಸ್ತಿ ಇದೆ 2:30 ಬನ್ನಿ 2:30 ಯಾವ್ದು ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟು ಯಾವ್ದಂತಪ್ಪ
ಬರೀಬೇಕು ಸರ್ ಅವರು
ಇದ್ಯಾಕೆ ಹಿಂಗಿಟ್ಟ ಅದೆಲ್ಲ ಬರಿಬೇಕು ಸದ್ಯಕ್ಕೆ ಅಷ್ಟು ಕೊಟ್ಟಿರಿ ಈಗ ಅಷ್ಟೇ ಸಿಕ್ಕಿತ್ತು ಇನ್ನೊಂದಿದೆ ಇಲ್ಲಿ ಬೇರೆ ಎಷ್ಟು
ತೆಗ್ದಿಡಿ ಸರ್.
ಆಯ್ತು ಆಮೇಲೆ ಬನ್ನಿ ಸರ್ ಎಲ್ಲಿ ಕಳಿಸ್ತೀನಿ ಹಾ ಕಡ್ಜನ್ ಆಗೋಗಿದೆಯಲ್ಲ 26/3 ಅದು ಸಾಹೇಬ್
ಮತ್ತೆ ಈಗ ಎಲ್ಲಿ ಫೈಲ್ ಇರುತ್ತೆ ರೆಡಿ ರಿಸೀವ್ ಮಾಡ್ಕೊಂಡು ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡು ಈಗ ಕರ್ಕೊಂಡು ಎಷ್ಟು ಕೊಟ್ಟರು ಎಷ್ಟು ಫೈಲ್ ಕೊಟ್ಟು ಕ್ಲೋಸ್ ಆಗಿದ್ದೀನಾ ಅಲ್ಲೇ ಇಟ್ಬಿಡಿ ನನಗೆ 2:30 ಶಂಕರ್ ಮಾಡ್ಬೇಕು ಮುಗಿಸ್ಕೊಂಡು ಫೈಲ್ ಇದೆ ಅಲ್ಲ ನಿಮ್ಮ ಹತ್ರ
Probably we'll say that. There are two things can happen. Take this one and get the registry to show it. Or you might say that you want to go and write that. Application is not. Application, I will show the possibilities. WhatsApp group it, that way it's here. No problem.
ಬಂದಿದೆ ಸರ್ ನಿನ್ನೆ ಪೇಪರ್
ಈ ಬೇಡ್ಕಂತ ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಬರ್ಕೊಳ್ಳೋರಿಗೆ ಹೋಯ್ತು
ಗಿರೀಶ್ ಗಿರೀಶ್ ಡೇಟ್ ಫೈಲ್ ಎಲ್ಲ 230
ಅಲ್ಲಿ RFI ಬೇರೆ ಇದೆ ಅಲ್ಲಿ
ಯಾವುದು ದೂರ ಯೂಶಲಿ ಎಲ್ಲ ರೀಚ್ ಮಾಡಿ ಎದ್ದೇಳೋದು ಮೀಟಿಂಗ್ ಇದೆಯಾ ಏನೋ ಗೊತ್ತಿಲ್ಲ ನೋಡೋಣ ಮೀಟಿಂಗ್ ಏನಾದ್ರು ಇದ್ರೆ ಗೊತ್ತಿಲ್ಲ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಒಂದೇ ಇನ್ನೊಬ್ರು ಕೊಡ್ಲಿಲ್ಲ ಎಷ್ಟಿದೆ Done. Demo. Come on. ಹೇಳ್ಬೇಕು. ತಪ್ಪ ಇದೆ ಚೆಕ್. ಇನ್ನೊಂದು ಬರ್ಬೇಕಲ್ಲ ಸ್ಕೂಟ್ನಿ ಬ್ರಾಂಚಿಂದ. ಪಾರ್ಟಿನ್ ಪರ್ಸನ್ ಬೆಳಿಗ್ಗೆನೆ ಕೊಟ್ಕೊಂಡು ನಾವೇ ಕೊಟ್ಟು ಕಳ್ಸಿದ್ವ ಅಪ್ಪ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ನಾವೇ ಕೊಟ್ಟಿದ್ವಿ. ಗಿರೀಶ್ ಯಾರ ಕೈ ಕೊಟ್ಕೊಂಡು ಈಗ ಆ ತಾತಪ್ಪ ಬಂದ್ಬಿಡ್ತಾನೆ. ಅವನ ಕೈಗಂತೂ ಕೊಡಲ್ಲ ಅವರು. ಯಾಕಂದ್ರೆ ನಾವೇ ಕೊಟ್ಟಿರೋದ್ರಿಂದ ಕೊಟ್ಟು ಕಳಿಸ್ತಾರೆ, ಇಲ್ಲ ಅಂದ್ರೆ ನಾವೇ ಹೋಗ್ಬೋದು. ಹಲೋ ಖಾತಾ 40%, ಖಾತಾ ಕೊಡು ಯಾರು ಕೊಡ್ತಾರೆ?
40% ಬಂದ್ರೆ ಕೊಟ್ಟಿಲ್ಲ. ಗೊತ್ತಾ ಸರ್ ಅದು?
ಹೋಗಿದ್ದೆ ನಾನು, ಆಮೇಲೆ ಕಳಿಸಿ ಸರ್ ಇನ್ನ ಬಂದಿಲ್ಲ ಅವ್ರು ಊಟಕ್ಕೆ. ಕಾಫಿ ಬರೋದು ಆಮೇಲೆ ನಾನು ಹೋಗೋಷ್ಟು ಕ್ಲೋಸ್ ಕಾಫಿ ಆ ಕಡೆ ಹೋದಾಗ ಇಲ್ಲಿ ಲೇಟ್ ಆಗೋಗುತ್ತೆ, ನಾವು ಹೋಗೋಷ್ಟಲ್ಲಿ ನೆನ್ನೆ ಆಯ್ತು, ಇವತ್ತು ಹೋದೆ ಬಂದೇ ಇಲ್ಲ ಸರ್, ಒಟ್ಟು ಕಳಿಸ್ತಿದ್ವಿ. ಮತ್ತೆ ನಿಮ್ಮ ಹುಡುಗರು ಯಾರಾದ್ರೂ ಹೋಗೋದಾದ್ರೆ ಆಗ್ತದೆ, ಇಷ್ಟಿದೆ ಒಂದಷ್ಟು. ಮಾಡಿ ಆಯಪ್ಪ ಉತ್ತರ ತಿಂತೆ. ಅದು ಎವಿ ಬರ್ತದೆ. ಇವತ್ತು 150 5ನೇ ತಾರೀಕಲ್ವಾ, ಡೇಟೇ 68 ಇದೆ. ಡೇಟ್ 68 ಇದೆ, ಡೇಟ್ 68 ಇದೆ, ಮೆಮೋನು 68 ಆಗ್ಬೋದಾ? ಇದು ಟಿಕೆಟಿಂಗ್ ಅವೆಲ್ಲ ಸಾಹೇಬ್ರು ರಜೆಗಳೆಲ್ಲ ಇದೆ ನೋಡ್ಕೊಂಡು ಅಲ್ಲ ಫ್ರೈಡೇಸ್ ಕೊಡ್ಬೇಡಿ. ನಾಳೆ ಅಲ್ಲಿ ಇವಾಗ ಕ್ಲೋಸ್ ಆಯ್ತು, ನೀವು ಶುರು ಮಾಡ್ಕೊಂಬೇಕಾದ್ರೆ ಏಪ್ರಿಲ್ 30th ರಜಾ, 31 ರಜಾ, ನಾಳೆಯಿಂದ ಫಸ್ಟ್ 3ನೇ ದಿನಕ್ಕೆ ಫಸ್ಟ್ ಆಗ್ತದೆ. ಈ ಗ್ಯಾಪಲ್ಲಿ ಯಾವುದು ಕೊಟ್ಟಿಲ್ಲ, 9 ವೀಕಲ್ಲಿ 20 ವೀಕಲ್ಲಿ ಯಾವುದು ಕೊಟ್ಟಿಲ್ಲ.
Lords, kindly, Lords. Two fresh matters, my Lords. I'm seeking to move for tomorrow, my Lords. My secondary evidence application has been rejected. Please.
Lords, kindly.
Yes.
At serial number 34.
Yes.
Lord, I'm told that Lord, somebody has mentioned at 1:30 there is some urgency, my Lord. The respondent is seriously ill.
No, now that they have complied that office objection.
Comply ಮಾಡಿ.
I posted for hearing. Which date? 27th. There is no other, see, 20th is also holiday. 13th is there, we said some problem on 13th. We said 27th. 27th you will hear on that day. What is that? Yes, it's an RF. Yes.
Serial number 41 as well, my lords, without mentioning us, my lords. The opposite side has taken time. Matter is now posted for 26. There is some urgency in the matter, my lords. 41, my lords. I appear for the petitioner.
Yes.
Matter has now been adjourned to 26th of this month, my lords. There is some urgency. Kindly be taken up on Friday, my lords.
Interim order is there.
Interim order is there, my lords. But what has happened is now I have filed a suit for eviction. Now they have filed a counterclaim, and on the counterclaim they have filed an amendment application which has been allowed. The order to stay the impugned order is done, my lords, but the trial judge is not proceeding with the matter because whether the pleadings have to be taken on record or not is pending before the High Court. You get the matter adjudicated there and come, therefore.
Sign the order sheet. We have signed that order sheet.
Can it be taken up on Monday?
26th, sir. 26th, let us see on that day.
That will be too late, my lords, because we've been moving, my lords, every time without informing us.
In your case, you are secured that suit is stayed. In some of the cases, they are going to, pronounce that order itself and degree. That case will take an important.
It's an eviction suit, my lords, without informing us, they have mentioned, my lords.
They said they have no objection to continue.
No, my lords. No, my lords. They didn't inform us, my lords. We have been waiting from morning, my lords, without.
See, on 27th, yes, 27th, yes.
May make a fresh mention tomorrow morning, my lords, with their consent.
If their consent, you take memo and.
Please, my lords.
Place it. Let us
Problem.
2:30, yes.
230 matters for orders, serial number 119, Prakash Timanna Hebbar for petitioner, Umesh S.
For elevator respondent. Yes.
Lord, why it is posted 2:30?
Lord, the last date of hearing, it was listed before the coordinate bench. Because of shortage of time, the matter could not be heard.
Yes.
My lord, the order which.
Urgency.
Urgency, my lord, I have undertaken that I will not alienate the 1/4 share of the suit scheduled property. Now, my lord, the plaintiff had filed suit for partition in the year 2014. Application subsequently after lapse of 8 years, they make an application under order 39 rule 1 and 2 in respect of 23.
No, I am asking that is there any urgency in that?
It may be taken up on Monday, my lord, I will be ready because we have filed some documents during the last date of hearing, that is on Friday. Lord, I will.
Have it on Tuesday in regular list.
My lord,
interim order is there anyhow.
My lord, now, my lord, I have undertaken. Now, in the portion of, my lord, item number 2, that is about 23 guntas. My lord, the caveator is putting up construction, my lord. Construction is complete, my lord. Interior work is going on. The remaining extent of land is available. The total extent is 2 acres 12 guntas. If the plaintiff succeeds, they can
suit for
partition. Suit for partition, my lord.
You are.
And in the year 1962 sale deed, they challenge, my lord.
No.
1962 sale deed.
Chaser or a family member?
Family member.
Family member, my lord, relationship is not in dispute. Now he has set up an alleged will to deprive the daughter, my lord, of the share in the father's property. Lord, therefore, the will is seriously disputed. The honorable trial court has said.
You are putting up a construction.
Construction apartment.
Lord, during the pendency, my lord.
The apartment is concerned, you can construct, but not to alienate.
My lord, they have not made an application to alienate. Their application is seeking not to put up construction. That is the application they made before.
Alienation prasna.
Now, construction is completed. Construction is completed. My lord.
Party interest is created.
My lord, now.
You will alienate a property without disclosing the dispute. Purchaser, after that hard-earned money, they will invest for buying the apartment.
My lord, before the first appellate court, an affidavit was made. My lord, recording the affidavit or contents of the affidavit, my lord, the miscellaneous appeal came to be disposed. Now I have further affidavit is filed before this court.
ನಾನ್ ಮಾರಾಟ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಡಿಮಾಲಿಷ್ ಮಾಡ್ತೀನಿ ಅಂತ.
Stage in the suit, it appears that now it is posted for evidence.
I thought we'll
Defendant
direct-
evidence.
We'll direct the suit may be disposed of. You construct not to alienate that property.
My lord,
That can be.
what the affidavit now I have filed is, I will not alienate 1/4 share of the plaintiff.
We don't know where 1/4
1/4 share. If they want to identify, my lord, there is a vacant land available in that. 2 acres, 12 guntas. Construction is only to an extent of 23 guntas. And also there is another item which is also on the main road. If the plaintiff succeeds, they can say, I will not alienate the other portions of the property is concerned.
No, my lord, now
They can claim that property, my lord.
You have constructed the full.
Not full, my lord, only 23 guntas. The total extent is 2 acres, 12 guntas. Out of which in 23 guntas, I am putting up construction. Therefore, if they succeed, vacant land is available, my lord. I will not plead equity. To that extent, I have filed an affidavit.
Now, what is the share he is claiming?
1/4.
1/4.
1/4, they would be entitled for 23 guntas.
No, which is that fertile land or which is that valuable land which
My
you
lord,
are taking?
Valuable land, my lord, in item number 1,
Disputes cannot be.
my lord, more valuable land is there on the opposite side.
that we don't
Which
know.
is
my
also,
lord, it's
my lord,
not
which is
correct.
also measuring about 12 guntas.
Yes.
They can take, my lord, proportionate, if that is their case, let them say which is the valuable land, the portion which is falling vacant. I
All
will
these-
undertake that we will not alienate.
all
To that
these
extent,
things
I
are
have made an
cannot-
affidavit. Let them take instructions from the party, my lord, make submission, and it will
No,
be listed.
how many is there for constructing that this thing?
Please, my lord.
48 flats. we are
48
constructing.
flats, my lord.
All these respondents are you are representing.
No, my lord, one respondent number
No,
2.
what about that other respondent?
Other respondents, my lord, sailing with, my lord, this respondent.
No, they have no share in that.
They are not
They
claiming
also
anything.
have-
They are
have a
supporting, they are supporting, my lord,
How much share you have in this?
1/4 share. my lord,
1/4 share.
1/4 share.
How many apartments you have constructed?
my lord, 48 apartments, out of which, my lord, my share is 39%.
No,
39,
48
yeah.
No, you, whatever the share you take, 48 apartments, 1/4 will comes to how much?
12 flats.
You
My
keep
lord.
it that 12
My lord,
flats for them.
Then let
my
him,
lord, what,
alienate.
even, my lord, what my share would
Want
be.
to sell everything.
My lord, my share is, my lord, my share would
ಅಲ್ಲ
be
ಆ ತರ
18
ಅವ್ರು ಅಫಿಡವಿಟ್
ಅಲ್ಲ,
ಹಾಕಿದ್ದಾರೆ.
ನನ್ನ ಶೇರ್ ಇರೋದು 18 ಫ್ಲಾಟ್ ಮಾತ್ರ ಬರುತ್ತೆ ನನ್ನ ಶೇರ್ಗೆ.
ನಿಮ್ ಶೇರ್ ಏನಾರ ಮಾಡಿ ಅವ್ರ ಶೇರು you say that all are also colluding and supporting you. Your
My lord,
share, his share is for the 12 plots.
My lord, if my lord, they can take claim, my lord, the valuable property, my lord, the entire extent is valuable property. They can identify the
Now,
vacant
you
land.
take that vacant site and give it to that flat to him. Okay, that will be decided.
My lord, vacant site, what I am putting up construction by entering into a joint development agreement.
See,
Now, my lord,
see, it is under dispute. You are allowed to construct. Yes.
they
Now-
did not make any application in time.
Now that you will be allowed to alienate, keep it that at least 10 flats.
My lord, 10 flats ಅಂತಂದ್ರೆ ನನಗೆ ಬರೋದೇ 18. 39% ನನ್ನದಿದೆ ನನ್ನ
Right.
ಶೇರ್ ಅದರಲ್ಲಿ.
Lord, there is
39% ಅಂದ್ರೆ
Instead of staying
My lord.
entire, then you will
my
lose
lord,
that also.
my
Then
lord,
we'll see.
may I make,
No,
my
I
lord,
can't make an FDP here
my lord,
to
may,
deciding that.
my lord, may I make, my lord, ನನಗೆ ಬರೋದು 18 ಫ್ಲಾಟ್.
ಹೋಮ್ವರ್ಕ್
Out
ಹಾಕೊಂಡಿದ್ದಾನೆ.
of my share, I'll reserve, my lord, 1/4 in 18 flats. And 1/4 in other, 1/4 in flats, what I would be entitled, my lord.
Lord,
See,
I am entitled for 18 flats as per the JDA.
what about that 40 flats will goes to whom?
My lord, out of 48, 18 I get, my lord, 30 goes to the developer.
Then if it is a problem, if the developers sold to somebody else.
my lord,
My
may I
lord,
make one
vacant land
submission,
is
my lord?
available.
May I make
There
one
are two
submission, my
portions
lord?
of the
One
vacant
second,
land
Mr.
which is
Kalyan.
available.
1 second. My lord, what happened is the contesting respondent, my lord, despite the interim order granted by the trial court not to put up further construction.
No, that
In,
is false.
why, 1 second. I did not
ಈಗ
disturb him.
ನಿಮ್ಮ ಇದರಲ್ಲಿ 18ರಲ್ಲಿ 8 ಬಿಟ್ಬಿಟ್ಟು
ಅಲ್ಲ,
10
ಎಂಟು ಅಂದ್ರೆ
ಸೇಲ್
ಜಾಸ್ತಿ
ಮಾಡಿ
ಆಗಿದೆ. ಅಲ್ಲ,
8
ಅವ್ರದ್ದು ಏನು
ನಾಳೆ
1/4
ನಿಮಗೆ ಬರ್ಬೋದು.
ಅಲ್ಲ 1/4 ನಾನು ಬಿಡ್ತೀನಿ ಅದರಲ್ಲಿ.
ಇಲ್ಲ.
4.25 ಫ್ಲಾಟ್ ಇರುತ್ತೆ.
Sir, if you are, you know,
5
indicting
flat,
that,
my lord. I'll not, 5 flats.
sir, indicting that builder also, tomorrow it's more complication.
My lord, I'll reserve,
Lord,
my lord,
ಏನಂದ್ರೆ
5 flats.
during the pendency, my lord, he has entered into
My lord,
JDA.
my lord,
In
I'll
violation
reserve,
of the interim
my lord,
order.
I'll
He is
reserve
not
5
entitled
flats.
for equity.
5 flats, my lord, to that effect, I'll file affidavit.
We are not saying that it is for a plaintiff. You keep it vague. If it is succeeded, it will goes to you
But
also.
I'll reserve 5 flats and also the land
No,
is
my lord.
available, my lord.
He is not
Vacant land is
entitled.
available.
you are getting 10 flats. If it is sold, 10 flats is enough. 8 will be there for your this thing. It will helpful for tomorrow. It will fetch us more money.
No, during the pendency, my lord,
ಅಲ್ಲ
he has
ಎಂಟಂದ್ರೆ ಅವ್ರಿಗೆ ಅಷ್ಟು
constructed.
ಶೇರು ಬರಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರದ್ದು ಅಷ್ಟು ಶೇರ್ ಇಲ್ಲ 5 ಫ್ಲಾಟ್ಸ್ ಆಗಿದೆ
No,
18 ಅಂತ ನೀವೇ ಹೇಳಿದ್ರಲ್ಲ.
ಅಲ್ಲ 18 ನನಗೆ ಬರುತ್ತೆ
18
18 ಅಲ್ಲಿ ಅವರು ಅಷ್ಟು ಶೇರ್ ಬರಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ
Blood.
ಅವ್ರಿಗೆ
ಬರಲ್ಲ
keep it there
even
for
if
the
it
interest.
is succeed Milord, Milord, ma'am, 6 flats I'll file affidavit.
No, my lord, no, my lord.
8 flats, nothing will happen. Yes. You file an affidavit to that 8.
Milord, I'll to the extent of 6 flats I'll make it.
No, keeping
No, my
8
lord.
flats, in all other flats, you can do whatever you want. Yes.
Milord, I'll take instructions, Milord, it may be called.
Yes. When do you want to start?
Milord, on 10th it may be called. I'll be
Yes,
after.
leave this matter on 10th.
Please.
Yes.
Much.
Undertaking, my lord, will
Undertaking,
continue. my lord.
ಅವ್ರು ಹಾಕಿದ್ರೆ ಮಾತ್ರ ಇಲ್ಲ
Allala, he has already undertaken.
Yes,
That is an
undertaken
interim
till
order, not to alienate.
till next day.
Great.
Milord, in the 230 days.
230 only if it is a settlement, otherwise it will go to regular list.
Much.
Yes.
This matter, my lord, the other side has stood its promise. Or vacant delivery, ಇದು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. They are clearing the debris, my lord. I have no problem. I can even do that myself and my lord, I can give it to them at my cost. ಸುಮ್ನೆ ಮತ್ತೆ ಇಲ್ಲಿ ಇರೋದು ಬೇಡ ಯಾಕಂದ್ರೆ there was they have given an undertaking to the Honorable Supreme Court that they will vacate the premises. Lordships may see my lords has handed over in the last date. My lords, the structure what was there, my lords, on the social property, my lords, is demolished.
Yes.
We are only removing, my lords, the remaining structure. ಅಲ್ಲಿ ಮತ್ತೆ ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲಿ ಪೊಸಿಷನ್ ಇಟ್ಕೊಂಡು ಅಲ್ಲಿ ಕಂಪೌಂಡ್ ಬಿದ್ದಿದೆ ಕೆಳಗಡೆ ಇದೆಲ್ಲ ಏನಾಗುತ್ತೆ ಒನ್ಸ್ once the Honorable Supreme Court says you should deliver vacant possession, you cannot then again come and say ಅದನ್ನ ತಗೊಂಡು ಹೋಗ್ಬೇಕಿತ್ತು ಇದು ತಗೊಂಡು ಹೋಗ್ಬೇಕಿತ್ತು. Why, my lord, this complication is what I am asking myself.
I thought now will not dispose of. When
Yes.
will you take it up then?
Yes, kindly take it 2 days hence, my lord. Let him clear it because there
Time you want.
my lords, so lordship may kindly call it on Monday, my lords. By then, my lords will remove fully, my lords.
Yes.
Yes,
This matter on Tuesday.
very well. Grateful. Obliged. 2:30.
Yes, 2:30. Yes.
Obliged.
Serial number 121, Rajimel Narsimha for petitioner.
I am for the respondent.
From yesterday, man.
Yes.
Matter from this. On stay.
Yes.
Also, before my learned senior begins, there is just a memo of documents that I wish to place on record.
Yes.
I have served it on. Yes.
This is a challenge on a stay application. They can't argue a completely new case at this point of time. What is on record in the trial court is one thing. What is before the trial court is one thing. To argue
If it
some.
is there in the trial court to assist here, if we give
That's fair.
additional records, it cannot be taken.
This is only, your lordship, the copy of the statement of claim and the statement of defense in the arbitration proceeding. There is nothing further that I am placing on record.
No, is it a part of the trial court records?
It is
all
part
this
of the
new
main
arguments
section.
entirely, completely new arguments.
Lordship, it is part of the section 34 proceeding. I will demonstrate why it is.
It's not part of the record, madam.
Yes, yes, yes. We'll see if it is necessary. Otherwise, we'll.
Yes.
Yes.
Yes. It is only an 227 petition. We can't see that more than what is. Yes. Now that which is that impugn order? Where is your application for stay? You have filed under which provision?
But my application for stay, madam, may kindly see under section. Madam, may kindly look at page number. Sorry, madam. Kindly see page 166, madam.
Yes.
That's my first stay.
It is 34 and 36.
Under 36, 2 and 3.
But trial court has referred in all 34.
34 is the main challenge.
Yes, but reference application
So
is under 34.
the application before the trial court, your lordship, that erroneously mentioned 34. That is why that error has come.
Making a wrong provision, it will not defeat unless sources are there. 36 is that
is the power of
for yes, stay. Yes. Now that what is that impugn order?
My lord, it's in the memo, my lord, which was filed.
Yes.
My lord, we took it back, filed it in the registry, and I think it's again we've got it listed.
Yes. 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 What is that order passed by the trial court? What are the reasons for rejecting?
Yes. May I take, my lords?
Yes.
If I may request, my lord, to kindly look at the order, my lord, kindly go to page 4 of the order, my lord.
Yes, there are two issues as framed.
Two issues are framed.
Yes.
And now, my lord, I'll kindly permit me to take, my lord, through to paragraph number 11.
Yes.
Where, my lord, the respondents would contend, no, this is their contention.
Yes.
So I have filed, my lord, as I pointed out yesterday, there's an arbitral award.
Yes.
I am challenging the arbitral award. They have also challenged the arbitral award.
Yes.
And my lord, in my challenge, my lord, this is their objection to my application for stay. And the further
Suppose if that principal district judge held that suit filed in that regular court is not maintainable.
Yes.
What is the effect of that interim order?
Effect of the
interim order passed by that regular court?
Yes.
No, it will be transferred to as it is, or it has to be written the plain to present before that, because transfer is only when the act came into the force.
Yes.
After that, there is no transfer. Now
Yes.
that if it is.
But my lord, both courts are within the jurisdiction of the principal judge. And therefore, my lord, under section 24,
No,
he has.
here I am asking that whether that has to be decided first or this has to be decided, because tomorrow, if the court.
My lord, can I point to one judgment of the Supreme Court on the subject, my lord? Since my lord has asked me this question.
Yes.
Can I request my lord to kindly look at the judgment of the Honorable Supreme Court in my lord, in Asma Latif's case?
See, after exercising all these things.
Yes.
Tomorrow, principal district judge says his suit is not maintainable.
Yes.
Even that interim order is granted, will go. Otherwise, should they not decide that first?
In my respectful submission, the interim order.
In the first round.
Yes.
Concession given by both advocates, I think it is not correct. You should have been said that the trial court has to decide for jurisdiction. Then it will goes to that other point.
That was the objection that was raised by us before the trial court. It was the petitioner who insisted on the stay order being heard first.
In fact, my lord, kindly see what Supreme Court says on the subject.
I'm only answering this.
Yes, yes.
No, on the question of what is the law with regard to this?
Yes.
If I may request my lord to kindly look at paragraph 1. I'm sorry, my lord, again, I have the same problem because I have a different citation. My lord, may kindly look at paragraph. My lord, kindly see the contention that was raised, para 2, my lord.
Yes.
A revision was carried by the appellant from the order dated so and so before the revisional court, which while its order dated so and so dismissed the objection filed by the respondent, directed the executing court to proceed with the execution of the decree while treating such objection as not maintainable. So it is arising from one of these. Now, if my lord may kindly look at in paragraph 3, they say how the High Court quashed the revision order.
Yes.
Kindly look at paragraph 11.
Yes.
What the contention was. If my lord looks at the paragraph 11, I'm sorry, it's not paragraph 11, my lord.
What is that starting line?
It starts with Mr. Kazmi. I'm sorry, my lord. I'm so sorry, my lord. This is.
11 is heard the learned counsel for the parties.
This file is written.
No, you have that, is it a?
SEC.
SEC is there, reported.
Reported.
Which is that SEC?
My lord, the SEC, my lord, is 2024 4 SEC 696. Kindly look at paragraph.
I got that SEC, yes.
Not got the SEC, my lord.
Yes, yes, yes.
I'm so grateful.
Yes.
Now, can I request now to kindly look at paragraph 11, my lord?
You have an SEC, Mr.
No, your lord. I have a.
My lord, we refer to the same judgment in the court below. I think my learned friend is familiar with this judgment.
That is all right. I will trace it, your lord.
Yes, yes.
I'm grateful.
And I'll just tell you the paragraphs.
Yes.
No, Kazmi filed with the mistake.
Now you refer to that paragraph.
My lord, kindly see 11.
Yes.
Kazmi has filed his written statement in the suit on 5/12/1990, wherein he inter alia contended that the suit was barred under section 331 of the UPZA and LR Act and not maintainable before the civil court, since the suit property was Bhumidar land. So contention was the court did not have jurisdiction.
Yes.
Then can I request now to kindly look at paragraph 23 now.
Yes.
My lord, in paragraph 23, my lord will see the sole question of law. The sole question of law which arises for a decision in this appeal is whether the order dated 5/8/1991 suffers from a jurisdictional error so grave that the decree drawn up subsequently is incapable of execution by the executing court and an objection that it is inexecutable was available to be raised under section 47, etc. So, my lord, what is the effect of courts passing orders without jurisdiction was the subject matter of this litigation. Now, if I may request now to kindly look at paragraph 28. No, I'll skip that. Can I request now to kindly go directly to paragraph number 42, my lord. But in fact, I'll skip these, my lord. If my lord may kindly directly go to paragraph 49 and 50.
Yes.
On the scope of interim reliefs.
Yes.
But I'll read para 49 first. What follows from a conspectus of all the para 49?
Yes.
What follows from a conspectus of all the aforesaid decisions is that the jurisdiction is the entitlement of the civil court to embark upon an inquiry as to whether the cause has been brought before it by the plaintiff in a manner prescribed by law, and also whether a good case for grant of relief claimed has been set up by him. As and when such entitlement is established, any subsequent error till the delivery of judgment could be regarded as an error within the jurisdiction. The inquiry as to whether the civil court is entitled to entertain and try a suit has to be made by it keeping in mind the provisions of section 9 CPC and the relevant enactments which according to the objector bars a suit. Needless to observe that the question of jurisdiction has to be determined at the commencement and not at the conclusion of the inquiry. So, my lord, court is saying that whether a court has jurisdiction or not is a question that the court will have to decide. So, to decide that question, whatever steps that may be required that is taken are all errors within jurisdiction. It is not error without, it's not an order passed without jurisdiction. Therefore, to that extent, the court has jurisdiction. Then kindly see 50. Although not directly arising in the present case, we also wish to observe that the question of jurisdiction would assume some importance even at the stage of court considering the question of grant of interim relief.
Yes.
Where interim relief is claimed in a suit before a civil court, and the party to be affected by the grant of such relief or any other party to the suit raises a point of maintainability thereof, or that it is barred by law, and also contends on the basis that the interim relief should not be granted, grant of relief in whatever form, if at all, ought to be preceded by the formation and recording of at least a prima facie satisfaction that the suit is maintainable or that it is not barred by law. Such a satisfaction resting on the appreciation of the averments in the plaint, the application for interim relief, and the written objections thereto, as well as the relevant law that is cited in support of the objection, would be a part of the court's reasoning of a prima facie case, having been set up for interim relief, and that the balance of convenience is in favor of grant and non-grant, which would cause irreparable harm and prejudice. It would be inappropriate for a court to abstain from recording a prima facie satisfaction on the question of maintainability. Yet, to proceed to grant protection pro tem on the assumption that the question of maintainability has to be decided as a preliminary issue under section 14, order 14, rule 2. That would amount to an improper exercise of power. If the court is of the opinion at the stage of hearing the application for interim relief that the suit is barred by law or is not maintainable, it cannot dismiss it without framing a preliminary issue after written statement is filed, but can most certainly assign such opinion for refusing interim relief. However, if an extraordinary situation arises where it could take time to decide the point of maintainability of the suit and non-grant of protection pro tem pending such decision could lead to irreversible consequences, the court may proceed to make an appropriate order in the manner indicated above, justifying the course of action it adopts. In other words, such an order may be passed, if at all required, to avoid irreparable harm and
that is
injury.
true. In the interim, they can pass.
Correct. So therefore, my lord,
tomorrow, if said that it has to be returned to that or transfer,
yes,
then again that commercial court has to reconsider for interim order, or what is that?
Lordship, may I answer? Your Lordship. In my respectful submission, Your Lordship, and I will cite authorities also. This issue, insofar as the order of the Honorable City Civil Court is concerned, is now closed and is before this Honorable Court, of course, subject to orders of this Honorable Court. Insofar as the City Civil Court is concerned, that matter stands concluded. The reason for that, Your Lordship, is simply that it was the petitioner itself who, in the face of a jurisdictional objection, first approached this Honorable Court, sought directions.
I will not go to that point.
Yes,
Because you
yes.
both has agreed.
Yes.
That let that be under 24 application can be decided. IA may be decided. Now IA has been decided. Now I'll only stick to that whether IA.
Yes.
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 Now, my lord, can I
Because,
take my lord to the
this court itself has passed an order.
Yes.
Directing to.
Dispose of the IA.
Yes.
Absolutely.
Now we'll consider that.
the order, interim order?
Yes.
So, my lord, may kindly look at paragraph 11, my lord.
Page.
Page number 5, the last line on page number 5 of the order.
Furnished separate. Yes. Yes. Para 11.
Para 11. The respondent would contend that the subject matter of section 34 of the application is an arbitral award in relation to a commercial dispute of a specified value within the meaning of section 2C7, 2C1 of CCA, which has been filed under section 34 of the Arbitration and Conciliation Act, which took place in Bangalore, and that
all this it has been discussed.
I'm saying what their contention is. Yes.
Because it is 24 is pending, I will not decide that.
Correct.
First point, I think court has not applied their mind, has not decided.
Correct.
Now only in the second issue.
Yes.
Yes.
For the reason which is given for that, we have to.
Yes. So therefore, my lord, will have to go after paragraph 50, my lord. Paragraph 50. In paragraph 50, the court says, in keeping with the principle of judicial discipline, I will not proceed to pass orders.
Yes, that's yes.
But my lord, the recording prior to that records all the contentions, and if my lord reads that, it will give my lord the impression that the court is of the view that it has jurisdiction. That civil court prima facie has jurisdiction. But the court is saying, I am not going to take any call on this because it has to be decided by the principal judge.
Yes.
Now, my lord, what follows in paragraph 51? Now, moving to the application under IA1 filed by the petitioner, page 31, my lord. Page 31.
Para
51.
51.
Para
Yes.
51 on page 31.
Till then it is discussed only this.
Only this issue of jurisdiction.
51. Yes. Yes.
Now, my lord, now moving to the application that's IA1 filed by the petitioner seeking stay of operation of the award dated 10/9/24. IA number 1 is filed by the petitioner under section 34(3).
Yes.
The petitioner has maintained the present petition on the ground that the present petitioner has maintained the present petition under section 34 so and so to set aside the award passed by the Honorable Arbitral Tribunal so far as the findings on issues 1, 2, 5 and 9 on the ground that the initial period of lease expired on 15/1/2018 and the petitioner has not expressed any intention of terminating the lease or putting an end to the relationship between the parties. In terms of clause 4.4 of the clause read with clause 4.43 of the lease deed, the lease granted in favor of the petitioner stood renewed for a further period of 10 years and that there was a follow-up with the respondent for execution and registration of the deed of renewal as per the terms agreed under clause 4.3 and though the respondent expressed that they would renew the lease only if they agreed to pay enhanced rents over and above the rent agreed in the agreement for which the petitioner had objected on the ground of unreasonable claim. Therefore, the respondent is said to have threatened to forcefully evict the petitioner from the suit property. Therefore, the petitioners approached this court under section 9, where an ex parte ad interim injunction order was passed against the respondents, restraining them from dispossessing the petitioner from the premises subsequently, and came to be dismissed, which in turn was challenged and in MFA number so and so before the High Court of Karnataka, wherein the petitioners were granted an interim injunction from disposition and which continued till the award had been passed. Thereby, now, this was the case when that Himagni judgment was there. They said the arbitrator can't go into the question of lease, etc. Thereby, on the ground that the award has been contrary to fundamental principle of Indian law and also award being subject to challenge by both parties to the arbitration, the petitioner sought for stay of operation of the award under so and so.
Yes.
It is also the case of the petitioner. The petitioners are operating a premium hotel on Schedule B property since 2006, and that over the years, the hotel and its operations have received excellent ratings, feedbacks from customers, and that hotel consists of nearly 115 rooms with 2 banquet halls, swimming pool, events, business center, etc., etc. And that the petitioner has entirely furnished the hotel by incurring exorbitant expenses of 13 crores plus, and that the petitioner is engaged with employees of more than 130 at the hotel for smooth operations. The petitioner has also obtained licenses from authorities like excise from Maharashtra Pollution Control Board, and to operate the hotel in B schedule property. And by virtue of the award, the petitioner has been directed to dismantle the hotel and take out all fittings and fixtures and hand over possession to the respondent. And therefore, the validity of the award dated so and so is challenged by both petitioner and the respondent before different forums, and it would result in serious hardship and loss and prejudice, and therefore on these grounds the petitioner sought for interim stay of operation of the award dated 10/9/24. The respondent filed objections to the same and contended that the petitioner has been ordered to vacate the premises, whereby the petitioner was given 12 months from the date of award to hand over the vacant possession to the respondent, and that in view of the order, the petitioner had no right to remain in the suit property, and that the respondent is the owner in respect of the entire building, which consists of 4th, 5th to 9th floor plus terrace measuring so and so, with units on the
That
ground.
he is not an owner of entire property.
The entire property, Your Lordship.
Then why that floors they have given?
But these are the floors which are
floors
leased to us.
out.
These are the floors, my lord.
Oh, entire property, some portions has been leased to you.
Yes.
Other portions you are continuing that.
I am in possession, Your Lordship.
Other portions are leased to somebody else. I think.
No, that is not what is there. That is also commercial.
It's
Yes,
a
yes.
commercial
It's
building.
commercial.
Yes. It is a
Part
larger.
has been given to that petitioner, part you have given to some other person.
Yes, Your Lordship. Yes.
And with the contingent condition, it was agreed to be renewed for a further period of 10 years, but the extension of renewal did not take place. Therefore, even as per the admission of the petitioner, the lease stood expired and it has not been extended, and the applicant petitioner is a trespasser. Therefore, on these grounds, the respondent has sought for dismissal of the application for stay. Along with the objections, respondent would also raise objections with regard to jurisdiction of this court and also with regard to constitution of the commercial court. Peruse prima facie materials available on record. The respondent has relied upon affidavit of one Amit Jaiswal in so and so. It is admitted that the petitioner, the respondent, has neither renewed the lease assuring the claimant of its terms nor carried out repairs that are critical for the use of the premises. Now, my lord, kindly see, this is going into evidence which has already been considered by the arbitrator. Arbitrator there's an award that has come into existence. Now,
what is this meaning? Respondent has neither
renewed the lease. My lord, in cross-examination, he's asked, has the lease been renewed? He's saying, no, it's not been renewed, which is why I have filed specific performance suit.
Yes. Claimant of the term carried out repairs that are critical for the
use of the premises. Yes. Then in para 9, it's admitted as under, I submit that the handing over and delivery of possession to us by the respondent has no nexus with the monetary demands of the respondent against us, assuming without admitting that they are due. I state that such a claim or its adjudication will not come in the way of respondent receiving possession of the scheduled premises from the claimant. I state the respondent cannot be permitted to take advantage of its own wrong, etc. Relying on the said averments on oath, the respondent has sought for dismissal of the above petition, including IA for stay. Also, having relied upon the verdict of the Honorable Apex Court, relied on by both parties and the respondents, and petitioners have placed documents number 2A, whereby from 7/8/24 to 29/8/24, for nearly 1 year, the petitioners have not made payment of rents to the respondent. And further, the petitioner has produced certain photo printouts, but prima facie no grounds made out by the petitioner to grant an order of stay. And that on perusal of the documents produced by the petitioner himself goes to show that for nearly 1 year, the petitioners have not paid rents to the respondent, and that the dispute between the petitioner and the respondent is with regard to the lease that is said to have been entered into and the tripartite agreement between the petitioner, respondent, and Messrs. Just Home Associates. And further, there is also no ground made out by the petitioner as to why the matter needs to be stayed now. It is also crucial to note that the petitioner is in the process of inserting and servicing AC that is said to have been not functioning in few of the units, but possession is still with the petitioners. Therefore, the question of respondent taking possession of the property, even for the purpose of carrying out repairs, does not arise. Further, the petitioner has admitted on oath on facts that the petitioners have no objection for handing over possession to the respondent. Therefore, the question of respondent interfering with the petitioner to effect repairs, so far as AC is concerned, is prima facie not made out. Therefore, in the light of the above discussion, the petitioner has failed to make out any ground for stay of operation of the order passed by the sole arbitrator. On the other hand, more emphasis of both counsels was on jurisdiction rather than on IA number 1 for stay. Accordingly, I hold the above in the negative. So, Manal, kindly see.
What is the reason given? Only that petitioner has admitted on oath that the petitioner has no objection to handing over the possession to the respondent. What is this admission?
My lord, I tell my lord what happened.
Yes.
During the arbitration proceedings, my lord, in between, my lord, when the learned arbitrator COVID had come and it had hit, and at that point of time, my lord, there were discussions between us on settlement. So, my lord, we said, okay, we will return the premises to you. You please take it over. They did not agree. My lord, if I make an offer,
this is before arbitration.
Yes,
No,
it was during the arbitration. It was during the arbitration towards settlement.
Arbitral award.
Before the arbitral award. So now what the court is looking, now kindly see, for granting any interim relief, my lord.
We'll see that what is that section 36 is.
Yes.
Yes.
Where the time,
Yes.
where the time for making an application to set aside arbitral award in section 34 has expired, then subject to the provisions of subsection 2, the award shall be enforced in accordance with the provisions of the Code of Civil Procedure in such manner as if it were a decree of the court.
Yes.
Where an application to set aside award has been filed in court under section 34, and the filing of an application shall not by itself render the award unenforceable unless the court grants an order of stay for the operation of the arbitral award in accordance with the provisions of subsection 3 on a separate application made for that purpose.
Yes.
Upon filing of an application under subsection 2 for stay of the operation of the arbitral award, the court may, subject to such condition as it may deem fit, grant stay of the operation of such award for reasons to be recorded in writing,
Yes.
provided that the court shall, while considering an application for grant of stay in the case of an arbitral award for payment of money, have due regard to the provisions of the provisions for grant of stay of money decree under the provisions of the Code of Civil Procedure. Then provided further that where the court is satisfied that prima facie case is made out, that the arbitration agreement or contract which is the basis of the award or the making of the award was indeed or affected by fraud or corruption, it shall stay the award unconditionally pending disposal of challenge under section 34. That is where without deposit, where it can. Then explanation for the removal of doubts, it's hereby clarified that the above provisions.
To stay of that operation, the award court may subject to the condition as may be deemed fit, grants the operation of such award, reason to be recorded in writing.
Yes.
If it is granting. Even for rejection also, they have to give a reason.
Reason.
And
my lord,
reason which has been given here.
And my lord, kindly see, for grant of any interim relief, the trinity of principles have to be followed. The court has to first ascertain and record a finding on prima facie case, balance of convenience, and irreparable loss. None of these things are done.
CPC.
And my lord, the court has, the question is prima facie case, qua the section 34 challenge. Whether, my lord, there's prima facie material to show that my section 34 challenge is prima facie case.
Order 23.
Yes, order. Whether there was any.
Yes.
Now, I think my learned friend has also filed his challenge, his section 34 petition. In fact, my lord, kindly even look at his section 34 petition, whether this ground that the court is referring to is there in his petition also.
No, see, now I am only examining that application.
Yes.
Whether court has applied their mind and passed an order.
Passed an order.
Yes. That's
Yes.
what we have to see. What is that order 23? Now that consideration of the interim order, there is prima facie.
39, 1 and 2, my lords.
39?
1 and 2. Also is not referred to.
There are two reasons.
What is my
for that.
grounds under 34 is also not referred to.
If your lordship will only have this memo, which was placed on record by the petitioner during yesterday's hearing. Now,
Where is that? Today you have given that.
no, this is, my learned senior has placed this on record.
Yesterday we filed to show that we paid rents. The
No,
court
that
says we didn't pay rent. I have
You are
before
paying that rent regularly.
regularly.
I will
Even
just-
as of this month, the rent has been paid.
It has not been paid, your lordship. I will highlight what the issue is. If along with this memo, your lordship, if I may only invite your lordship's attention to the award itself, which is at page 98 of the writ petition.
No, you are relying on that award or?
They both have to be looked at together, Your Lordship.
Yes,
Now,
award.
yes, Your Lordship.
Because each is in different parts. I have to see that award is in one.
Is in a separate compilation.
Yes, yes.
The only reason that will
Yes.
put
Yes.
perspicuity, Your Lordship.
Yes.
If Your Lordship has only page 98, which is the dispositive part of the award.
Yes. 98.
Paragraph F, Your Lordship, at page 98.
Yes.
Says, all the counterclaims of the respondent except counterclaim 2 are rejected. I will pause here.
Yes.
Counterclaim 2, Your Lordship, was my claim for recovery of possession. So this claim has been decreed in full.
Yes.
The claimant shall quit and deliver vacant possession of the subject property to the respondent in 12 months from the date of the award. This date, Your Lordship, expires on 10/9/25.
Yes.
Now, the claimant, it goes on to say, Your Lordship, shall continue to pay the agreed rents
Yes.
of rupees 43.71 per square foot and parking charges during the use and occupation of the property as per Exhibit P1.
Yes.
Now, in view of this finding, Your Lordship, or this direction, I will only invite Your Lordship's attention to this memo which was placed on record. The first submission, Your Lordship, is the petitioner was expressly directed to vacate.
Yesterday,
This was filed
It
yesterday.
was filed yesterday. It's also filed before the court below. I'm not producing anything new. Only thing is, my lord, we have updated it to up to this month. There's a memo filed to show payment of rents.
No, along with that order of the trial court, you have filed.
Yes, yes, my lord.
Yes.
It is separate memo, my lord. It was separate memo.
ಇದರಲ್ಲಿ ಬರೀ one order ಮಾತ್ರ produce ಮಾಡಿ.
My lord, can I pass it on, my lord?
Yes, yes. Let us see. Yes.
If Your Lordship has the second column,
Yes.
Your Lordship will see that the rent for the month of September 2024,
Yes.
which was payable in that corresponding month, Your Lordship,
Yes.
was paid in the month of August 2025. Right from September
Yes.
up to August 2025, Your Lordship,
Yes.
they did not pay a single rupee worth of rent.
They are not paid.
They have not paid. Your Lordship, this is the petitioner's own memo,
Yes.
which categorically highlights that from September 2024 to August 2025,
Yes.
all of the rent was paid on one date. That is 29/8/2025,
Yes.
just prior to the expiry of the 12-month period, Your Lordship. So, my first submission, Your
Subsequently,
Lordship,
they have paid. Not that regularly they are paying.
they have not
Lump
paid
sum
yet.
once. As on today, they have paid.
No, Your Lordship. Since there are certain other amounts that have been specified now.
Yes.
On and from October 2025, Your Lordship.
Yes.
This fact has not been made part of this sheet. These rents have been paid and they have been reversed by me.
Yes.
I have not held a single rupee from the petitioner on and from September 2025.
After that, 10,
Yes.
12 months over.
No, no. Reverse means
The
they have
reason-
reversed it.
That's what-
They have returned the money that we have
We
paid.
have returned the money. That is what I'm saying.
That's what he said.
Yes. Now, there is a
I
reason.
want to make a commitment that I have received, therefore I have continued you. That is
Yes,
what
Your
that
Lordship,
is.
because that is going to be the argument.
Yes.
Now, the reason and the difficulty, Your Lordship, is this. If Your Lordship will recollect, a question came from my
Trans-
lords, was specifically raised yesterday as to what would be the effect of this award being quashed.
No,
Now-
that is now that
Yes,
it is only limited.
yes,
Order passed on that IA.
yes,
It has been passed in terms of the law or not? That is what that I have to see.
yes, Your
I will
Lordship.
not go into the jurisdiction because it is pending before the different courts.
Yes, yes,
Now that this court is also earlier
Yes.
has directed that irrespective of that, IA has to be decided.
has to be
Now
decided.
we will come to that IA,
Yes,
whether trial court has applied their mind and passed an order.
Yes, Your
That
Lordship.
is what that we have to see.
yes. So if Your Lordship only has the order again,
Yes.
the relevant portion which was read out by my learned senior.
Yes,
Insofar as the impugned order is concerned, Your Lordship,
yes,
a categorical finding has been rendered that no rents have been paid for almost 1 year. I will only invite Your Lordship's attention to paragraph 58 of the order,
Yes.
which is at page 36.
36, yes,
Yes. So I will only read that again, Your Lordship.
yes,
Also, having relied on the verdict of the Honorable Apex Court, relied on by both parties.
58.
Yes, Your Lordship.
Para 58.
Para 58, yes.
Relying on the said government and work on the
Yes, and thereafter, Your Lordship,
Yes,
the
yes.
second sentence.
Yes.
Also having relied upon the verdict of the Honorable Apex Court, relied on by both the petitioner and the respondent hearing. The petitioners have placed document 2A. This is the very document 2A which was before the Honorable Court, Your Lordship. Whereby from 7/8/24 to 29/8/25, for nearly 1 year, the petitioners have not paid any payment of rents to the respondent.
No, this has
No.
been done after this order.
No, no, no.
No, Your Lordship. This specific memo was also before the Honorable Trial Court. This has been considered by the trial court.
No, trial court has not said this has not been paid regularly. Lump sum it has been paid. The meaning it shows that he has not paid at all.
No, it says, Your Lordship, for nearly 1 year, they have not paid rents and only chose to pay on 29th August. That is the import.
That reason is not there.
Yes.
If you read
Yes.
plainly,
Yes.
it shows that he has not
Yes.
paid rent at all. That is what the impression of this court also at the beginning.
No, that
Subsequently has paid.
yes, they have paid, Your Lordship.
Yes, that has
And
not
this has been placed on record. This was argued before the trial court.
Yes.
And this fact has been duly considered.
Yes.
Now, Your Lordship, in my respectful submission, the issue insofar as whether or not this award can be stayed in the first place, Your Lordship, and these, in fact, Your Lordship, written submissions have been tendered by both parties. I have categorically placed these written submissions on record along with my reply as well. If Your Lordship will only bear with me for a moment, why this stay application could not lie in the first place? That is the question, Your Lordship.
No, that has to be answered by the trial
Yes,
court,
and
is it not?
in my submission, Your Lordship, these issues have been considered by the trial court, and it is only and only after that, because Your Lordship, the application itself in the form in which it was,
Acted in that order, that's what that.
yes, in the order, Your Lordship,
Not said anything.
yes,
That is what that, see, this is not that we are under 226, we are passing an order.
Yes.
Saying that there is no ground dismissed and all.
yes,
To consideration of IA,
yes,
they have to give a reason. Prima facie case is there or not.
yes,
Whether it can be, because, see, suppose if court given a reason saying that this is not a case for granting,
yes,
in the instant to show that he will not be in the position to succeed.
yes,
That should be the finding. Otherwise, tomorrow if it is succeed,
yes.
if it is vacated, consequence is nothing.
I will demonstrate to Your Lordship why the trial court,
No,
beyond a
no,
point,
that
yes,
doesn't mean that he is entitled for stay.
yes,
But court has to give a reason to say
has
that.
to apply, yes, certainly, Your
These are all the reasons. It is prima facie, it is not possible to succeed. Therefore, he is not entitled for the
Yes.
interim order. That is not forthcoming.
If
After
you're,
37-page order,
yes,
only one para it says that regarding that application.
yes. If Your Lordship will only bear with me for a moment, I will demonstrate why the trial court could not have, beyond a point,
Yes.
even considered this application.
Yes.
I will only highlight 2 letters, Your Lordship,
Yes.
which have been placed on record by me before the trial court. This was before the trial court, that cannot be disputed.
Yes.
It is also now before this honorable court. If Your Lordship only has page number 166, Your Lordship,
In the
this is my reply, Your Lordship.
your reply.
Yes.
Yes.
All of these documents have been placed before the trial court.
Yes.
The difficulty, Your Lordship, is this lease has expired.
No, that is true.
And
No,
despite that,
lease is expired in 2018.
18,
From
precisely.
that day, one of the other court as granting an interim order is continuing.
Yes.
Even if it is extended, I think 2018, 2028, it will be closed at all.
Yes.
Now that without lease, it has been continued all this year.
Yes.
Court is granting an interim order. Now that ultimately is challenging that arbitration
Yes.
award. To entertain that, court has entertained that, then what is the reason for not granting in that interim order?
Yes, I will.
Not granting order, that's what that.
I will only point that out to Your Lordship.
Yes.
If Your Lordship sees, this is a letter of 20, at page 166, Your Lordship, of my reply.
Yes.
If Your Lordship has this letter,
Yes.
categorically, Your Lordship, this letter was placed on record before the trial court. I have also placed the transmittal email.
Should the not court order has to be reflected all these things?
Your Lordship, these facts have been considered by the trial court, and it is for this reason that the court has arrived at a conclusion that even a prima facie case has not been made out.
No, nothing.
This matter has been heard. Yes.
Trial court has to give a order on application.
Yes.
Seeing that referring so and so documents, then he has to see that reason has to be given. Nothing is there on that. That is what the.
Your Lordship, the two documents that I am highlighting, I will just.
This is what I am doing that.
Yes.
I am hearing an appeal, seeing
Yes.
that records and passing. This is not that appeal.
In
That is what.
the writ jurisdiction of this honorable.
Yes.
Certainly.
Yes.
If your Lordship only has this letter,
Yes.
after, I am reading the second paragraph, your Lordship.
Yes.
After due consideration of the pending issues
Yes.
and to put an amicable quietus to the disputes/litigations, Royal Orchid Hotels is willing to hand over possession of the hotel
Yes.
by 31 March 2026. To give effect to the same, we will cease accepting bookings and reservations for banquets and rooms and commence winding down operations.
Yes.
Now, this particular letter, your Lordship, has been placed on record before the trial.
Did they accept it? I mean, did they these are offers
I
that were
am
made. Did
getting-
they
I am-
accept the settlement offer?
Permitted to conclude.
Yes.
Now, insofar as this letter is concerned, your Lordship will only see that there is one, the fourth
No,
line
this
from the
is
bottom.
before that arbitration award.
No, your Lordship, this is after the award. And if your Lordship has the date of this letter, it says 22 September 2025,
Yes.
which is after 10/9/2025.
Yes.
This letter was before the trial court.
Yes.
Now, thereafter, your Lordship, I will only highlight the fourth line from the bottom in paragraph 2. It says, on hearing from you, we will also initiate the withdrawal and closure of all litigation pending in Bangalore courts.
Yes.
Please note that this offer is made without prejudice to our contentions in all pending litigations inter se, and subject to your acceptance of our offer above. This is a without prejudice offer.
Not accepted, no, it's not fair to read.
The reason for it not being accepted, your Lordship, is that a gun was put to my head. I will vacate the premises. I acknowledge that the lease has expired. However, you withdraw your claims against me insofar as monetary demands are concerned. I will only now once again.
With the condition.
Yes.
Cannot be a ground to see that he is not
I'm only
challenging that.
I'm only
Now that-
demonstrating to your Lordship that these facts have been placed on record
No, that
and have
is
been
true.
considered by the trial.
You-
Yes.
Even on these documents.
Yes.
His original petition under 34 cannot be dismissed. This is what he has offered.
Yes.
That subject to condition if you are accepted that.
Yes.
If you are not accepted, he has all right to challenge.
Yes.
That cannot, no, on relying on this trial court as the.
No, I am not saying that relying on this, the trial court has passed.
Then it's.
I'm only demonstrating to your Lordship everything that was on record.
No, it is true that
Yes.
he was ready to hand it over.
Yes.
Subject to conditions.
Yes.
Because he has to pay some money and all. If it is not agreed, his right to challenge still it is there. Whether it succeed or not is the different.
If your Lordship will only have page 171, your Lordship, there is another letter. This is not even addressed to me.
Yes, 170.
171 of my
Yes,
reply.
same.
Yes, yes. Now, this is a letter, your Lordship, which is addressed to the Commissioner of Police. This
Yes.
is not addressed to me.
Yes.
Your Lordship now only turns to the next page.
Yes.
The first page is 171. Your Lordship has the third paragraph from the bottom. Alternatively, the heading reads alternatively.
In
Page 172, your Lordship.
172.
Yes.
Yes, alternative.
Alternatively, we are ready to hand over the hotel to them by 15/12/25, but both parties must adhere to the directions in the award passed by the arbitral tribunal in full, and the owner should refund all our dues ordered by the learned arbitrator, as both the parties must unconditionally close all litigations before the courts at Bangalore.
Yes.
Now, insofar as the refund of security deposit is concerned, your Lordship, I have made a categorical statement on oath
Yes.
before the commercial court at Bangalore that I am willing to refund the security deposit. The lease has expired. I have no interest in retaining that amount. If your Lordship will only have that one affidavit, which I have placed on record, expressing my willingness and giving them an undertaking that I will refund the deposit, at least initiate demobilization. Your Lordship will appreciate this is a matter which has been pending before the courts since 10/9/25. Now, your Lordship will see the conduct of the petitioner, your Lordship, because even the remedy of a stay of the award is an equitable remedy, your Lordship.
Yes, yes. No,
Now-
see, court could have given all this reason.
Yes.
His conduct and all.
Yes.
These are all the reason.
Yes.
This is his conduct.
Yes.
This is the reason. Nothing is there. That is what we are saying.
Your Lordship,
What you
in
are
my
ordering and
respectful-
broughting my notice.
Yes.
This is the first time I have to be decided.
In my respectful submission, your Lordship, if the order is carefully, insofar as paragraph 58 is perused, your Lordship,
Yes.
that in and of itself
No.
records,
Only one thing you have shown that
yes,
he has not paid the rent.
yes, he has not.
That is also wrong.
No, he has not paid the rent, your
No,
lordship.
subsequently it is paid. That is not the reference.
After a year, yes, after a year.
As on the day court decided,
Yes,
it has paid. There is no such reference is that. If you read as it is,
yes.
it's showing that he has not paid that rent. That itself is enough for dismissal. Because he has not complied, he
Yes.
cannot seek for a stay of the
He
order.
cannot seek a stay.
But here
Yes.
he has complied that. Court could have been given a reason.
Yes.
Yes, subsequently you have complied. There is a direction to pay it.
Your lordship will
regularly.
only,
Therefore, you are not approached the court with a clean hand. We are rejecting. That is different.
your lordship, that has also been recorded in my respectful submission. If your lordship will only have paragraph 58 again.
Yes,
I am reading your lordship the 5th line
yes,
from the top.
yes.
The petitioners have placed document number 2A,
Yes.
whereby from 7/8/24 to 29/8/25,
Yes.
for nearly 1 year,
Yes.
the respondents have not paid any payments of rent. So for nearly 1 year, the respondents have not made payments of rent is qualified, your lordship, by the fact that rents have not been paid up to 29/8/25.
Yes.
So for the petitioner to argue, your lordship, that the trial court has not recorded that rents were paid at all, the fact that the word 29/8/2025 itself has been recorded.
Subsequently, it has been paid. That cannot be accepted. For he is not entitled for that.
No, your lordship, it is only say inherent in.
Court has not seen that records
Yes.
properly.
No, inherent within that particular finding, your
I
lordship.
think you have to be added now.
No, I am only saying, your lordship, that once the court records that up to 29/8/25 rents have not been paid.
That court has relied on.
Yes.
This, what is that extract?
Yes, I will demonstrate even that, your lordship.
Yes, what is that?
Why this is a clinching document.
Yes,
One of the most significant grounds, your lordship,
yes,
for the stay itself, as was sought by the applicant, was that both parties have challenged the award. Because, your lordship, it is undisputable that the lease has expired.
yes.
This fact is not in dispute. The writ petition itself goes on to admit that the lease expired. They have not paid rent for 1 whole year up to 29/8/25.
Yes.
Even this fact is not in dispute. It is their own.
Now, after expiring that lease,
Yes.
now you can't say that no interim order granted because throughout 2018, number of order has been passed by the court as continuing for him to in the possession.
Yes, your lordship. Because the issue of whether or not the lease is renewed was still pending consideration before the arbitral tribunal. Now, by a 40-page award, your lordship, the arbitral tribunal after
During that period,
yes,
what is the result? Whether he has to be vacate or he has to be continued.
has to vacate, your lordship. The question and the reason for that, your lordship, is very simply this. And that was the question which your lordship raised even yesterday,
Yes.
which in my respectful submission goes to the very heart of this matter. If your lordship will only consider this,
Yes,
the lease has expired on 10/9/25.
yes,
They do not dispute that the lease has expired.
yes.
Now, your lordship specifically posed a question.
It is not expired in 10/9/25. It is expired in 2018 only.
In-
After that, it is not.
I am saying by virtue of the award.
Yes. Award
Even
is-
if,
time has been extended for him to vacate.
yes, your lordship. So even if I am to catch the higher limit,
Yes.
10/9/24 is when the award is passed.
Yes,
10/9/25 is when this lease has expired.
yes,
Now, your lordship, they say that this lease, I still might have a chance of continuing to stay in the property. That is the only ground, your lordship. Now, if your lordship only has, and I will only highlight this one particular portion.
yes,
If your lordship only has
yes.
clause 4.3, your lordship,
In where?
and that clause is at page 37 of the writ petition.
Yes,
Now, this is the lease deed, your lordship, an admitted document on the strength of which the award has been passed.
page.
This is, your lordship, page 37 of the writ petition itself.
Yes,
I will only read clause 4.3.
yes,
The period of lease shall be 10 years.
yes,
The initial 5 years of the lease shall be treated as lock-in period.
yes,
If ROHL proposes to terminate this lease deed during the lock-in period, in such event, they shall be liable to pay JHA the entire minimum guaranteed lease rent, so on and so forth. I will not read the subsequent portion, only because I wish to highlight, your lordship, that the lease expired on the expiry of 10 years.
yes,
Now, if your lordship only has the award, because your lordship exercise of any power to set aside this order now
yes.
would cause grave prejudice, your lordship, to this applicant, to the respondent, I apologize.
Oh, that should be the finding.
Yes, if your lordship only has,
Balance of convenience. there is no prima facie case.
Yes.
Balance of convenience is in favor of the defendant. Therefore, I am rejecting, giving a reason.
Yes,
I thought that order should be there.
The findings insofar as prima facie case, your lordship, are there in my respectful submission. But yes, if your lordship only has paragraph 80.
The trial court has considered, that is what that issue is.
Yes, your lordship, the fact that payment of rent, your lordship, was a precondition.
Yes.
The moment they failed to perform that one fundamental precondition,
Yes,
the question of considering any other issue could not have possibly arisen.
You are saying that there should be in that order.
Yes.
Then court said that there is no prima facie case for this reason.
Yeah.
They are not said anything.
Your lordship, there is a recording immediately after that. I will only highlight it again.
Yes.
But if your lordship will only have this one particular paragraph for the moment, because this, your lordship,
We have to read this order of rejection.
Yes.
Along with that, all records you have produced.
No, only the
That is
award,
how
your lordship.
this order is to be.
Only the award, your lordship.
Yes.
Only the award. I will only highlight 2 paragraphs from the award. That is all.
Yes.
If your lordship will only have page 82 of the petition itself.
Yes.
I'm reading clause 3, your lordship.
Yes.
The deed prescribes conditions for renewal of the lease as stated in clause 4 referred to above. That the claimant must have paid an average amount of rupees 42 per square foot per month
Yes.
from 2012 to 2018. If there is any shortfall, the claimant shall pay the same and obtain the renewal of the lease.
Yes.
It is the case of the claimant that such a situation would arise only when the lease is renewed. To have a clear visibility on the renewal of the lease is at the end of the lease and not earlier. This portion, your lordship, is important.
Yes.
Indeed, such a calculation, even after the expiry of 10 years of the lease, is not forthcoming.
Yes.
In this regard, the oral evidence of the parties is to be looked into. When PW1 was posed with questions 57, 58, 59, 61, and 62, the answers would clearly disclose that the claimant would be eligible to seek renewal only if the conditions stipulated therein are satisfied and not otherwise.
No, that is true. That
Yes.
is why that they said specific performance cannot be granted.
Yes.
That now it is challenged. Court has to be decided.
Yes.
Now
in
after 2018,
yes, your lordship. Yes.
it is not renewed. You have
Yes.
not taken any action from 2018.
Your lordship, the matter, arbitral proceedings themselves began in the year 2021 because of COVID and so on and so forth. So arbitration was pending till 2024, your lordship.
Yes.
Now, thereafter, your lordship, I will only complete that portion.
Yes.
It is to be noted, I apologize. If your lordship is on page 83,
Yes.
admittedly, such payments have not been made.
Yes.
And it is only during the pendency of the proceeding, certain amounts have been paid pursuant to the order passed by this tribunal.
Yes.
It is to be noted that a perusal of Exhibit P3 does not give an indication that there is an obligation on the part of the respondent to renew the lease on the expiry of 10 years, and that renewal clause, if any, would come into play only when certain conditions enumerated therein are satisfied and not otherwise.
Yes.
Now, I will pause here, your lordship, for the reason that what this paragraph does is categorically records that insofar as the lease is concerned, that has expired. There is no dispute. Now, if your lordship only has one further paragraph, and that paragraph, your lordship, is important. That is at page 87, your lordship.
Even that is not extracted in that order to say that arbitrator has considered this point.
Yes.
He has given such a finding. There is no material which is produced to.
Your lordship,
report on that.
the respectful submission for that is,
It is under 226 order. It looks like under 226 order.
your lordship, even in 34 jurisdiction, your lordship,
Yes.
proceedings are summary in nature.
Yes.
Even in so far as the award itself is concerned, the question of a court setting it aside after a merits examination is not permissible, your lordship. So, given that there is absolute, blatant material available on record to show that fundamental conditions have not been satisfied, they did not warrant any further inquiry, your lordship. That is the submission. Now, if your lordship only has paragraph 58, that paragraph, your lordship, is at page 87.
Yes.
Insofar as issue number 9 is concerned, apparently, after the expiry of 10 years from the date of execution of Exhibit P1, the lease and tripartite agreement stands automatically terminated by the efflux of time. And the respondent is entitled to recover possession in respect of Schedule B properties.
Yes.
But however, and this is important, your lordship, only after the claimant removes fit-outs and other properties owned by it in the scheduled property. This exercise shall be done by the claimant within a period of 12 months from the date of passing of the award. The claimant will continue to pay the agreed rent as per Exhibit P1, which is 43.17. Now, Your Lordship, this period of 12 months was granted to the claimant specifically for the purposes of demobilizing its premises. They now say that my business continues to be hampered. Now, that in my respectful submission, Your Lordship, cannot be.
That is under that main matter, court will consider whether such a condition, such a ground can be raised in this. They may reject it also.
Yeah, and that ground has in fact been considered, Your Lordship. Now, insofar as the,
Yes.
if Your Lordship will only have further, Your Lordship, there is only one. This is of some significance.
Yes, which paragraph?
If Your Lordship has, I am not on the award anymore, Your Lordship, but this affidavit that has been specifically referred to
Where?
during the arbitration, I will only highlight that, Your Lordship. That affidavit is the first document along with my reply.
Reply, it's there.
Yes.
Yes. Yes.
Now, if Your Lordship has this affidavit, it is an affidavit which has been filed by one Mr. Amit Jaiswal.
Page.
I will only,
After that objection. Yes.
yes. If Your Lordship has page 50.
Yes, 6.
6, Your Lordship.
Yes.
Yes. No, I apologize. This is the clarification.
Yes.
If Your Lordship only has page 61, the document begins at 61.
Yes.
And what I am now reading, Your Lordship,
Yes.
is paragraph 6.
Yes.
This is what has been considered by the Honorable Court, Your Lordship,
Yes.
in arriving at its conclusion.
Yes. Para?
Para 6, Your Lordship.
Page 62.
At page 65, Your Lordship. 61 is where the document begins. I am at 65 now.
Yes.
This is an affidavit which was filed by the petitioner's representative
Yes.
before the arbitrator.
Before the arbitrator.
Before the arbitrator. So the lease, Your Lordship, as Your Lordship rightly pointed out, stood expired as far back as in January 2018.
Yes.
Right from then, Your Lordship,
Yes.
this issue of delivery of possession has not been in dispute.
Yes. Yes. Yes.
If Your Lordship has para 6,
Yes.
I state that the respondent has neither renewed the lease, assuring the claimant of its term, nor carried out the repairs that are critical for the use. This is that portion which has been reproduced, Your Lordship.
Yes.
Now, if Your Lordship also has, subsequently, paragraph 7 on the next page, Your Lordship.
Yes.
No, I apologize. I'm reading the first paragraph that I have relied on, Your Lordship, is paragraph 6.
Yes.
And now if Your Lordship has paragraph 9, I apologize.
Yes.
9 is at 67.
Yes.
If Your Lordship sees this paragraph,
Yes.
I submit that the handing over and delivery of possession
Yes.
by us to the respondent has no nexus with the monetary demands of the respondent against us. Assuming without admitting that they are due, I state that such a claim or its adjudication will not come in the way of the respondent receiving possession of the scheduled premises from the claimant.
Yes.
I state that the respondent cannot be permitted to take advantage of its own wrong. Now they say, I cannot take advantage of my own wrong because they said, we will hand over possession of the property, but 15 crore rupees you are required to pay us as a precondition to accepting handover, which was not acceptable. In view of this, Your Lordship, this is on record before the trial court. This has also been considered, after which the trial court has come to a finding that even a prima facie case has not been made up. Now, if Your Lordship only has paragraph 58 of the award, I have already read that. I'm only going to reiterate, Your Lordship, that even under the award, which was made after consideration of all of these pleadings,
Yes.
and these specific admissions before the arbitrator,
Yes.
that the Learned Arbitral Tribunal had granted the petitioner a period of 12 months
Yes.
to stay in the property demobilized.
Yes.
Now, I will only pause for a moment, Your Lordship, to highlight the conduct of the petitioner.
Yes.
On 10/9/24, Your Lordship, an award is passed.
Yes.
After the award is passed, Your Lordship,
Yes.
the petitioner seeks this clarification from the learned arbitrator that insofar as this period of 1 year is concerned, please permit me to stay for 12 months and continue my business operations until 12 months.
No, we will
that
not
was the prayer that was sought. They were already permitted to stay.
Sorry, that's not
Now,
correct. That's not correct. Please,
My submission, Your Lordship,
please see
was,
the application.
I will clarify it, they were permitted to stay for 12
No,
months.
that's permitted, whether he has sought for that.
Yeah.
Yes, a clarification has been sought, Your Lordship.
Clarification sought as to what is the effect of the order, not as to.
I will highlight that application as well, Your Lordship.
Yes, yes.
If Your Lordship only has this application which is on record at,
Along with that, your objection or is?
this is along with my objections, Your Lordship, and
Yes.
that is in fact the first document on record. If Your Lordship has Annexure A at page 56,
Yes,
Your Lordship has seen paragraph 86F, which
Yes,
says that the
yes, yes.
petitioner was required to vacate. This is an application filed under section 33 by the petitioner, Your Lordship.
Yes.
Now, in this application, Your Lordship, what the petitioner says is, if Your Lordship only has paragraph 5 at page 58.
Yes.
Therefore, in the said period, I respectfully submit that it is imperative that the claimant's operations at the scheduled premises must continue without any interference from the respondent. The award passed is silent on this aspect. The claimant's prayer for direction to the respondent to maintain the premises has not been granted, and therefore, the onus of maintaining the hotel falls on the claimant. This is the first clarification that they seek, Your Lordship. Thereafter, Your Lordship, in paragraph 6, they go on to ask, in view of the facts and circumstances of the case and present dispute between the parties, it is just and necessary that this honorable tribunal provide clarification regarding para F on page 43 of the award. It is prayed that this honorable tribunal provide a necessary clarification and pass an additional award if required. Therefore, that the claimant is entitled to uninterrupted use, occupation and enjoyment of the scheduled property for the 12-month period. Now, why do I highlight this portion, Your Lordship? An additional award has been passed on the strength of this clarification.
No, it is not that he is going to hand it over or he will not challenge that award.
Yes.
He said
No.
that during that period also there should be safety.
They should be permitted to continue, Your Lordship.
Yes.
That is the clarification that was sought. Now, Your Lordship, nevertheless, the obligation to hand over within 12 months remains. Now, insofar as the subsequent conduct is concerned,
Yes.
Your Lordship will only note that this particular application came to be allowed on 16/12/24.
Yes.
On 16/12/24, Your Lordship, a clarification is issued that they can continue to operate their business in the premises
Yes.
until 10/9/25. This, Your Lordship, is placed on record by the petitioner itself.
You have argued all these points before the trial court.
Yes, Your Lordship, these points have been argued.
There is that, there is no thing
The
reference in the
fact of the matter, Your Lordship, is insofar as the state court's jurisdiction is concerned, Your Lordship, it is seized of this matter. It has considered all of these. The very fact that rent itself has not been paid could, beyond that point, Your Lordship, not entitle the petitioner to any further consideration itself, is my respectful submission. That was a fundamental prerequisite, Your Lordship. For one whole year, they continue to run their business. They don't pay a dime. And then, Your Lordship, they seek a stay. The trial court has seen through this fact and therefore arrived at this prima facie finding. If Your Lordship will only have the last portion of this particular order, which is at page 107, Your Lordship.
Yes.
Indeed, I am only reading paragraph 14 now, the last paragraph.
Para 14, yes.
Indeed, having said so, that is of the writ petition itself, Your Lordship. Writ petition itself.
Yes.
Indeed, having said so, the phrase use and occupation,
Page 1.
Page 107, Your Lordship.
Yes.
If Your Lordship has page 107, paragraph 14 is what I read.
Yes.
Indeed, having said so, the interpretation to the phrase use and occupation would be that the claimant is permitted to run its business of running the hotel as per Exhibit P1 uninterruptedly by the respondents or anyone claiming through them until the expiry of 12 months from the date of the award. The application stands disposed of accordingly.
Yes, there is no.
Now,
That's, yes.
this, Your Lordship, is an additional award which has been made. This additional award, Your Lordship, has not been challenged even by way of an amendment to their section 34 petition.
They have been protected.
No,
till
my
months, right?
submission, Your Lordship, is this gets subsumed into the original award. Under the original award, they were required to vacate on 10/9/25. That original award, Your Lordship, comes to be passed on 10/9/24. On 12/12/24,
No,
this order
understood that.
comes to
I
be
don't-
passed.
I think it is not necessary to challenge.
Your Lordship, because
If there is any adverse order is there, then he has to be challenged.
Yes, it
Otherwise,
is-
even one order,
yes,
you can challenge that part of that.
Yes.
Even, I think you have filed a petition before that commercial court.
Yes.
You are not challenging entire award, part of that.
Absolutely. Only the severable portion.
Like that, they can also, whichever that not against them, they can.
But we had challenged the order even before this order was passed,
For a
even
moment
before the
I-
hour 34 is pending.
Even then after also.
No, I have challenged the order, sir, in March 2025. not
No, we challenged it in December
Even
of
then,
20.
it is not that whichever the order is against you, you can challenge.
Yes.
No such.
But I concede your lordship. That is just for perspicuity. I thought that is relevant, but I'm in your lordship's hands. If your lordship only subsequently
Yes.
has, this conduct is important, your lordship.
Yes.
If your lordship has the, specifically,
Yes.
page 101, your lordship. I apologize. If your lordship only has,
Yes.
yes. Now, the limitation, your lordship,
Yes.
for challenging the award itself expired on 16 March 2025. There is no dispute on that. 3 months expired on 16 March 2025.
16 March.
16 March 2025 in terms of section 34(3).
Yes.
Now, it is possible, your lordship.
When it is filed.
The challenge filed
The
on.
challenge
12,
by the
12,
petitioner was on 12/12/2024.
10/12.
10/12/2024.
Yes. 10/12.
2024, your lordship.
After that limitation.
No.
Within limitation. No, I'm making
No,
another
they filed
submission,
it in
your
March of this year. We filed it immediately after the award.
So on 10/12/2024, your lordship,
Yeah,
a section 34 petition is filed by the petitioner.
Yes.
In terms of section 34(5), your lordship, the petitioner is required to issue prior notice of the Arbitration Act at the time of filing for 1 whole year, your lordship. It is only in July that the petition under section 34 is served on me. They sit on that petition for 1 whole year, your lordship,
Yes.
choosing to serve it on me only on 15 July 2025. Even that email is placed on record, your lordship.
Yes.
Now, if your lordship only will have one letter, which is important. There is a letter, your lordship, that your lordship will recollect I said that limitation expired on 16 March
That's
2025.
what last day of limitation, they have sent in a notice.
No, your lordship, I am saying I have filed 1 day before limitation expired. I have filed
He filed.
my 34 petition. They have filed much prior,
No,
but they have not served me
notice they
for
said,
7 months after filing the petition itself also. For 7 whole months.
no, why that court has not issued notice?
Yes, it has.
Lordship, the applicant kept seeking time to take steps. I have put all those procedural orders also on record.
Now for that to, what is that remedy available for you? We can remedy available for to.
Your lordship, the point or submission here is
That
this.
I understood that.
The conduct,
How he has to delay that.
they delay the entire proceeding, your lordship. An award which has attained finality. The award became final, enforceable and binding, your lordship, on 16 March 2025.
To delay
Yes.
within the framework of law, what he can do, he has taken that opportunity. and
I am only completing as far as the chronology is concerned, your lordship. And that goes to
what
why.
he can do
Yes,
now that he can till that final disposal.
yes.
Whatever that law permitted for a time, he
Yes.
can take that advantages and
He can, but that advantage itself, your lordship,
You said that it was
the right to take that advantage
Yes.
has now stultified their right to seek a stay, and that is my submission.
Yes.
If your lordship only has this one letter on record,
no, but nothing is there on all that you want me to give a finding all this.
no,
This
I am
has not
only,
been considered by the trial
your
court.
lordship, I am only submitting.
Argued.
Yes,
If you are not considered, we will record that these are all been argued. Nothing has been considered by that court. We'll make an observation.
your lordship, if your lordship is inclined to record that this has not been considered,
Yes.
I will only make 2 submissions, your lordship. The first is that insofar as the order that has been impugned is concerned, the mere fact that they have not paid rent
Yes,
in
it
and of
does.
itself, in my respectful submission,
Section of
qualifies as sufficient ground,
Yes.
along with sufficient reasons for rejection of the stay. The second submission, your lordship, is this. The applicant has approached this honorable court in exercise of its writ jurisdiction. Now, your lordship, in so far as an order for stay under section 36 is concerned,
Yes.
that order, your lordship, cannot be challenged in proceedings in writ jurisdiction before this honorable court.
Show me that.
And
First
there-
we have to be argued on that.
Yes,
matter.
your
You
lordship,
have-
yesterday the difficulty was that my learned senior began on the
No, today
merits, and
itself,
therefore I was constrained to.
2:30 to
Yes.
4 o'clock, I could have been disposed of another 10 to 15 matters.
If your lordship only bears with me for one moment, I will show the judgment itself. Yes.
You are in a counsel appearing for the
The
respondent.
respondent, yes,
If you have any objection for maintainability.
Yes.
First audience for you.
yes.
You have to raise that, then we will decide.
I have raised my,
Otherwise, if I convince me saying that it is not maintainable.
Yes.
You have wasted my time.
No.
I will dismiss this petition imposing cost on you because you have wasted my time.
I apologize for that, Your Lordship.
What is that maintainability?
Yes, if Your Lordship only has,
I have raised at the beginning itself, Mr.
Your Lordship, my learned senior began with the
So
submissions
whatever
yesterday.
Began it.
And
Now
therefore-
you could have said that the moment if you say it is
Yes.
not maintainable, I will give a first preference to you to argue that because first I have to find out that whether I have jurisdiction or not.
Yes,
Tomorrow my order has to be challenged saying that this court has passed without jurisdiction.
yes. If I will only have,
Counsel without assisting, if you have passed any order,
Yes.
it is different. Yes, you have to be assist that.
I apologize, Your Lordship. I was under the impression that this might perhaps be heard once and for all. And therefore I was,
Maintainability is first, then other things. Why it is not maintainable, first you tell me that, then we'll go to the judgment.
if Your Lordship only has, give a copy. Your Lordship, I have turned to,
Everything in that, whatever I have, this.
I apologize, Your Lordship. I sincerely apologize. But if Your Lordship only turns, I will not take to.
Council's good ground is on legal points. If it is there, first you have to be impressed
To
the court on
maintain
that. Taking all these documents which I have thinking that I am hearing in first opinion. You
Yes.
should have taken that in the beginning itself. Yes,
If Your Lordship has the first decision,
yes.
this is the decision of the Supreme Court in Deep Industries versus. There are three judgments, Your Lordship, which I am citing.
Yes.
The first of these that I am relying on.
Oh, each one is single judgment. This.
Yes, Your Lordship. The first decision that I rely on, Your Lordship, is Deep Industries. Now, this decision, Your Lordship, is very categorical
Yes,
in that orders which are passed by courts
yes.
under the Arbitration Act are not to be interfered with unless and until, Your Lordship, a party is able to make out a case of absolute fraud or manifest injustice. Now, in my respect,
In that 37 petition or 34 petition, or you are saying that under 36 order?
Your Lordship, I am saying insofar as a 36 order is concerned.
36. Is it
Yes,
under 36?
my submission, Your Lordship, is the Arbitration Act, Your Lordship will appreciate, it is well sectioned, is a self-contained code.
No.
Section-
See, there are two things.
Yes,
36 order filed under the trial court, or you are saying that under 227 this court has a
no, I am saying in 227, Your Lordship,
Yes.
this court
any
may-
order passed under 36(3).
cannot be assailed before this court.
That's
In 227, that is my submission. Your
Yes,
Lordship.
yes.
If Your Lordship has Deep Industries, the judgment, Your Lordship, begins at page 387.
No, which deep industry.
Yes,
That pertains to an order passed by an arbitrator, which is challenged in a writ petition, not by a court.
Yes, we have.
I will only highlight those portions, Your Lordship.
Page
Learned senior may
387.
distinguish it.
387.
387, Your Lordship.
That is with regard to challenging an arbitrator's award in a writ petition.
If Your Lordship has paragraph 15,
387.
yes,
388.
387 is where Deep Industries begins, Your Lordship.
Yes.
Now I am cutting to paragraph 3, page 394, Your Lordship,
394.
which has paragraph 15.
394.
Yes.
Yes.
If Your Lordship has paragraph 15,
Yes.
given the aforesaid statutory provision and given the fact that the 1996 Act repealed 3 previous enactments in order that there be speedy disposal of all matters covered by it, it is clear that the statutory policy of the Act is that not only are time limits set down for disposal of the arbitral proceedings themselves,
Yes.
but time limits have also been set down for section 34 references to be decided.
Yes.
Equally in Union of India versus Varindera Constructions, dated so and so, this court has imposed the self-same limitation on first appeals
Yes.
under section 37, so that there be a timely resolution of all matters which are covered by arbitration awards.
No, that's what I am asking.
Yes,
34, 37.
yes.
In between 36.
I will get to that also, Your Lordship. By
directly
36 is covered. Yes, I will get to that, Your Lordship.
Yes. 36 you have to be. Yes.
36. But for the time being, Your Lordship, I will only complete this submission by saying,
Yes.
if paragraph 17 may be had regard to,
Yes.
this being the case, there is no doubt whatsoever that if petitions were to be filed under Articles 227 of the Constitution
But
of
we also
India,
have to read para 16.
para 16.
Because
Certainly.
para 16 is section 5 of the arbitration.
I
Act,
will read para,
which
I
talks
will read
about
para 16.
Yes,
It
yes.
it helps me a lot.
Yes.
Most significant of all is the non-obstante clause contained in section 5, which states that notwithstanding anything contained in any other law, in matters that arise under part 1 of the Arbitration Act, no judicial authority can intervene except where so provided in this part. Section 37 grants a constricted right of first appeal against certain judgments and orders and no others.
Yes.
Further, the statutory mandate also provides for one bite at the cherry and interdicts a second appeal being filed.
Yes.
The submission, Your Lordship, is that only those orders which are made appealable under section 37 of the Arbitration Act can be entertained or taken up in an appeal. Now, the question that Your Lordship posed was as to whether this would cover section 36. The answer to that, Your Lordships, will find in the subsequent judgment that I have placed on record. I will only highlight the page number. If Your Lordship has page 414.
14.
Yes, 414, Your Lordship.
214.
414, Your Lordship. 414, yes. This, Your Lordship, is the decision in Chintels India versus Bhayana Builders.
Yes, 414.
414, Your Lordship. To appreciate the ratio of this decision, Your Lordship,
Yes.
I will only have to read section 36 once
Yes.
to ensure clarity. If Your Lordship has section 36,
I think it is extracted somewhere.
yes,
In to go through the text.
in the decision as well, Your Lordship.
Maybe extracted. 39 is there. 34 is there. Maybe 36 is not
It,
extracted. Let's
it
read
reproduces 37, Your Lordship, and 34. I will show why this applies to 36 on all fours.
Yes.
Your Lordship will only consider 36 for a moment.
Yes.
Where the time limit for making an application to set aside an arbitral award under section 34 has expired, then, subject to the provisions of subsection 2, such award shall be enforced in accordance with the provisions of the Code of Civil Procedure, in the same manner as if it were a decree of the court.
Yes.
Your Lordship only has subsection 2 again, where an application to set aside the award has been filed in the court under section 34. The filing of such an application shall not by itself render that award unenforceable unless the court grants an order of stay of the said arbitral award in accordance with the provisions of subsection 3 on a separate application. Your Lordship, on a reading of these two subsections, Your Lordship will appreciate that exercise of power of stay under section 36 can only and only vest with the court under section 34, which is to say, Your Lordship, section 36 powers are rooted in or find their source in section 34. So, Your Lordship, if an order has been passed under section 36, it is for all intents and purposes an order which is passed in exercise of inherent jurisdiction under section 34.
Yes.
Now, Your Lordship, the reason that this statement assumes importance is
Yes.
because in Bhayana Builders, this issue of the effect doctrine or the effect of powers exercised under section 34 has been considered. If Your Lordship only has specifically paragraph 12 of this judgment, Your Lordship. The difficulty in Bhayana Builders or the issue in consideration, Your Lordship, was this. Perhaps I may offer some context. An application was moved under section 34. It was beyond the period of 3 months plus 30 days. Now the 34 court, Your Lordship, condoned the delay and this order was challenged.
Yes.
Now, the maintainability of the appeal on this point, Your Lordship, was in question because section 37, which is the appeals mechanism, so to speak, does not provide for any particular category of orders condoning or refusing to condone delay under section 34.
Yes.
So what was argued, Your Lordship, was that since this is not categorically spelt out under section 37, this appeal itself is not maintainable.
Yes.
That was the context. Now, Your Lordship has categorically put a question, and rightly so, that section 36 does not find mention in 37. Neither does it find any mention in 34. But 34 finds mention in 36. And Your Lordship will agree that exercise of power under 36 can only arise or stem from exercise of powers under 34. Now, in this context, Your Lordship, this is what the Supreme Court has to say in paragraph 12.
Yes.
We now come to section
May I request that
37.
my lord sees para 1 first, my lord. The question is, the court has framed the question. The
Lordship, I
question
may
is,
complete my submission.
no,
and
it's
then-
you look referring to the judge. The question is whether a 34 order can be challenged under 37 1C. That is the question in this case.
I will read the entire question, Your Lordship, then.
Yeah, please.
Because that is not the entire question.
For application, order passed under the IA, if I take an half an hour.
No, I will only leave it at this, Your Lordship.
See that the pendency in my court is that 10,000.
I'm mindful of that, and I apologize, Your Lordship. I will only close in the next 5 minutes, just only 5 minutes.
Yes.
If Your Lordship has paragraph 1, I will begin by reading paragraph 1.
Yes.
The appeal arises out of a certificate
Yes.
issued under Article 133, read with Article 134A of the Constitution by the High Court of Delhi in the impugned judgment dated 4/12/2020. The question raised in this appeal is whether a learned single judge's order refusing to condone the appellant's delay in Section 34, in filing an application under Section 34 of the Arbitration and Cancellation Act is an appealable order under Section 37(1)(c). Now, if Your Lordship only has Section 37(1)(c),
Yes. I think that has no bearing, Mr. There is no power for condonation under 34 itself.
Precisely, Your
Lordship.
Lordship.
Exercising the power under 37 and condone the delay. That is what that.
No, that is, the Supreme Court has said that this would be sourced to Section 34, Your Lordship, and therefore would come back to Section 37 itself.
Yes.
If Your Lordship only has Section 37(1)(c), I will only read that portion. Notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the following orders and from no others to the court authorized by law to hear such appeals from original decrees of the court passing the order. Namely, now I will cut to 1(c), Your Lordship, setting aside or refusing to set aside an arbitral award
Yes.
under Section 34. Now, what 37(1)(c) provides for, Your Lordship, is only setting aside or refusing to set aside an award, which is to say,
Yes.
award is quashed or award is upheld. Condonation of delay itself, Your Lordship, is not appealable directly under Section 37.
Yes.
This is what was argued before the Supreme Court, Your Lordship. In view of this, I am grateful to my learned senior. If Your Lordship only sees paragraph 12 now,
Yes.
we may now come to Section 37(1)(c).
Yes.
It is important to note that the expression setting aside or refusing to set aside an arbitral award does not stand by itself.
Yes.
The expression has to be read with the expression that follows
Yes.
under Section 34.
Yes.
Section 34 is not limited to grounds being made out under Section 34(2).
Yes.
Obviously, therefore, a literal meaning of the provision would show that a refusal to set aside an award as delay has not been condoned under subsection 3 of Section 34 would certainly fall within Section 37(1)(c).
Yes.
Therefore, the aforesaid reasoning is strengthened by the fact that under Section 37(2)(a), an appeal lies where a plea referred to in subsection 2 or 3 or Section 16 is accepted. This would show that the legislature, when it wished to refer to a part of a section as opposed to the entire section, did so, contrasted with the language of Section 37(1)(c), where the expression under Section 34 refers to the entire section and not to 34(2) only. The fact that an arbitral award can be refused to be set aside for refusal to condone delay under Section 34(3) gets further strengthened. Now, Your Lordship may only consider this. Section 36. It is not as if an application under Section 36 can be filed as a separate MA before a different court, Your Lordship.
Yes.
It has to lie before the court which is seized of the proceedings under Section 34 itself. So, inherent in the exercise of powers under Section 36, granting a stay or refusing to grant a stay is the exercise of power under Section 34. If Your Lordship will consider that the very issue which was being argued by my learned senior at the very outset was this: which court has power under Section 34 itself? As a logical corollary, the power under Section 36 will flow from 34. Now, if Your Lordship, the petitioner is in fact aggrieved, because Your Lordship, sections 34 to 37 provide a very circumscribed, narrow set of grounds on which the award can be considered. For that matter, on which a stay can be considered. Your Lordship may consider setting aside of an award is a final relief. A stay is something which is in the nature of a temporary interim relief which is granted prior to setting aside power. But the law, Your Lordship, insofar as 34 jurisdiction is that it is a summary procedure.
Is it bar under Section Article 227?
Yes, Your Lordship,
Where is
because
that?
it would be
You are not-
categorically covered by 37(1)(c) itself.
No, see, power exercise, supervisory power exercise in the
Yes.
court under Article 227 is different.
Yes.
Is it that is barred?
Yes.
Unless law, statutory laws which specifically says that you have a remedy of appeal.
Yes.
Then the course appeal available for that party is only under 227.
But your lordship, that is the submission.
That is
A
what
remedy of appeal is provided for. Your lordship may consider it, commit it differently. If I commit it differently, your lordship.
You say that
Yes.
this order is merged under 34.
Yes.
Therefore, it is only appeal under 37.
Yes,
not
your
under
lordship.
the revision.
It cannot lie under Article
Any
227.
judgment on the direct point.
Your lordship, I will only read out from this very judgment. Bayana Builders goes on to discuss this, your lordship.
Yes.
Your lordship will only have this, what is known as the effect doctrine,
Yes.
has been expounded by the Supreme Court in this decision.
We will continue to hear on Tuesday.
On Tuesday, your lordship.
Tuesday. Monday is afternoon is not sitting.
Yes.
Tuesday 2:30.
Tuesday at 2:30.
Yes. You also see that, Mr. on maintainability. Only on maintainability. Other points you have argued.
Yes. Your lordship, I may only be permitted on Tuesday to only cite a few decisions in so far as the expiry of lease issue was concerned. I did not cite those today.
Only now you have to argue on that maintainability.
Yes.
Yes.
So only two decisions that I may be permitted to rely on that day. That is all. I will not take.
Yes. Yes. Leave this matter on Tuesday because I have so many other matters, Mr.
I apologize, your lordship. I consumed a significant amount.
Yes.
Interim order, Mr. Interim order.
Yes, granted earlier is extended till next date.
Grateful.
It's okay with your lordship. I'm grateful, your lordship.
Yes. RFA. Yes, RFA will have it on Friday. RFAs on Friday. Regular list will be Friday.
My lord. On
Is it 2:30? Yes. ಅಲ್ಲ RFA ಗಳನ್ನ only on Friday I have fixed that. Otherwise ನೀವು ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಹಿಂಗ್ ಕುತ್ಕೊಂಡು ಕಾಯ್ಬೇಕಷ್ಟೇ. ನೋಡಿದ್ರಲ್ಲ ಇವ್ರು 9,000 ಪೆಂಡಿಂಗ್ ಇದಾವೆ. ಅವ್ರು ಸುಮ್ನೆ ಸೂಟ್ ಇದೆ ಅದಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು they will. Actually RFA is the most important than that GMCPC. GMCPC application ಅಷ್ಟೇ. Application ಇಲ್ಲಿ ರಿಟ್ ಅಲವ್ ಆಗ್ಲಿ ವಜಾ ಆಗ್ಲಿ ಶೂಟ್ ಅಂತೂ ಇದ್ದೇ ಇರ್ತದೆ.
On submission.
I think is that more petition is on that side only.
Serial number.
ನಿಮಗೆ ಇನ್ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ? Next Friday 13ಕ್ಕೆ. Yes, 13.
Serial number 122, my lord.
123 on 2013.
Serial number 55, my lord. Serial number 55, my lord.
Other matters will come.
Serial number 1. Serial number 1.
Much obliged, much obliged.
My lords, 122, my lords. My lords, may kindly have it after 11th, my lords.
ಬೇರೆ ಮ್ಯಾಟರ್ ಹಿಯರ್ ಮಾಡಕ್ಕೋಸ್ಕರನೇ ನಾನು ಅದನ್ನ ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ದೀನಿ. I will come to that other matters. Yes. 120.
122, my lords. After 11th. The senior counsel has not been available.
20.
Please, my lords.
13.
So 18th ಆದ್ರೆ ಕೊಡಿ ಸರ್.
18th ಇಲ್ಲ ಇನ್ನ
11th at least
27th.
11th ಆದ್ರೆ
27th. No, only Friday.
only Friday sir.
Yes.
27th are both, my lords.
27th. Yes, 27th. Yes. Continue. Continuation of list. Serial number 35. Lokesh and DK for petitioner. Govardhan S. Yes, 35. Each time is granted. You are appearing for?
Respond number 1, my lord.
What is this, Mr.?
My lords, basically the plaintiff here, the petitioner here.
Any of that process is not completed. Let him complete.
My lords, this is a very simple case, my lords, wherein the position of law is very clear. What has happened is, if my lords just permit me to recollect the facts, one Doddamada.
No, facts beda. You are the plaintiff.
They're challenging one rule 10, my lords. They filed a impleading application on behalf of the decree holder number 2, my lords.
In the execution petition?
Yes, my lords.
Suit for?
This suit for, it's not a suit, my lords, wherein it's under Workman Compensation Act, my lords.
Workman Compensation?
Yes, my lords.
What has happened that?
Lords, in that the award has been granted and the execution is pending for almost 11 years, my lords.
No, you are the claimant.
I am the respondent number 1, who is the wife of the deceased, my lords.
Yes.
So the series of succession goes in this way, my lords. One Doddamada.
What is that award has been passed, Mr.?
Award is
5,35,000.
5,35,000.
You have filed an execution petition.
Execution is comprising of 9,45,000, my lords.
Yes. What is that? Yes, challenging. Who is he? petitioner.
Petitioner number 1 and 2 are they are claiming to be the LRs of the decree holder number 2, my lords.
They are
And by
LRs.
relation, they happen to be the brother and sister of the deceased, my lords.
Now, who is the deceased? What is his name?
Deceased is Dodda Madam, my lords.
You are the.
I am the wife, my lords. Respondent number 1 is the wife and the decree holder number 1, my lords.
What is the relationship between that this petitioner herein?
Petition number in is the brother and sister of Dodda Madam, my lords.
Brother and sister.
Yes, my lords.
They are also claiming that rights.
Yes, my lords. So the simple position of law is that
They are not entitled. It is when he was in service, he has died.
he has died, my lords. In service, he has died, wherein has his legal heirs under class 1 heirs.
Wait. You are all working as an. Your husband is working as what?
Lords, he was working in for
ಮೇಸ್ತ್ರಿ ಆಗಿ ಮೇಸ್ತ್ರಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರೆ.
ಹೌದು ಸ್ವಾಮಿ.
They are claiming under this thing.
In fact, my lords,
is there any stay here?
Yes, my lords, there is a stay.
Where is the stay?
The order of stay, my lords, on.
Yes. Who are the legal heirs, Mister?
The legal heirs are the wife and the mother, my lords.
And children.
Not the children, my lords. The wife and the mother. What has happened is the Dodda Mada during his work he has passed away, my lords.
Yes.
Wherein successing the legal heirs of the Dodda Mada, the wife and the mother, my lords.
Brother is not entitled.
No, my lords. Brother and sister not entitled because under as per the class 1 here, the brother.
Application is rejected for on that ground.
Yes, my lords. On the very clear ground that under the class 1 here, even if.
Where is your friend, Mister? Where is your friend? Furnishing a PF issue notice to respondent number 3, 4 for second time. Postal Chera neither. Yes, Mr.
In fact, the respondent number 2 and 3 have already deposited the money before the execution court.
They are not necessary party.
Yes, my lords. At the time of withdrawing, they have filed frivolous applications. 12 applications they have filed with the same contention, wherein they have been making unnecessary contentions.
They have deposited that amount.
Yes, my lords.
You file an application for releasing that amount.
The matter is being stayed by this honorable court.
No, you file it here.
Please, my lords.
Either they will argue or they will permitted you to withdraw. You file it application for direction to release that amount.
Please, my lords.
You file it, yes. None appear. I will also not extend that interim order.
Please, my lords.
None appear for the petitioner. Leave this matter up to 2 weeks.
A short date, my lords, because this
not extending interim order, Mister.
No, my lords. The very reason why I am pleading before this court is the respondent number 1 is 6-year-old. Even to this day, she has no one to look after, and she is doing the wage work, my lords.
I am not extending that interim order.
No, lords. I will plead my case before this sole court that I am in the position to withdraw the money, my lords.
No,
for that reason.
You go and execute that order.
Grateful, my lords.
Yes, I am not entering. Putting in stay. Further execution, so also additional senior stay. No, I am not granting stay. You want yes.
Grateful,
I will only adjourn. Yes, none appears. Leave this matter up to 2 weeks.
Serial number 36 adjourn. 37 disposed of. 38, 39, 40.
None appear for the petitioner. Counsel for the respondent is present. Yes.
37 disposed of. 38, 39, 40, 41 adjourn. 42 Ajay Prabhu M for petitioner, government advocate. 42 Ajay Prabhu.
Yes,
Yes, my lord, I filed a suit for adverse possession against government.
Yes.
My lord, suit is pending, my lord.
Yes.
I filed an application for injunction.
Yes.
My lord, the injunction application is rejected. My lord, now issue is, my lord, that NHA has, my lord, acquired the land. Is, my lord, proceeding to construct, my lord, road. My lord, I just want.
See, you are sued for bare injunction.
No, my lord, suit for adverse possession.
Adverse position against state government.
Government, yes, my lord.
And then that property is acquired.
Now it is, my lord, acquired by NHA. My lord, if I, my lord, the NHA doesn't, my lord, deposit the compensation, I will lose anything. I will lose all, my lord, doors. Hence, my lord, my request is, my lord, the direction to the NHA to deposit the, my lord, compensation amount after determining it in court.
No, that NHL is a party here.
Yes, my lord, it is party.
Yeah,
even before trial court, it is party, my lord.
Yes.
If they deposit, my lord, my.
They passed an award.
Yes, my lord, they passed an award.
That award.
My lord, not in, my lord, in respect of this property, my lord.
Yes.
Because it is a government, that they consider it as government land, they don't pass any order.
That's what,
Award.
if you succeed, we'll direct you to pass an award, that's all.
No, my lord, now the suit is pending, my lord. If they, my lord, if they.
No, unless you declared as an owner, why they have to, it is a government property.
No, that is what, my lord. If they determine the compensation and deposit in the court, they don't release it in my favor.
Mr. Government property, as on today, they will not pass an award. ಅವ್ರೀಗ ಯಾರಿಗೆ ಒರಿಜಿನಲ್ ಓನರಿಗೆ ಅವಾರ್ಡ್ ಪಾಸ್ ಮಾಡೇ ದುಡ್ಡು ಕೊಡಕ್ಕೆ ದುಡ್ಡಿಲ್ಲ, ನಿಮ್ದು ಗವರ್ಮೆಂಟ್ ಅಂತ ಅವಾರ್ಡ್ ಮಾಡಿ ನಿಮಗೆ ಬ್ಯಾಂಕ್ ಇದ್ರಲ್ಲಿ ಕೋರ್ಟಲ್ಲಿ ಇರ್ತಾರೇನ್ರಿ. ಇಫ್ ಯು ಸಕ್ಸೀಡ್ ಯು ಆರ್ ಎಂಟೈಟಲ್ ಫಾರ್ ದಟ್. If you succeed, you are entitled for claiming an award that is there. First, you have to be declared as an owner.
But there will be delay in, my lord,
That is there.
seeking for
First, you
them.
have to succeed, Mr.
Lord, there will be delay in, my lord, seeking award.
No, you
If
are
they determine and deposit in the court, my lord, I would be, my lord, have cause to, my lord, have cause to fight this suit, my lord.
Cannot be directed to pass an award unless you show that you are an owner.
My lord, kindly see, my lord.
We'll say, if you succeed, you can liberty for you to seek for an award and all other consequential benefit as per the law.
That liberty may be granted.
Yes.
Kindly see annexure C, my lord, for that moment.
In this writ petition, petitioner sought ಏನು ಎರಡು ಕೋರ್ಟಲ್ಲಿ ನಿಮ್ಮ ವಿರುದ್ಧ ಆಗಿದೆಯಾ?
ಹೌದು.
ಸೂಟ್ ಫಾರ್ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್.
Adverse possession.
Then what is the stage in the suit?
Now, my lord, it is for evidence, my lord.
Yes, order 39 rule 1 and 2 application reject ಆಗಿದೆಯಾ?
ಹೌದು, ಎರಡು ಕೋರ್ಟಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ.
Yes. The petitioner plaintiff has filed a suit for adverse position against the state government and its authority. Along with that, plaintiff has filed application under order 39 rule 1 and 2. Really government advocate ಯಾರಿಲ್ವಾ? Serial number ಎಷ್ಟಿದೆ? Yes. 42. Yes. ಅವ್ರ ಹೆಸರು ತೋರಿಸಿ, ಅವ್ರು ಯಾರು ಇದ್ದಾರೆ? Yes. Under order 39 rule 1 and 2. The trial court by order dated 7/3/2023 has dismissed that application. Being agreed by that same, the petitioner has filed an miscellaneous appeal number 3 of 2024 before Principal Senior Civil Judge JMFC Beltangdi. The same is also came to be dismissed by confirming that order of the trial court on 2/6/2025. Being agreed by these two order, petitioner is before this court. Learned counsel appearing for the petitioner submitted that during the pendency of this petition, now that land has been acquired by National Highway Authority for formation of the road. Therefore, now he sought for directing that National Highway Authority to pass an award and
Determine and deposit the amount.
determine that award and deposit the same before the trial court. Since petitioner suit for adverse position itself is pending consideration, till that decided, under this circumstances, it is made clear that if petitioner succeeded in the suit, he is at liberty to seek for an passing an award in respect of that suit scheduled property. With that liberty, this application, writ petition is disposed of.
Yes.
Serial number 43, Chandrasekhar Swamy KB.
Petitioners. Kindly, my lord.
For an award before the appropriate authority.
Kindly, my lord. Serial number 35, my lord.
35,
my lord. I'm appeal for the petitioner, my lord. Interim order is there.
Interim order will be extended.
Yes, sir.
Yes, sir.
Much of it.
For petitioners, my lord.
43, office objection.
Yes.
My lord, this writ petition is the.
What is that
Impleading
office objection?
Applicants. Office objection is with regard to the petitioner has to file the independent writ petitions. The common order was passed.
What fee ಕಟ್ಟಿದ್ದೀರಾ ಎರಡಕ್ಕೂ?
Petitions. ಎಲ್ಲದಕ್ಕೂ.
How much you have paid?
500 rupees.
Yes.
Other office objections complaint.
Yes, what is this, Mr.?
My lord, in a
Is accepted
suit
office
for
objection.
the respondent number 52 to 56 have filed the suit for declaration and permanent injunction. And the respondent number, they have filed they have sold the suit scheduled property in favor of the respondent number 1. Thereafter, the respondent number 1 has formed the layout and sold the property in favor of the respondent number 2 to 49, my lord.
No, you are the.
I am also one of the purchaser of the site in the same layout.
Yes.
Therefore, these petitioners have filed the impleading applicants. Their rights and interest is involved. Though the counsel for the plaintiffs submitted that he has no objection to allow the application. Suit for declaration and permanent injunction.
Then why the trial court is rejected? Where is that?
During the pendency of the suit, the petitioners have purchased the property. Only on that ground, it was dismissed.
Where is that order, Mr.?
Annexure E1.
Yes.
Annexure E, page number 216, my lord.
ಏನ್ ಇಷ್ಟೊಂದು ಲೆಂತಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ? Yes, you take notice. Yes.
Please, my lord, I filed the memo on 25th June 2020-25 to dispense the notice to the respondent number 1 to 49.
ಮತ್ತೆ ಯಾರಿಗೆ ನೋಟಿಸ್ ಆಗ?
1 to 51.
ಮತ್ತೆ ಯಾರಿಗೆ ಬಾಕಿದವರಿಗೆ?
Baki 52 to 56. Who are the plaintiffs? I may be permitted to serve the copy to the counsel who appearing for the trial court.
Dispensed. Issue emergent notice to so and so respondent. In addition, petitioner is also permitted to serve a copy on counsel appearing for so and so respondent before the trial.
Serial number 44, Vivekar.
Yes, awaiting service of notice to respondents.
Yes, sir, the hand summons to respondent, my lords.
When?
Same is not put up with the file, my lords. We have filed on 2nd March.
Yes, learned counsel for the petitioner submitted that. They have served an hand summons. Hand summons notice ಕೊಟ್ಟಿದ್ರಾ?
ಕೊಟ್ಟಿದ್ರು.
Not order ಇದೆ ಕೊಡಿ.
On 2nd March, we have filed in the counter, my lords.
Summons order ಆಗಿದೆ. Petitioner is permitted to take out hand summons. Counsel appearing for the respondent ಗೆ ಹೆಂಗ್ರಿ hand summons ತಾಣ?
No, my lords, we have served the respondent's party in, my lords.
Party ಕೊಟ್ಟಿದ್ರಾ?
Yes, my lords, we have filed in the counter also.
Yes.
Office may be directed to put up.
Learned counsel for the petitioner submits that he has served an hand summons to that party.
For all the respondents.
All the respondents.
For all the respondents.
Yes. And he has also produced the acknowledgement before the, in the office to verify and proceed further. When do you want?
My lords, any date may be fixed.
Yes, this matter on 17th.
Grateful.
Yes.
Serial number 45, disposed of. 46, adjourn. 47, Rani KN for petitioner. Sapna N. Nair.
For the petitioner, my lordship.
Hearing to respond to your lordship.
Office objection is not.
Needful has been complied, my lordship.
We had filed a memo reporting the death of 4 respondents, your lordship.
Yes, Mr. You have to take.
Please, my lordship.
Yes, when memo is filed, madam? Compliance of the office objection.
22 February, my
Last date we have filed the
take a
memo.
copy of the annexures. Adondena? Yes, submission is accepted, office objection is overruled. Memo illide. Learned counsel for the respondent has filed a memo reporting death of respondent number 7 and 8.
Respondent number 5.
Respondent number 5, respondent number 7 and 8. 3 ಜನನು ತೀರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ.
4 ಜನ, your lordship. 5, 6, 7 and 8.
Submitted
On
that
1 to
respondent number 5,
2026.
6, 7, 8.
Yes, your lordship.
Yes. ನಮಗ್ ಡೇಟ್ ಹಾಕಿಲ್ಲಲ್ಲ. Filed a memo on 24 February 2026.
On 21 to
Reporting death of respondent number 5, 6, 7, 8. Learned counsel for the petitioner placed 2 weeks time to file necessary application.
Please, my lord. Interim order may be kindly extended.
Interim order granted earlier is extended till next date.
Please, my lord.
48, adjourn. 49, B. Sharat Kumar.
A favor of
Yes.
petitioner.
Awaiting service of notice to respondents.
ಇಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ ಎಸ್ಟರ್ಡೇ.
ಯಾರು?
ವಿಜಯ್ ಕುಮಾರ್ ಅಂತ ಕಾದ್ ಲಿಸ್ಟ್ ಅಲ್ಲೂ ಬರ್ತಿದೆ.
ಅವ್ರ ಹೆಸರು ತೋರಿಸಿದ್ದೇನ್ರಿ? ಏನಾಗ್ಬೇಕು ಅವ್ರು ಇಲ್ಲಲ್ಲ ಈಗ? Interim order is there?
Yes, sir.
Yes.
Extended.
Leave this matter after 2 weeks. Interim order granted earlier is extended till next date.
Then number 50, Viresh
On the
Rachappa.
petitioner, my lord.
Awaiting service of notice to.
My lord, respondent number 2, my lords, was ex parte before the court below.
You want to dispense?
Please, my lords, I'll file a memo, my lords.
Yes.
Lord, the challenge is, my lords, to an application, execution petition and the order passed on order 2152, sir.
Yes, ready, mister.
ಪೆಟಿಷನ್ ಕಾಪಿ ಸರಿಯಾಗಿಲ್ಲ ಸ್ವಾಮಿ ನಮಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್.
Stay ಇದೆಯಾ?
ಅಲ್ಲ ಅದಕ್ಕೆ ಸ್ಟೇ ಪ್ರೆಸ್ ಮಾಡಬೇಕು ಸ್ವಾಮಿ. I'm surprised that not PF has been paid. ಆಫೀಸರ್ ಕೇಳಬೇಕು ಯಾಕೆ ನೋಟಿಸ್ ಬರೆ ಕೊಟ್ಟಿಲ್ಲ, ಕಾಪಿ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ.
ಇಲ್ವಾ ನೋಟಿಸ್?
ಬಂದಿಲ್ಲ ಸರ್.
ಮತ್ತೆ ಹೆಂಗ್ ವಕಾಲತ್ ಹಾಕಿದ್ರಿ?
ಪಾರ್ಟಿಯಿಂದ ಬಂದಿದೆ ಬಟ್ ಪೆಟಿಷನ್ ಕಾಪಿ ಸರ್ವಾಗಿಲ್ಲ.
May I make a submission? I'll serve another copy on him. I have no difficulty. This is an execution petition. But I am a statutory authority discharging my functions under the provisions of Karnataka Protection of Interest of Depositors Act, my lord. Well, under this act, my lord, any person who has deposited the money, my lords, with a financial establishment, there's a mechanism given under the provisions of the act. The government, my lords, issues a 3-2 notification, which is an ad interim attachment. Then I go before the honorable special court. Then, my lords, it's made absolute or the 3-2 notification is rejected.
What is that execution?
Illi, nan suit alli, I'm not made a party. In the execution petition, I'm not made a party. The financial establishment, which is the defaulting agency, they have been made a party. Now they file an application in the execution petition that I am holding the money on behalf of the financial establishment. Hence, I should be directed, the statutory authority should be directed to pay them the money. But I file my objections before the honorable court, saying that I'm neither a party to the original suit nor a party to the execution petition.
ಏನಾಯ್ತು ಈಗ? ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ?
ನಮ್ಗೆ 28 lakhs ಅಲ್ಲಿ ಕೊಟ್ಟೆ ಹೋದ್ರೆ ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡ್ತೀನಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Stay further proceedings. You give a copy to him.
Today itself I'll submit, my lord. You, my lords.
Stay of further proceedings in execution petition number
4319 of 2018, my lord.
19 of 2018 pending in the file of 31st additional city civil and session judge Bangalore till next date of hearing.
Oblige me.
Yes.
Till number 51, Vaibhav Ravi Malimat.
Yes. Memo is taken on record, dismissed as withdrawn.
Till number 52, Arjan. 53, VB Shivakumar.
Respond in this case, my lordship. My lordship, in the order 32 rule 15, my lordship, allowing the trial court, my lordship. Trial court ಅಲ್ಲಿ order 32 rule 15 file ಮಾಡಿದೆ. It's allow, my lordship, in favor of me, my lordship. In between this, my lordship, honorable court has passed.
No, ಏನ್ stay ಇದೆಯಾ ಇಲ್ಲಿ?
Yes, my lordship, stay ಇದೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
Yes. None appear for the petitioner.
This is our 2 months in the stay ಇದೆ, my lordship, ಬರ್ತಾನೆ.
Trial court not proceed further the matter till next time. None appear for the petitioner. And office objection is also not complied. Counsel for the respondent is present. Please this matter after 2 weeks. I will not extend the interim order. Yes.
Date fix ಮಾಡಿ.
ನಿಮಗೆ ಯಾಕೆ ಡೇಟ್ interim order extend ಮಾಡಿಲ್ಲ? You want yes.
Much apply, my lordship.
Please this matter after 4 weeks. Yes.
Till number 54, Arjan. Till number 55, Kalpana PV for petitioner, connected matter.
Serial number
53.
50?
53.
53 ಏನಾಯ್ತು?
2 weeks ಅಂತ ಹೇಳಿ, 4 weeks ಅಂತ ಹೇಳಿ.
53. No, that Shivkumar, you are appearing. Yes, yes. Where is that complaints of order, mister? You come this side. No, you are for the petitioner. Yes.
I was for the petition.
Office objection is not complied, mister.
I do it, my lord, but not, it is.
Court fee is not paid.
No, there's only one thing that was raised, my lord. There are 3 applications. Court says I must pay, I paid separate court fee. The common order is passed. On the common order, I have paid the court fees.
No, all application different court fee is paid.
Yes.
Clearly the court fee is
300 rupees I have paid separate court.
DCF of 100 rupees.
ಇನ್ನು 100 rupees ಕೊಡ್ಬೇಕು ನೀವು.
Adu also, that is also paid.
You verify, then what is that matter?
Order 32 rule 15, my lordship. On the ground, my lordship.
That's a question which has to be answered by this court.
Yes.
Whether a person who is suffering from mental illness, whether he has to secure a certificate from the mental board and then present saying that he is mentally ill or not. But there's some evidence that is recorded with the trial court. My lords have to hear this on detail and whether the learned judge is correct in allowing the application.
Application is filed under order 32.
32 rule 15.
Kodi, kodi, kodi. Suit for,
Partition, my lordship.
who are you?
I am the wife of the husband, my lordship.
Wife of-
Plaintiff wife, my lordship.
Plaintiff
But the
wife.
wife says the husband is mentally ill. He is suffering from schizophrenia
Yes.
and he is not able to represent himself personally. She has only produced certain medical reports with regard to that.
No, if he is not, then in spite of that, independently, she can't file any suit.
She cannot file a suit. They have sought for such a relief.
What is that relief they have sought?
Relief for partition and separate possession on behalf of the husband.
No, she herself can, she can.
She has only sought for appointment of the guardian.
Yes, my lordship.
No, she can't file any independent suit for seeking a partition, mister.
No,
my
she
lordship.
can't file it.
She can't.
Yes, kodi,
Niman's also stating, my lordship, I have paranoid schizophrenia. I'm treating last 20 years, my lordship. Niman's also added, I'm
No.
till
No, what is the law required? Whether you want to produce the certificate or your affidavit is
But
enough?
the law required is under the Mental Health Act, there is a board. The party must be sent to the board. The board must give a certificate for
Application filed under order 32.
yes, my 32.
32 rule
Kindly
15.
CPC can order 32 to 15, my lordship. As clearly stated law, my lordship.
Not
In-
on 32, not order 32. No, you are the brothers.
Yes,
Are you?
there is
disputing
already
that?
a partition.
That is true.
There is already a registered
No,
partition.
that will dispute on that merit.
Yes,
Are you
ma'am.
disputing that your brother is not mentally distinct?
I am saying my mother says, mother of the plaintiff says that he is mentally sound and he is capable of speaking by himself.
Then
Court
why-
does not examine him.
No, why he is not coming before the court then if it is?
But he could have come to the court. The learned judge should have examined him physically, personally, whether he is capable of speaking
No,
or
I'm
not.
asking that if he is personally capable, why he is sending that wife and keeping?
That
Now, what benefit he will get it? That's what that.
the benefit is,
FID for that.
the benefit is the wife is a modus operandi in this case. She wants to create a problem in the house.
Yes.
The husband is capable of taking care of himself.
Trial court, small submission, my lordship.
32,
Trial court records, my lordship. Kindly peruse the 96 page number, my
See,
lordship.
what is that order say?
Yes, my
Law
lordship.
says, order 32,
Rule
rule
15, my lordship.
15. Yes. Apply person unknown, unsound mind, rule unsound. So far as may be applied to the person adjudicated before jurisdiction of the suit, sound mind shall also apply to person who is not adjudicated before the court. An inquiry to be capable with person or mentally inquiry, protection of interest. Inquiry should be conducted.
Yes, ma'am. Inquiry also conducted, my lordship. And they have examined the doctor also, my lordship. I have also examined. The doctor clearly stated, my lordship, in cross examination, my lordship. Kindly peruse the DW2 cross examination, my lordship. Trial court records also bandide, sir.
Yes, bandide. And then we will hear, Mr. We'll hear that.
Please, sir.
Yes, we'll have it on, your question.
ಸರಿ ಇವತ್ತು 4.
Yes, 12th. 12th we'll hear that.
12th.
Top of the table, my lord.
No, it will come, Mr. We'll hear.
Interim order be extended. There's an
Interim order
interim
may be
order.
extended till.
Much obliged, my lordship.
What are the other office objections? Typed copy
That's
of
the only
case.
office objection.
More than one IAS challenge to be clarified. Court be to be paid. If it is paid, Mr.
Is paid.
Yes.
Much
Yes.
obliged, my lordship.
Up to 25. Serial number 54 adjourned, serial number 55. Kalpana PV.
I am for the respondent number 7 and 8 in this case. More cases already settled ಆಗಿದೆ sir.
55.
Joint memo filing.
Settled.
Yes, my lord. ಎರಡು ಮ್ಯಾಟರ್ ಕ್ಲಬ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಒಂದು ಮ್ಯಾಟರ್ ಮಾತ್ರ there is a
Dispose, please.
ಅಲ್ಲ ಏನು ಇದಾಗಿದೆ?
actually suit for specific performance, my lord. They have disputed for the agreement.
ಮೂರು ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ?
More is a different contention. One is the main is the commercial appeal, another IA on IA. Therefore,
ಇನ್ನೆರಡು connected ಇದೆ.
ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂತಾ
yes,
ಇದ್ದೀರಾ?
please.
Already settled, my lord.
Agreed.
ಕೋರ್ಟ್ ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. Then it become infructuous.
ಅಲ್ಲ ಇಲ್ಲ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಇನ್ನೂ ಸೆಟ್ಲ್ ಆಗಿಲ್ಲ. ಇದರಲ್ಲಿ ಇನ್ನು ಲೋಯರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇನ್ನೂ ಸೆಟ್ಲ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. We are filing joint memo here.
As per the joint memo, matter may be disposed, please.
ಅಲ್ರಿ ನೀವು ಸೂಟ್ ಅಲ್ಲಿ ಹಾಕಬೇಕ್ರಿ.
ಇನ್ನು ಅಲ್ಲ suit already disposed, my lord. Execution is pending, my lord.
This is under execution.
Yes, my lord. Yes, my lord.
Yes, order is challenged under the execution.
Yes, my lord.
ಏನಂತ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಈಗ?
They have already executed the sale deed, my lord.
Executed the.
Yes, my lord. Yes, my lord.
Then this petition will become infructuous.
Yes, my lord.
ಕೊಡಿ ಅದು ಕೊಡಿ. ಎಲ್ಲಿದೆ?
After filing of the writ petition, they have executed, my lord.
Executed.
Yes, my lord.
Yes. The parties has filed a joint memo stating that pursuant to that degree passed in OS number
1718 of 2024, my lord.
718 of 2024 dated 16/4/2025.
Yes, my lord.
They have executed that.
Yes, my lord. Please.
An agreement of sale.
Yes, ma'am.
Executed sale deed. The joint memo produced is taken on record. The same is extracted below. In view of the above writ petitions are disposed of.
Yes, my lord.
All three.
Yes, my lord. Yes, my lord. All the parties are present now.
Yes, all the parties are present. Signature in but a compromise in Allah.
Yes, ma'am.
You are saying that you are settled there.
Yes, ma'am. Much obliged.
Pending application,
All pending applications are disposed of.
office objection. Serial number 56, Prasanna K.
Process is paid by this morning.
Yes, madam. Needful has been done.
Interim order may be extended.
Just to verify and proceed further, interim order granted earlier is extended till next day.
Please.
57, P. Sheshagiri Rao for a petitioner, connected matter, A. Sampath.
For respondents.
Furnishing a PF.
Plus, those are other defendants may not be
Which may
necessary.
be
I am the
dispensed,
only
my lords,
contestant.
only contesting respondent is already present before this.
They come up with this present petition. And second matter, my lord,
My lord, suit for partition and consequential relief of
Suit for
permanent.
partition.
Please, my lords.
What is that amendment you have filed, Mr.?
plus
Now, my thoughts.
I filed the amendment, my lord, to include, my lord, earlier there was a partition, and my lord, based on that partition, my lord, there was sale deeds, and I am the purchaser of that document. I want to plead, my lord, those documents, those relating those details, my lord. And about the sale deeds, that's all.
My lords, here they have come on record after the demise of defendant number 15 before the trial court, my lords. They claim that they are the legal heirs of the defendant, but however, they are the brothers of the defendant, my lords. When they filed an application.
First thing is, their application for impleading is allowed.
Please, my lords,
Please,
we are
my
already
lords.
party.
You can't raise that objection that he is a brother or other things. Now, only thing is that, what is the wrong in that allowing his application for amendment?
We'll address the arguments tomorrow or day
Plus that
after.
amendment, my lords, I filed a separate written statement, my lords, after my impleadment. They did not object it.
What is the stage?
My
But
lords,
now they filed some application to recast the issues. That is posted for orders.
You know, discussing issue on this basis also now.
Lords, everything will be carried out, my lord. Let them have their written statement.
Is there any stay in that suit?
My lord,
There
this
is no
interim, the order has been stayed, my
No,
lord.
will stay that suit itself, madam.
No,
If it is order is stayed, if it is proceeded, then it will,
but
prejudice is right.
no, my lord, so
Will
my,
grant the time, but not proceed with that suit also.
lords, that will harm me, my lord,
Please,
because,
please, my lords,
no,
that
my lords, that will harm me because I objected to that.
next date is
No, I'll
on
just conclude.
4th.
Lords, after written statement, it was amended. I produced additional documents that was allowed. I was cross-examined.
Then we'll.
My lords,
when do you want
earlier
to-
there
yes,
was a
when do you want-
my lords, earlier there was
No,
a
when do you want?
Lords,
any
next
date in
week,
the
some
next
date,
week,
my
my
lords.
lords.
Yes, this matter on 26th, yes.
For my lords, just
request
to
on-
bring to the notice, my lords, the earlier writ petition was filed by us seeking the
No, madam,
relate.
now he can't say that he wants to have a cake and he want to eat. See, if he don't want to stay that suit, but he wants to that.
Lords, stay adre, my lords, ಏನಾಗಿದೆ, my lords.
Then you have to wait, then they want.
Please, my, because we objected the 17th, it could, please, 17th, it could
It
be
is
taken.
on 4th of April, my lords, next date,
Why fourth, madam?
before the trial court, for the orders on the striking
Or
of
18, my lord,
application.
may just trouble someone.
ನಾನು
24th.
26 ಹೇಳಿದೆ.
26, yes. Yes.
ಇದ್ರಲ್ಲೂ
You are filing an application to delete that.
I'll file the memo, my lords.
Kodi. So and so, Learned Council has filed a memo. You are appealing for which respondent, mister?
My lords, I was entered K waiter, my lords, for respond. In the first matter, my lords, I am respondent number 17. I am already on record, my lords.
On 17.
17 and 18 I represented.
17 and 18.
Please.
All others you are dispensing.
Please, please.
Except 17 and give memo kodi.
Connected matter.
First taken on record dispensed. ಎರಡನೇ ಮ್ಯಾಟರ್ ಅಷ್ಟೇ
Same, my lords. I am my application, my lords.
One matter is for 6.
is R1 to R5 ಇದೆ.
One matter is for 6 rule 17, my lords. The other one is for recall and reopen.
50.
ಯಾವುದು ಅಪ್ಲಿಕೇಶನ್
57 sir.
57 the matter. Yes, 57. Yes. All other is dispensed at the risk of the petition. Yes. Memo kodi ಎರಡು.
58 urgent, 59 Alabakasham.
Petitioner, my lord, defendant's writ petition, my lord. Suit
Office
office objection comply ಆಗಿದೆ. IA number 1 incomplete ಇತ್ತು. Replace ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ ಹೊಸದು. Annexure A was incomplete.
A to be made as a series.
Replace ಮಾಡಿದೀನಿ ಅದು correction ಮಾಡಿದೀನಿ.
Petition. Copy to be filed to verify that LRs of the petitioner. Yes. Annexure to be made as a series. Yes. What is this?
Cure ಆಗಿದೆ ಸ್ವಾಮಿ.
Yes.
Now defend this matter, my lord. Suit for specific performance decreed ex parte, my lord. Page
Yes.
61 is the ex parte judgment, my lord.
Yes.
Lord, this is a residential house, my lord. Page 68 is a photograph, my lord. My lord, the respondent, my lord.
Who are you?
I am the owner of the property, my
No,
lord.
you are the defendant.
Defendants, my lord.
Suit for specific
Suit for specific performance. We were placed ex parte, my lord.
By ex parte, notice is not served.
What is not served? I filed previously. I filed one writ petition, my lord. That writ petition order is annexed, my lord. Page 31, my lord.
Elli the finding why you have been placed ex parte.
Please, my lord.
Feed so and so executed sales.
Address incomplete, my lord. He gave some wrong address and he has taken, my lord.
ಆಯ್ತು
Only,
ಆಮೇಲೆ ಈಗ ನೀವು ಮಿಸ್ಲೆನಿಯಸ್ ಪಿಟಿಷನ್
ಈಗ 9 rule 13 is pending, my lord. In 9 rule 13, my lord, I filed an application for stay, my lord. That application, my lord, despite 45 adjournments, my lord, my application is not heard, my lord.
Now you are seeking only a direction.
Mandamus for dispose of the IA and the petition, my lord.
Yes. This writ petition. Petitioner sought following relief. The respondent herein has filed an suit for specific performance of contract in OS number 26573 of 2013. Before, where is the degree?
Page 61 is the judgment.
Before 28th additional city civil judge Bangalore. Thus, petitioner herein has been placed ex parte and suit has been decreed. By judgment and degree dated. Dated like
22/3/2014. 22/3/2014.
2014. 22/3/2014. Thereafter, the petitioner has filed an application under order 9 rule 13.
Annexure D.
Annexure D.
Page 43.
In miscellaneous petition 25005 of 2023 and also filed an application under 151.
Please, my lord.
151 for stay of the judgment and degree. The application, the miscellaneous petition has been filed on 10/11/2023. 10/11.
Please, my lord.
31/1/2023. So far, no order has been passed. Therefore, petitioner seeking direction to dispose of that petition as well as application as expeditiously as possible. In view of the above, without expressing any opinion on the merit of the case, the trial court is directed to dispose of the miscellaneous petition. Filed service agidi ellarigo.
Service agi record al bandide sir.
Yes, filed under order 9 rule 13 in miscellaneous petition 25005 of 2013 as expeditiously as possible, not later than 6 months from date of receipt of copy. Submission is accepted. Office objection.
Serial number 60 adjourned, 61 Harsh S. Parekh, 61.
Due for the petitioner, Your Honor.
This case.
Awaiting, you are taking notice, Mr.
Also an application for vacating.
Yes.
My lord,
Two weeks time to file my objections to the vacating
You are
interim.
taking notice to whom, Mr.?
1 to 3, my lord, respondents 1 to 3. Who are the contesting respondents because they were the plaintiffs in the trial court. My lord, may.
Your Honor, I was served with papers yesterday.
Wait, Mr.
Please.
Khanna. Yes. So and so is undertaken to appear for
1 to 3.
respondent number 1 to 3. Submitted that he has filed an application for vacating that interim order.
Please.
To verify and post this letter on 12th.
Please.
Yes.
Please.
Interim order may be extended. Your
Interim order granted earlier is extended till next
Great.
year.
Public.
62 adjourn, 63 adjourn.
62, my lord.
Sunil S. Narayan.
62, my lord, I have filed a wakalat. My name has not been shown.
Therefore, they have taken time to service is not completed.
My lord, there is an interim order. It is most frivolous, my lord, the petition.
Application haki vacating. If you file a vacating application.
If a date is given, my lord,
ಯಾವತ್ತಿಗೆ ಹೋಗಿದೆ ಅಷ್ಟೇ ಹೇಳಿದೀವಿ.
ಅದಕ್ಕೆ ಒಂದು date may be given, my lord.
Avoid service ಅಂತ ಹೇಳಿದ್ದೀರಾ ಸರ್?
ಸೈನ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. Yes. Post this matter on 17th. Yes. In the meantime, file a vacating.
Yes, my lord.
63 adjourn.
Serial number 60 interim order to be kindly extension. Serial number 60.
60 ಏನಾಯ್ತು?
Interim order extension. ಅದು actually adjournment ನಮಗೆ ಹೇಳಿಲ್ಲ. So without the information, they are taking the adjournment.
Waiting service of interim order extend ಆಗಿರ್ಬೋದು. Wherever interim order is there, will extend.
63 adjourn, 64 Sunil S. Narayan.
64 for petitioner lordship. For petitioner lordship.
Awaiting service of notice.
I paid the court fees on that day. What date only?
Court fees paid. Yes. Interim order ಇದೆಯಾ?
Kindly extend interim order.
Interim order granted is extended till next date of it. Yes.
Ides only.
65 adjourn, 66
Yes.
Akshita DJ.
66, I appear for the petitioner, my lords. It says await
Awaiting
for service, my lords, that interim order be extended and any date may
Interim
be
order.
fixed, my lords.
Interim order granted earlier is extended till next date of it. Yes.
Any date, my lords, in next 2 weeks.
Petitioner.
Let the service, after service, you can move that matter. Yes.
Great.
57 PS Venkata Subbarao.
Petitioner, my lord. Await services.
Awaiting service.
Interim order may be extended.
Interim order granted earlier is extended till next date of it.
68 Bharatiyam.
My lord, in this case, it's a suit for partition of 1980, my lord. Still, it's pending before the trial court, my lord. The previous bench has the coordinate bench has deferred for just a week, my lord, on 17 and directed us to serve on the contesting respondent, my lord. We tried to contact the advocate and we couldn't serve on the advocate, my lord.
Lordship, it is one matter. Kindly see the order dated 20th, my lordship, 20th February. On that day, the coordinate bench of this honorable court is pass
They
an
are the
order
contesting
to
respondent.
pass and hand over the hand summons to the 82 and 83. Rest of the defendants are dispensed of.
Yes, ma'am.
I am the contesting the respondent in the original suit, defendant, and also here itself also. I am arrived as 18, 19, 20 as a respondent here itself only. Kindly recall that order. I am going to contest the case, my lordship, in this case.
Yes, madam, why you are dispensed?
My lord, in this, I have
All
prayed for-
response, 87
There is
response are there.
2 IAs, my lord. I have challenged on 2
Whatever it may
IA.
be.
Common order has been passed. Let me explain it, my lord. The IA is against with regarding
Knowing
to
fully well we are the contesting defendants. Property is also joint family property.
If it is make out that contesting respondent notice is dispensed.
Dispensed.
Petition itself will be dismissed because the notice is not served to them.
My lord, with regarding to this is IA, we propose for a defendant, my lord. That defendant have filed their objection.
Suit for?
Suit for partition, my lord.
Yes.
My lord, this is a suit for partition where Malamma is the plaintiff who has contested the suit, my lord.
Adjournment, sir.
Filed the suit for partition in 1980, my lord, challenging the partition deed executed in 1956, my lord.
That is not the matter. Lordship,
What is that?
One of the property is not added, my lord. In 2019, Malamma has
No, what is the prior in the suit you show me? Plain.
1/3 share, my lordship. They are seeking a 1/3 share. That is the relief, main relief. There are 3 branches, my lordship. in
Sir,
this.
Harsha. ಹರ್ಷಿತ್ ವಶಿಷ್ಠ ಮೈಕ್ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ನಿಮ್ದಲ್ಲ ಸರ್, ಅವ್ರಿಗೆ. Lordship, here it is a 3 branches.
Properties are, huge properties are involved in this suit.
My lord,
4084 440.
ಅವ್ರು ಹೇಳಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಿದಾರೆ ಅವ್ರು.
I am the
ನಾ ಮಿನಿಮೈಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ
Wait,
ಅಷ್ಟೇ.
wait,
ಎರಡೇ
wait.
ಮಾತು.
Yes,
My
what
lord,
is the
I-
suit for?
suit for partition, my lord. I have prayed for one-third share in the property, my lord. Suit has been pending. I have filed in 2019 one IA. One property was missed out.
You are for the plaintiff.
Yes, my lord.
You
I
have
am the
filed a
plaintiff.
suit for 1/3 partition.
Yes, my lord.
Now that, what is that order you are challenging here?
My lord, I filed IA 34, my lord. That is order 6 rule 17 for amendment and incorporation of one of my property which has been left out. That IA was being disposed very recently, my lord. On 17 January 2026. In 2019, I have filed this IA, my lord.
Yes.
And it is disposed in 2019. Again, I filed another IA. This property is entered into an agreement. That is respondent number 82 and 83 are agreement holder, my lord. These two agreement holder filed their objection. This property has to be incorporated in suit for partition. That is my overall prayer, my lord. So they are the contesting respondent who said this property is already entered into agreement, and the present plaintiff who is contesting on behalf of Malamma, he is a person who is given in adoption, my lord. His natural father has entered into an agreement to say,
Yes.
I am an adopted son. I didn't get share in the property.
Anyhow, that he wants himself come on.
Let him come on record. I don't have any objection, but others are not necessary.
Recall the document.
Yes, you will take notice to whom, Mr.
18, 19, 20.
Let them take only for 18,
18, 19
Others are
and
not
20.
necessary, my lord.
18,
19 and 20.
so and so is undertake to appear for 18,
Ah,
18 alla?
8, 18, 18, 19, 20
18, 19 and 20.
in respondents.
Yes, office is directed to show his name.
Yes, number code.
My lord, one small request, my lord. Tomorrow the cases for evidence. This is a property should be added, my lord. If the evidence proceed means again for this property I have to recontest, my lord.
We'll do it. We'll give it a permission.
ಲಾರ್ಡ್ಶಿಪ್ ಇದರಲ್ಲಿ
Yes, my lord, for further proceedings.
ಇದರಲ್ಲಿ ಒಂದು ಸಣ್ಣದೊಂದು ಇದಿದೆ 17/2 ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್
ಆಯ್ತು, stay ಕೊಡೋಣ.
ಸ್ಟೇ ಕೊಡಿ. Yes, no problem. Further proceedings stay.
Stay of further proceedings in OS number 8024 of 1980.
80.
Pending in the file of
66.
Additional city civil judge Bangalore in estate of.
Oh, oblige, madam. Oblige.
Yes.
Sir, name. Serial number 69, Purushottam Bajaj, party.
Where is your advocate?
My lord, can I submit a few papers? I went to Mr. Arun Ponapa's office yesterday. He said, give me some more time. I have to study the matter. I cannot just say. I would like to submit
You give a time for him, mister. He will.
judgments of the Supreme Court where I have appeared.
No, mister. You have approached that council.
I have approached the council, but you know,
let him prepare.
my problem is that I am 69 and I had a heart attack 3 years back and I am on medication.
After explaining that,
Now my tension
petition
is, my
is not
tension
meant-
is growing. All like how my lord gave us a stay, give me also stay, and
no,
I will,
no.
I will give the reasons. Kindly see the
unless
Supreme
petition
Court
is
orders.
maintainable, unless petition is maintainable, office objection is complied.
My lord, I
Whether
have
you are a
complied,
party
I
in
have
person
complied all
or
the,
an
all the,
advocate
I have complied,
or anybody will not.
I have complied with all the office objections.
There are other 4 office objection is there.
Which are created today, my lord, which I will comply tomorrow. They will
Comply, you
they
comply tomorrow, yes. You comply tomorrow, we'll have it on Monday.
My lord, my pressure is building up. 13th is the judgment. Just here, the order that my lord wanted, I have given that order. Just have a look at that order.
No, I will look at only office objection is complied.
My lord, in other matters, the objections go to the registrar and they all waive that objections. I
You go and register, if they are waived it, that is good, yes.
My lord,
They have raised it.
my lord, just look at these papers, my lord. See, these are the papers which we used to use. Now we have changed and we have put a display board. See, these are all the papers. You know, cause list hanging outside. Now we are putting a display board.
No,
We are
see,
moving.
I'm
The writ
saying
petition, the writ petition
what is
which
the-
I am talking about is lying in the record room, waiting to be destroyed. All I am saying is get it here.
Sir, if you want to argue, the office objection is, it is not maintainable, I will consider, if it is not made out in a case, if I dismiss, then you can't make any this thing. Otherwise, I will impose a cost. If you want to argue, I will argue.
Yes,
Therefore, I
my
said
lord,
you
I'm
take an-
willing to pay the cost, my lord.
Yes.
I have a very good case on merits, my lord.
Yes, what are the office objections?
Now, the very first is the impugned order.
Mr. Counsel, Mr. Party in person, you make in a party, R2 has to be make in a party. Why you are not made as in party?
R2 is the judge whom I'm seeking a transfer against. So let her also come before the court and tell why she's ignoring the orders of the higher.
Yeah, under the law, you cannot make in a party. Therefore, I am telling that you are a party in person. If you want, you take an instruction. Otherwise, you will face the consequence. You don't know what is the procedure of law. I have explained that. Then you said I will contact in a party lawyer. Now you are saying that. Then I have no other alternative. I will hear you. I will pass on a legal order. Then you have to be faced. You are making a judge as in a party.
My lord, she has disobeyed the orders of this honorable court.
Sir, I am saying that if it is disobeyed and all, lawyer knows how to file in a case, how to get over that order. Therefore, I said you have any financial difficulties? You said no, there is no financial difficulties. Then go and otherwise we can say that go to that legal service authority. You said I am capable of engaging the lawyer. You engage the lawyer and they will do it.
My lord, he is saying I have to
losing
study the case. It's a big case. I will take some time. What I am trying to show, my lord, are some Supreme Court judgments where I have myself appeared.
Mr. I will, otherwise you will lose your case. Otherwise you will lose the case. If you want to engage the counsel, do it. Otherwise.
My lord, I have a very good case on merits. There is no question of losing the case. There may be some small procedural mistakes like my lord pointed out yesterday.
Not small, mister. You cannot make a judicial officer as a party in this case, mister.
I will remove that. By Monday. I will remove that.
Yes. Then what is that second?
But the second thing is, my lord, just see the impugned order at page 45, my lord.
Copy of the miscellaneous to be filed. What is that order you are challenging? You are not filing that copy.
No, it's there at page, the certified copy is at 45 and 46. What my lord asked yesterday, I bought the certified copy today. Page number 45.
What is the relief sought in this petition?
She's ordered for a judgment on 13(3).
What is wrong in that?
Page 45. I will tell my lord, there are three things which are wrong in that. This honorable court has passed an order in writ petition, which is attached at page number.
Yes.
At page number 58 to 64. Annexure H.
To written rule in nicer respondent order file and so on, direct that office to produce that complete records placed before this court. Pass an order, honorable court may deem it fit to proper. What is your prayer? Where is your prayer in this, mister?
My prayer is at page number 42, 43.
What is that prayer?
The prayer is to temporary.
Read. Where is your prayer? Read, mister. What is that order on annexure A? Yes, read.
Yes, my lord. The prayer, interim relief, pending hearing and final dispose of this writ petition, be pleased to stay the operation of the impugned order dated 11/2.
Stay on the main prayer.
The main prayer, yes, my lord. The main prayer, para number 1A, writ, issue a writ of certiorari or any other appropriate writ, order, direction, quashing the order dated 11/2/2025, passed by the 40-123 City Session Judge in OS number, and order dated passed by the Principal Judge in Miscellaneous Petition 179. Both the certified copies are attached.
No, order dated 11/2/2026. Where is that order?
At page 45, my lord. Operative patient on the last line.
What is that order dated? Yes, where is that? In which page?
It's dated 14/2.
Page number
45.
45.
The 5 pages of certified copies, the last page is the operative portion,
No.
45, 1 to 5.
Last page is page number
Fifth page of 45, 1, 2, 3.
45.
45, 1, 2, 3, 4, 5, 5 pages order it is, certified copy.
You have made that pagination in that, which is the page, Mr.
Pagination 45.
45 is that order starts.
Okay, see in that page number 5, print out.
There is no page number 5, Mr.
The last page of that order, certified copy.
No, in that your paper book, it will come in that which page, Mr. Ink. You have not made any pagination by in that pen. Which is that page you have to
because in the morning I took permission and I quickly complied with all the objections. So I did not have time to change the entire pagination. So I put 45, 1, 2, 3, 4, 5.
Paper you have submitted to the court, same paper should have been with you also to
Yes.
reference.
45, 5.
45, 5 means what, Mr.?
See, in 45 is the certified copy of the order. In that there are 5 pages, the 5th page and the last line.
Each page you have to be given a number. You can't say that 45 per 5, 45 minus 4. This is not there, Mr.
Okay, I understand this is one more procedure, but kindly have a look at, because look at the last line of the order, judgment for 13-3.
What is the date of that order?
The date of the order is 14-2.
14-2.
14-2. 14-2-2026.
14-2-2026, where is that order?
At page number 45, my lord. Certified copy I have taken and attached today only.
14-2-2026 is not there, Mr. There is no such order, Mr. 14-2-2026 order
The
is
date
not
may be
there.
wrong, my lord. The date may be wrong because of my old age.
Everything is wrong.
But certified,
How can
the
I search
certified
it,
copy
Mr.?
is there, my lord, in front of, the certified copy is in front of the, my lord.
No, in the certified copies, that order is not there. On the date of that order is not there.
Maybe I may be wrong in the, my
You
lord, I
may
may
be
be
wrong
wrong
in
in
what order I have to see, Mr.
that particular at page 45, my lord.
Page 45, nothing is there, Mr. So I mean that what is there in page 45, Mr. Is this matter?
Five page order is there, my lord.
You make it correct, Mr. This matter on day of tomorrow. Same copy has to be with you, that when you are referring that page has to be referred, Mr. Yes.
Hearing interlocutory application matter, serial number 70. This is Sunita for appellant. G. Sridhar.
Yes.
I appeal for the appellant, my lord. The matter is already admitted, my lord. It has to be heard finally, my lord.
Yes.
Date
In
may be
this
fixed,
matter-
is small matter, my lord. It's a suit for partition, my lord.
Why that IA then? Yes, leave
Okay,
this
my
matter
lord, for the stay.
in B group. Yes.
Like RFA, finally.
RFA, RFA, then we will post it for why it is posted. It is admitted already.
Admitted ಆಗಿದೆ ಅದು IA ಮೇಲೆ ಬಂದಿದೆ
Yes. Post this matter in hearing list. Yes.
ಅಲ್ಲ ಡೇಟ್ ಕೊಡಿ ಸ್ವಾಮಿ ಸ್ಮಾಲ್ ಮ್ಯಾಟರ್ ಪಾರ್ಟಿಷನ್ ಪ್ರಿಯರ್ ಟು
Yes,
ಶಿ ಇಸ್
27. Yes.
ಪ್ಲೀಸ್
Serial number 71. Chandrakant Arpit for appellant.
For the appellant in this matter, my lord. My lord,
Yes.
this matter is also admitted. My lord, we have filed the application. My lord, we have produced the survey sketch copy, my lords, which reveals that the property measures only in 958.30 square feet. But
I
the
thought IA
appellant-
will be considered along with that main matter.
Please, my lords. My lords, interim order earlier granted may be extended, my lords.
Yes, post this matter in hearing list along with that IA. Interim order granted earlier is extended till next day.
Number 72. Rajshekhar S for petitioner. Shankar Rai.
My lordship, for respondent number 1, I pray for time in this.
Yes.
72. Rajshekhar S.
My lordship, for respondent number 1, I pray for time. Senior is not doing well, my lordship.
Yes, sir. The request of counsel for the respondent. Respondent,
Respondent number 1, my lordship.
Yes, leave this matter after 2 weeks. Interim order granted earlier is extended till next day.
73. A. Chandrachud for petitioner.
For the respondent, my lord, I filed an application for vacating the interim order.
Yes.
That this is I am the plaintiff. Defendant has filed an application for hit by res judicata. Trial court has rejected. No, it is not res judicata. It's suit has go on the matter on merits of the case. Against that order, the defendant has filed this petition, my lord. So this is a suit for injunction and the order. Judgment, earlier judgment was not binding on me because I am not a party in the proceedings. So therefore it's fairly, trial court has suit for injunction and declaration of the judgment is not binding on me. This judgment is not binding on me. Earlier suit is not, I am not a party in the proceedings. So therefore it is not hit by the res judicata. So rightly it was rejected, the application, and the suit may go on. Annexure A, my lord.
None appear for the petitioner. Leave this matter up to 2 weeks. I am not extending interim order.
10th or 11th.
No, I am not extending that interim order. If
Alla,
not there,
urgency, keep on coming, date may be given. First,
leave this matter on 18th.
much of it.
Bill number 74, Abhishek NV for petitioner, connected matter.
Yes, Mr.
Petition. For cancellation of sale deed. These both petitions arise from orders passed in miscellaneous appeals, arising out of application and order 39 rule 182 seeking for injunction. Yes. Not the suit, the plaint is that
Suit for
cancellation of sale deed.
Yes.
Plaint is at annexure B.
You are the plaintiff.
I am the plaintiff.
Yes.
The defendants are my vendors.
Yes.
They have sold the property to me on by virtue of sale deed, my lord, dated 31/7/2020.
Yes.
After the sale deed came to be executed, my lord, it's an agricultural land. The mutation also came to be made in my favor, and the revenue entries were transferred. Subsequently, my lord, in 2021, the defendants interfere with my possession. Upon inquiry, they say that I have already executed a sale deed in their favor.
Yes.
I investigate and I get to know that a sale deed dated 26/3/2021 is registered in the name of the second defendant.
Yes.
I have sought for cancellation of this sale deed.
Yes.
Now, this sale deed, which is in favor of defendant number 2.
No, what is that interim order you are challenging?
One is an order to not against them to not alienate the property. Another is an order to restrain them from interfering with my possession of the property. This sale deed of 2021.
No, when there is a sale deed, possession is not handed over to him.
Illa, so this is a sale deed based on an unregistered GPA. It is not even notarized. It is on an unstamped paper. This GPA.
ಆಯ್ತು ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಏನಾಯ್ತು ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರ
ಅಲ್ಲ
appellate
court mainly see the reasoning of the appellate court at ink page.
ಅಲ್ರಿ ಏನಾಯ್ತು ಹೇಳ್ರಿ ಟ್ರಯಲ್
court ಅವ್ರು ಏನ್ ಹೇಳಿದ್ರು prima facie case I have made out.
What is the trial
with
court?
kind permission.
The trial court allowed the application for injunction to restraining the defendant from alienating. Insofar as not to interfere was concerned, it was rejected, saying that I have not produced any photographs. Other than Nandan appeal issue, I have preferred an appeal as against the order, rejecting my application not to interfere. They preferred another appeal. Both came to be clubbed together and decided. In the appellate court gives a finding in my favor in all respects. The appellate court says that I have established prima facie title, I have established prima facie possession. The GPA is loaded with suspicion.
Both of them maintain status quo.
One reasoning ಏನ್ ಕೊಡ್ತಾರೆ?
Status quo regarding alienation may be continued, past my lordship. In respect of possession, my lordships, in the plaint, my lordship, they have shown that it is only a plain land, my lordship.
In respect of possession, if you are there, you continue.
5 ಶಾಪ್ ಕಟ್ಟಿದ್ದೀನಿ, ಶಾಪ್ ಅಲ್ಲಿ ನಾನೇ ಇದ್ದೀನಿ.
But continue that. You are not saying that status
With that observation, my lordship.
Yes, status quo as on today, it has to be whoever there in the position, they have to continue.
And as well as there should be an order against them to not alienate the property also.
That is there. That is there. We will say alienate.
That was also
position is concerned. Party has to maintain status quo as on today. Yes. Study. What is the stage in the suit?
Evidence.
Yes. This petition is filed by the plaintiff. Challenging. ಎರಡು club ಮಾಡ್ಕೊಳ್ಳಿ.
Firstly, not to interfere. Second one is not to.
Yes. Challenging. Filed in a suit for
cancellation of sale deed.
Filed in a suit for cancellation of sale deed dated
26/3/2021.
26/3/2021. along with that plaintiff has filed an application under Order 39 Rule 1 and 2.
IA number 1
IA number 1
and IA number 5.
IA number 1 for not to alienate
Not
the
to alienate.
suit scheduled property. IA number 2.
IA number 5.
IA number 5
So,
for restraining the defendant from interfering into the peaceful possession of that respondent. The trial court has allowed IA number 1 and dismissed that IA number 5. Being agreed by allowing that IA number 1, the respondent defendant has filed MEA number
7 of 2023.
7 of 2023. For rejection of IA number 5, plaintiff has filed an miscellaneous appeal 31 of 2023 before senior civil judge and principal JMFC KGF. The first appellate court has allowed that appeal filed by, allowed that MEA 7 of 2023 and dismissed that MEA 31 of 2023, being agreed by the order passed by that first appellate court dated 13/9/2024. The plaintiff is before this court. The suit is for cancellation of the sale deed. The trial court, after considering that material available on record, has rightly passed an order on IA number 1, directing the defendant to not to alienate that property. In respect of IA number 5,
So far as the observation of the first appellate court is that, my lords, Mary a suit for cancellation of the sale deed is not maintainable. They ought to have filed suit for.
yes.
That is the observation of the first
that
appellate
is the
court.
only note.
Yes, yes. In respect of IA number 5 filed by the plaintiff for temporary injunction restraining the defendant from interfering into the suit scheduled properties is concerned. In the interest of justice, the parties are directed to
My assertion that I am in possession of the property by constructing 5.
Parties are directed to maintain status quo in respect of possession of the property till the disposal of the suit. To that effect, order passed by the appellate authority, appellate court has been modified.
ಇದರಲ್ಲಿ ಸುಮ್ಮನೆ the plaintiff has contended that as if it is no construction or the scheduled property, plain schedule may kindly be perused, my lords.
I agree. As on today, what is there, it will be there. You cannot construct further also. If it is constructed, it cannot be demolished also.
By virtue of this order, our interfere ಆದ್ರೆ
ಏನಕ್ಕೆ interfere ಆದ್ರೆ violation of that order.
ಸ್ಟೇಟಸ್ ಕೋ ಅಂತ ಹೇಳಿ ನಾವು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದ್ದೀವಿ, ಅವರು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದ್ದೀರಿ ಅಂತ. Physical position with the defendants, my lords.
If you are in the possession,
Please,
this is not a vacant place.
Kindly peruse
No, Mister, it is not a vacant place. You have made in a shop.
that observation may be made.
He cannot come and open the door and enter. If it is done today, is it not violation of the court order? If really you are in the position, you need not be worried. Just to shop premises. If it is an open space.
As per the plaintiff government itself, my lordships, they have not mentioned any shops and all that, my lordships. It is true that there exists shops in this scheduled property.
ನಿಮಗೆ ಏನ್ ಮಾಡ್ತಾರೆ, ಶಾಪ್ ಹೊಡೆದಾಕ್ತಾರ?
ಅಲ್ಲ, ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ನ ಅವ್ರು ಏನಾದ್ರು ಮಿಸ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಅಂತ.
ಏನ್ ಮಾಡ್ತಾರೆ ಹೇಳಿ?
ಐ ಆಮ್ ರೆಡಿ ಟು ಗೋ ಆನ್ ವಿತ್ ದಿ ಟ್ರಯಲ್, ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
ನೋ, ಅವ್ರು ಏನ್ ಮಾಡ್ಬೋದು ಹೇಳಿ. ಐ ವಿಲ್ ಗಿವ್ ದಟ್ ಬೈ ಎಕ್ಸ್ಪ್ಲನೇಷನ್.
ಅಲ್ಲ, ಬೀಗ ಹೊಡೆದು ಮತ್ತೆ ಇದು
ಇವತ್ತಿನ ಮೇಲೆ ಬೀಗ ಹೊಡೆದಿದ್ದು ಗೊತ್ತಾಗಲ್ವಾ?
ಅಲ್ಲಲ್ಲ, ನಾವು ಮೈ ಟೆನೆಂಟ್ಸ್ ಆರ್ ಅಲ್ಲಿ ಬಂದು ಗಲಾಟೆ ಮಾಡೋದು ನಾವು ಸ್ವಾತಂತ್ರ್ಯ.
If anybody enter your house, you do not know that when he has entered. If it is enter this order of this court, this is not any contempt.
Observation that
and if you are pressing to show that you are not in the position.
ಇಲ್ಲ sir, I am in the position of the scheduled property.
ಯಾವತ್ತು position ಒಳಗಡೆ ಬಂದ್ರು ಕೂಡ it's an content of this court. If you are already in that position.
Observation
plain land ಆದ್ರೆ there may be a problem.
That observation may be made.
No observation will be made. This is what that explanation. What is the problem? Tell me that.
ಅಲ್ಲಲ್ಲ, according to plaintiff it is a plain land.
ಇಲ್ಲ
ಆಯ್ತ್ರಿ, ಈ ಪ್ಲೈನ್ ಲ್ಯಾಂಡ್ ಇದೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ಈಗ ನೀವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇದೆ. ಇಫ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಪ್ಲೈನ್ ಲ್ಯಾಂಡ್, ಅವ್ರು ಹೇಳಿದ ತಕ್ಷಣ ಅಲ್ಲೇನು ಚೇಂಜ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ, ನಾವು
ಪ್ಲೈನ್ ಲ್ಯಾಂಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಡಿಮಾಲಿಶ್ ಮಾಡ್ಬೇಕು ತಾನೆ.
ಅಲ್ಲ ನಾವು ಕಟ್ಬಿಟ್ಟಿದ್ದೀವಿ ಸರ್ 50 ಟೆನೆಂಟ್ಸ್ ಇದೆ.
As on today, it is constructed, is it not?
Please, my lord.
If you want to take an advantage and demolish that, it is not violation. Yes. Directed to maintain status quo in respect of position of the property. And the trial court is directed to, what is the stage in the suit, Mr.?
The evidence commence ಆಗಿಲ್ಲ sir.
Evidence commence. Yes. Directed to dispose of the suit as expeditiously as possible. Parties are directed to maintain status quo. The parties are directed to cooperate for early disposal. Yes. All pending applications are disposed.
Serial number 75, K. Govindaraya Kamath for petitioner, Srinivasa.
I appear for the petitioner, my lords. 6 times, my lords. Maybe.
My lord, you have filed IF for vacating stay.
Yes, there is an IF for vacating, Mr.
My lords, it may be heard on Monday, my lords.
No, I will adjourn, but I will not extend that interim order. IF
Lords,
for
we are
vacating.
ready, my lords. It's a very simple matter, my lords. We have filed order 1, rule 10, my lords, before the trial court. We are the plaintiff before the trial court. And it's a declaration and a permanent injunction suit, my lords.
Now, what is the stay, Mr.?
My lords, it's in the evidence statement.
My lord, after arguments, when the matter was posted for judgment. My lord.
What is the stay, Mr.?
My lord, it's but.
No, who is the plaintiff?
Plaintiff, my lord, is the petitioner.
Now suit is stayed. What is that urgency for you?
My lord,
You are
urgency.
the defendant.
My lord, urgency is, my lord, matter has been posted twice for the judgment. At that stage, my lord, they are one or the other where they are trying to precipitate the matter.
Degree, I should dismiss agutte anta. You don't know that.
I understood.
You know that.
I understood, but intentionally,
Their
my
suit
lord,
is stayed, Mr. That is delayed for them. Why do you worry them? Yes.
my lord, belatedly, for false cause of action, they have filed a suit. My lord, in fact, in the plaint, my lord, in prayer 2 may be seen. My lord, wherein, my lord, the sale deed executed in favor of defendant number 3 has been challenged.
ಈ ಸೂಟ್ ಸ್ಟೇ ಆಗಿರೋದ್ರಿಂದ ನಿಮಗೇನ್ ತೊಂದರೆ ಏನಿದೆ? ಏನಿಲ್ಲ ಅಂತ. ಯಾರಿಗೆ ತೊಂದರೆ ಇದೆ ಅವ್ರದ್ದು ಹಿಯರ್ ಮಾಡೋದು.
Maybe as
if suit itself is stayed by the defendant, then you have to be considered.
My lord, as
ಅವ್ರದೇ suit ಅವ್ರು stay ಮಾಡಿಸ್ಕೊಂಡ್ರೆ ನಿಮಗೇನಂತ?
maybe taken on Monday itself, my lord.
Please this matter on 24th. Yes.
Published.
Interim order may be extended.
Interim order extended till next date of it.
76, Shruti C. Chagati for petitioner, Usha
I'm
SM.
appearing for second respondent.
For the respondent number 4, my lordship.
Inconvenience today, my lord. Kindly have it
There is
entertained
a
the
short
next week.
point, Your Honor.
Wherever application for vacating is there, I will hear other matter. Yes. Leave this matter on 26th. Yes.
There's an interim order, my lord.
Interim order granted earlier is extended till next date of it. Yes.
77, Vivekananda S for petitioner, SV
Wait,
Bhatt.
please, my lord, in this case.
Yeah, right, my lord. I am for the respondent, my lord. I have filed the application for vacating stay.
Filed objection to that vacating that interim order, my lord. Here is the case is, they filed the plaintiff is the respondent here, number
Right.
1 here.
May
He filed,
I would like to be present physically there, my lord. May I request your lord to have it on Monday, my lord. Monday, my lord.
Monday. Yes. Leave this matter on
interim
17th.
order may be extended.
Much
Interim order
obliged.
granted earlier is extended till next date of it.
Much obliged.
78, Akshay BM for petitioner, Prasad
Petitioner.
KR.
Yes.
Lords,
Here for the respondent.
Injunction was not granted, my
No,
lords.
they are
It's a
not
suit
there.
for specific performance.
No, there is vacating application. They are not there.
I'm ready.
They will extend that interim order. Why do you want? Yes.
They have not
Interim
served a
order
copy
granted.
of that application.
Yes. Leave this matter of 2 weeks. Interim order granted earlier is extended till next date of it. Yes. Please.
Serial number 79, Ravi
Yeah,
Kumar
for
NR for
respondent.
petitioner.
And for the petitioner, I filed the application for bringing the LS of petition number 6, my lord.
Yes.
During the pendency of the petition, he was died.
Yes. Will
Allow-
allow
allow
that
this.
application.
Last-
Allowed ಆಗಿದ್ಯಾ?
Allow ಮಾಡ್ಬೇಕು. Allow ಮಾಡ್ಬೇಕು.
ಮಾಡ್ಬೇಕಾ ಬೇಡ?
ಮಾಡ್ಬೇಕು.
ಮಾಡ್ಬೇಕು. Yes. IA 2 of 2025 is filed for bringing LRs of
Petition number 6, my lord.
who are the LRs?
LS, my lord, wife and children.
Yes. That IA is allowed the LRs of petitioner number 6 is permitted to come on record. Learned counsel for the petitioner is permitted to amend the cost of, amend it.
Next date.
Interim order may kindly be.
Interim order granted earlier is extended till next date of the. Yes.
Date ಕೊಡಿ ಸುಮ್ಮನೆ vacating stay ಹಾಕಿ stay vacate.
ಎಲ್ಲ ಹಾಕಿಲ್ಲಲ್ಲ ನೀವು?
ಹಾಕ್ತೀವಿ ಸುಮ್ಮನೆ ಒಂದು ಡೇಟ್ ಕೊಡಿ.
ಹಾಕಿದ್ಮೇಲೆ ಮೂವ್ ಮಾಡಿ. ಹಾಕ್ತಾರನ್ನ ಡಿಸೈಡ್ ಮಾಡಕ್ಕೆ ನಂಗೆ ಟೈಮ್ ಇಲ್ಲ. ನಿಮ್ಮ ಹಾಕರ್ನ ಆಮೇಲೆ ನೋಡೋಣ.
ಸುಮ್ಮನೆ ಡೇಟ್.
Yes.
Serial number
You
80,
file it and
Pradeep
then
Naik
know
K
that.
for petitioner. 80, Pradeep Naik K.
For the petitioner.
There is a status quo order regarding road is concerned.
Yes,
Lord,
please.
Since securing the status quo order, the petitioners, 6 criminal proceedings have happened, my lords. And in
No, you are ready.
one of the, yes, my lords.
Yes, what is this suit for, Mr.?
Injunction suit has been filed with regard to the road is concerned.
No, you are the plaintiff.
I am the plaintiff before the Honorable Trial Court.
Ah,
Injunction application, suit for injunction application came to be dismissed.
yes.
And MA has been filed, MA also dismissed against that. This present writ petition has been filed.
No. Suit is not dismissed.
The suit is pending. Suit is
IA
pending.
is dismissed.
IA dismissed against that. MA has been filed, MA dismissed. Against that, the present writ petition has been filed.
Yes.
My lord, they entered caveat and your lordship may kindly see on 2/5/25.
Yes.
Shri Prasanna advocate undertakes to file wakalat for respondent number 4. Issue notice to the other respondent. Parties are directed to maintain status quo till next date of hearing. That order has been continued.
Yeah.
And again, they moved an application for modification of the order dated 10/9/25. Your lordship may kindly see the order dated 10/9/25. Defendant number 4 should not be dispossessed during the subsistence of the subject petition on the strength of the interim order till next date of hearing, subject to the modification IO extended. So on 2 occasions, they have been heard in the matter. And the I'll complete. This matter is concerned, your lordship may kindly say they are owning more than 40 to 50 acres of coffee estate in Mudigere. I am having a little bit of land of 4 acres.
Yes.
Now they try to obstruct the road to enter my property. The interim order has been not granted only because they filed a earlier suit for injunction. The present
Respondent number 4 in the suit says move this matter on that it will be disposed now on the.
Yes,
date of
yes,
the interim order. Notwithstanding the fact that injunction different suit in this favor and the order of the police protection. In the light of the defendant number 4 shall not be dispossessed from this property during the.
we are not doing that one.
Is there
My submission is as follows. I have filed an injunction suit and have secured an injunction against them not to trespass into my property. Paragraph number 23, 24 and 25 of my order, which is in my favor, there is a categorical finding that they need not pass through my property.
No, that order, you can place it at the final hearing. Now that till the disposal of the suit, there is no right of yours is affected. They said that you cannot be dispossessed. Court has clarified. I will direct it to dispose of the suit.
Yes, we are ready for that.
Millards, one submission. The petitioner number 1 and 2, apart from this counter suit, what they have filed, notwithstanding the fact that they are injected not to trespass into my property, they have filed another suit where they are claiming the property pertaining to which I have secured injunction. Thus, my lords, I have a grave threat of disposition from my property. Hence, my lords,
see,
they have not come clean before this honorable court to provide all the antecedents.
No, Mr. case.
They have initiated multiple suits.
Case suit for injunction is pending. This court has granted in a status quo. After that, you are moving the matter. It is clarified. You cannot be dispossessed taking the status quo with the help of the police.
Please.
They have protected your right. What else you want? You go and agitate the suit and get it dismissed.
In fact, the coordinate bench has also suggested the same. 3 months date will be fixed for disposal. That they have not agreed.
Millards.
Then we will hear that matter. Yes. This matter. 1 second. Yes,
Interim order.
Interim order granted earlier is extended till next
Please.
81, V. Raviraj.
Yes.
Serial number 81, V. Raviraj.
I pay for the petitioner in this matter, my lord.
None appear for the respondent. Read this matter of 3 weeks interim order granted earlier is extended till next date of hearing. Yes.
82, Manjunatha V. for petitioner, Rangarama V.
Yes.
For petitioner, my lords, place time, it is not one.
Where is respondent? None appear for the respondent. Counsel for the petitioner is present. Read this matter after 3 weeks interim order granted earlier is extended till next date of hearing.
83, M. Sudhakar Pai for petitioner, K. Shashikant Prasad.
Yes, I appear for respondent number 4, 6 to 11.
Where is Sudhakar Pai?
Amendment of written statement was allowed. Now that has been challenged before this honorable court. The amendment is stayed. The suit is continuing. Amendment, my lord, written statement filed by us. Respondent number 4, 6 to 11.
No, that suit for,
Suit for declaration, my lord.
so you are the plaintiff or a defendant?
I am the defendant number 4, 3 and 5 to 10.
Yes.
My written statement, I sought for amendment on the basis, my lord, to include certain details regarding earlier suit.
Yes.
They themselves have stated, my lord, about that suit in para number 5 of the plaint.
We'll have it on Tuesday.
Yes, sir.
Yes, none appear for the petitioner. Leave this matter on Tuesday. Yes.
Serial number 84, Sunanda S for petitioner.
Ten.
Nagaraj B.
Yes.
For
10,
petitioner,
sir.
my lord.
10.
We are 6 to 60. We have filed IFR vacating stay.
Yes, then petitioner has to come. Yes. Yes.
ಅಯ್ಯೇ ಅಲೋ ಆಗಿದೆ my lord.
Yes.
ಜೂನಿಯರ್ ಬಂದಿದ್ದಾರೆ ಅವರು. ನೋ ಮ್ಯಾಟರ್. ನಾವು ಐ ಹಾಕಿರೋದು.
Yes. You are
11th ಕೊಟ್ಬಿಡಿ ಸರ್. ಜೂನಿಯರ್ ಮ್ಯಾಟರ್ ಗೊತ್ತಿಲ್ಲ. 11th ಕೊಡಿ. ಸೀನಿಯರ್ ಬಂದಿಲ್ಲ.
Yes, leave this.
11th.
Not 11th. 17th. Yes, leave this matter on 17th. Interim order
16th ಕೊಡಿ ಸರ್ ಪ್ಲೀಸ್. 17th ಬೇರೆ ಇದೆ. 16th ಕೊಡಿ.
16th.
ಎಸ್ ಸರ್.
Yes, interim order granted earlier is extended till next month.
85, Subbareddy KN for petitioner. Ravindra Prasad B.
May recollect last occasion also they had sought for right.
Yes.
Lords, my property was brought to an auction under the SURFACE Act by a different financier.
Yes.
Lords, now that money under the scheme of the SURFACE Act, he cannot do anything other than give that money to me.
Yes.
That banker mischievously comes to the court and say, I want to hand over the demand draft for 5 crore 87 lakhs, whereas the
This is suit for
recovery of money.
Yes.
And I am a guarantor for certain loan transactions under a binding agreement is their contention.
Yes.
The DD which was offered to be given by the bank is for 5 crore 87 lakhs and odd.
Yes.
Their claim is 3 crore 60 lakhs.
Oh, that you can be.
Now the court said, see, the DD is for 580, drawn in my name.
Yes.
It is not in the name of the court, it is drawn in my name. Where is any question of accepting this DD? It has to go to him. Even under the scheme of the SURFACE Act, the moment the sale takes place, the residual amount has to come to me. And then he has to take steps for attachment before judgment or attachment to garnish order, anything he can do.
Yes.
Now, without any such application, he cannot come and say the DD offered should not be given.
Where is that counsel for?
Last time, last time, inge bandru, amel dates.
We'll have it.
4 dates, Lords, they have not.
We'll have it next week. No interim order will be extended.
Lords may not extend the interim order, Lords.
You want to extend the interim order?
Huh?
No interim order.
Interim order extend madale next week ಹಾಕಿದ್ರೆ
Leave
ಆಯ್ತು.
this,
ಆಮೇಲೆ
none appear for the petitioner. Leave this matter next week.
Please.
Serial number 86, BK Manjunath for petitioner.
In this case, the petitioner.
The respondent, my lord.
Vacating stay ಇದೆ some vacating.
12th date. 12th. Next week on the 12th. Yes. Yes, Mr.
My lord,
Vacating stay copy ಕೊಟ್ಟಿಲ್ಲ some.
Huh?
Vacating stay copy.
no, it has been furnished, my lord. We have served on them, and that is my endorsement has also been provided. The matter arises from a partition suit.
Copy issue first senior ಗೆ ಕೊಡಬೇಕು.
It has been served by email, my lord, on their official email address.
Is it permitted under the law to serve on email now?
After the after the amendment, my lord, yes. After the amendment.
Now it is
After
permitted.
the amendment is what my understanding is.
Where is that amendment? Show me.
No, that I do not have it with me right now at present.
Now they are saying that.
Can you
it is
make
not
interim
served. Now
extension?
it is shown that,
Can you make
We'll furnish a physical copy
Okay,
in
that's
that case.
better, yes.
Short date.
Otherwise, if you show under that amendment rules, if it is permitted, then we will take it that it is served. Otherwise, you have to serve the copy.
can you make interim extension can you?
Yes. Counsel for the respondent is directed to serve IA copy on the petitioner. Leave this matter next week.
Can you make
Any date, my lord?
Interim order granted earlier is extended till next date of hearing. Leave this matter on 16th.
much.
Yes.
ನಂಬರ್ 7 ಸರ್ ನಾಳೆ
serial number
7 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
Pass over.
ಪಾಸ್ ಓವರ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ನನಗೆ ಜಮೀನಿಗೆ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ, ಸ್ವಾಧೀನ ಆಗಿದೆ.
Preliminary hearing.
ಅವರು
preliminary hearing day after tomorrow.
My lords, serial number 99, my lords.
Preliminary hearing day after
My lords, serial number 99, I have actually filed for vacating stay. It has come in B group, my lords. It may come in serial number 99, my lords. I appear for respond number 8. My lords, I have filed for vacating stay. They have filed objections as well. It must come in hearing on IA, my lord.
Suppose this matter
Date
interlocutory stage on application for
My lord.
vacating.
and date may be fixed, my lords.
My lord, serial number
Next week
92,
date may
my
be
lord.
fixed, my lords. 18th.
Let's serial number
Date.
110.
What's serial number?
My lord,
Next week.
serial number 92.
7 minutes, there's a direction, my lord.
Serial number
107, interim order.
Wait. Wherever interim order is there, we extended. Whoever want time, if you want time, today is the Wednesday, next Wednesday will be given the date. If they are not asked the time, we'll give it after 2 weeks or.
Your lordship.
7, there's a direction, my lords, to expedite the suit from the Honorable Supreme Court.
Day after tomorrow.
Your lordship, serial number 107, your lordship.
97.
Serial number
Sir, your lordship, serial number 107. Your
Give the date.
Grateful.
Serial number 95 next week ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ. Please.
Next week ಕೊಡಿ sir.
Please, ನನಗೆ ಭಾರಿ ಅರ್ಜೆಂಟ್ ಇದೆ ದಯವಿಟ್ಟು ರಿಕ್ವೆಸ್ಟ್. Serial
Sir, 2
95.
weeks ಅಲ್ಲಿ ಹಾಕ್ಬಿಡಿ.
87 ಇಂದ ಒಂದೊಂದೇ ಕಾಲ್ ಔಟ್ ಮಾಡಿ.
ಆಯ್ತು. ಆಯ್ತು. 6:45 ಆಯ್ತು.
ನಾ ಏನ್ ಮಾಡ್ಲಿ ಸರ್? 4ನೇ ತಾರೀಕು ಇವತ್ತು 11ರ ನಂತರ ಡೇಟ್ ಕೇಳ್ಕೊಳ್ಳಿ ಸರ್. ಫ್ರೈಡೆ ಇರಬಾರ್ದು ಅಷ್ಟೇ. ಫ್ರೈಡೆ RFA 87 ರೆಡಿ ಇರಿ ಸರ್. ಇಬ್ರು ಯಾರು ಇಬ್ರು ಇರೋ ರೆಡಿ ಇರಿ. ನಾನು ಅವರು ನಾನು ಅಂತ ಡಿಸೈಡ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಬರೀಬೇಕಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗೋಯ್ತು. ಮುಂದಕ್ಕೆ ಕೇಳಿ ನೀವು ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತೀರಾ. ಡೇಟ್ ಅಲ್ಲಿ ಪಾಪ ಜನ ಕಾಯ್ತಾ ಇದ್ದಾರೆ. ನೀವ್ ಹೇಳೋವರೆಗೂ ಕಾಯಕ್ಕಾಗಲ್ಲ ಸರ್. ರೆಡಿ ಇರಿ ಬೇಗ. ಅಪ್ಪಪ್ಪ ಅವ್ರು ಕಾಯಲ್ವ? ಈಗ ಅವ್ರು ಏನ್ ಹೇಳಿದ್ರು ಹೇಳಿ. ಬಿ ಗ್ರೂಪ್ 88 ಅರ್ಜನ್ 89.
Now responded to court officer. Then maybe listed on 11/3 court of 11/3.
11/3.
Yes.
90 ಎಲ್ಲ 11/3 ತಗೊಂಡ್ರೆ ಇದೇ ಪರಿಸ್ಥಿತಿ. 91. ಸರ್ ಇಬ್ರು ಇದ್ದಾಗ ನೀವಿಬ್ರು ಹೇಳಿದ್ದನ್ನೇ ಕೊಡ್ತೀವಿ. ಇಬ್ರು ಅವರು ಹಬ್ಬ ಆದ್ಮೇಲೆ ನೀವು ಹಬ್ಬಕ್ಕಿಂತ ಮುಂಚೆ ಅಂದ್ರೆ ನಾನೇನ್ ಮಾಡ್ಲೆ? ಎಲ್ಲ 11 ತಗೊಳ್ಬೇಡಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ನೀವ್ಯಾರು? ಎಲ್ಲಿ ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್? ಹೇಳಿ ಅಡ್ವೊಕೇಟ್ ಕರ್ಕೊಂಬನ್ನಿ. 92 ಎಲ್ಲ 11 ತಗೋಬೇಡ್ರಿ. ನಾನು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ನಿಮ್ಗೆ ಇದೇ ತರ ಕಾಯ್ಬೇಕಾಗತ್ತೆ. ಎಲ್ರಿಗೂ ಅರ್ಜೆನ್ಸಿ ಇರೋದೆ. ಹೇಳಿ ಯಾರು ಬೇಗ. ಯಾರು ಮಾತಾಡ? 92 93 94
94 petitioner 12/3 ಗೆ ಸರ್.
12/3 94 12/3 95 12/3 ಆಯ್ತು. 96 ಅರ್ಜನ್ 97.
ಸೊ 10/3 ಕೊಡಿ ಸರ್. ಸೊ ಅದರಲ್ಲಿ ಆರ್ಡರ್ಸ್ ನ ಕ್ಯಾಪ್ಷನ್ ನಲ್ಲಿ ಬರ್ಬೇಕು ಅಂತ ಆಲ್ರೆಡಿ ಒಂದು ಆರ್ಡರ್ ಇದೆ
ಇರ್ಲಿ ಮೇಡಮ್. ಇವಾಗ ಸಾಹೇಬ್ರಿಲ್ಲ
ಈ ಗ್ರೂಪ್ ನಲ್ಲಿ ಬರ್ತಾ ಇದೆ. ಸೊ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಇದೆ, ಅದಕ್ಕೆ 10/3 ಕೊಡಿ.
10 ಅಲ್ಲಮ್ಮ, ಸಾಹೇಬ್ರು ಹೇಳಿದ್ದು ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ನಂತರ ತಗೊಳ್ಳಿ ಅಂತ.
ಸೊ ಇಲ್ಲ ಸರ್, ಅದ್ರ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್
ಅವ್ರು ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇದಾರೆ. ಅವ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವ್ರನ್ನ ಕೇಳಲ್ಲ, ನಿಮ್ಮನ್ನ ಕೇಳಲ್ಲ. ಇವಾಗ ಆಯ್ತು ಇರಿ, ಇಬ್ಬರನ್ನು ಕೇಳ್ಬೇಕು. ಅವ್ರ ನಿಮ್ ಪರವಾಗಿ ಅವ್ರಿಗೆ ಹೇಳ್ತಾ ಇರೋದು. ಹೇಳಿ ಈಗ ಪಿಟಿಷನರ್ ನಿಮ್ಗೆ ಯಾವಾಗ?
ನಾನ್
ಮೇಡಮ್ ಅವ್ರು 17th ಕೇಳ್ತಾ ಇದಾರೆ. ಮೇಡಮ್ 17th ಕೇಳ್ತಾ ಇದಾರೆ. ಯಾವತ್ತು ಹೇಳಿ ನಿಮ್ದು? 17 ನಂತರನಾ?
ಇಲ್ಲ ಸರ್, 17th ಮುಂಚೆ ಕೊಡಿ.
17th ಆಯ್ತಾ ಸರ್? ಸಾಲ್ವ್ ಆಯ್ತಾ?
17th ಮುಂಚೆ ಕೊಡಿ ಸರ್. 17th ಎಸ್ ಅನ್ಲಿಲ್ಲ. ಸೊ ಅದ್ರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಇದೆ ಸರ್.
ಆ ಡೈರೆಕ್ಷನ್ ಎಲ್ಲ ಇವಾಗ ನಾನು ಎಲ್ಲಿಂದ
ಮತ್ತೆ 11th ಕೊಡಿ. 11th ಕೊಡಿ.
ಯಾವುದು?
11th ಕೊಡಿ.
11th ಅಂತಪ್ಪ ಅವ್ರಿಗೆ 11th ಬೇಡ ಮೇಡಮ್. ನೀವಿಬ್ರು ಡಿಸೈಡ್ ಮಾಡ್ಕೊಂಡು ಹೇಳಿ ಆಮೇಲೆ.
ಸೊ ಇಲ್ಲ ಸರ್, 11th ಕೊಡಿ. ಸಾಹೇಬ್ರು ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ರಿಪೀಟ್ ಆನ್ ವೆನ್ಸ್ಡೇ.
ಅವ್ರಿಗೆ 11th ಬೇಡವಂತಮ್ಮ. ಅವ್ರಿಗೆ 11th ಬೇಡ.
ಸೊ ದೇ ಐ ಆಮ್ ನಾಟ್
ಕೇಳಿದಾರೆ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ಸಾಹೇಬ್ರೀಗ. 98
11th ಕೊಡಿ ಸರ್.
ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ ಇಬ್ರು. ಆಮೇಲೆ ಇನ್ನೊಂದು ರೌಂಡ್ ಬರ್ತೀನಿ ಬೇಕು ಅಂದ್ರೆ. 98
So I cannot talk to somebody in the court, so kindly give it on 11th.
98 ಹೇಳಿ ಸರ್. ಇರಿ ಸರ್ ಒಂದ್ ನಿಮಿಷ. ಸೆಕೆಂಡ್ ರೌಂಡ್ ಬಂದ್ 98 ಅರ್ಜನ್, 99 ಅರ್ಜನ್, 100 ಮೇಡಮ್. ಒಂದ್ ನಿಮಿಷ ಇರಿ. ಅದು ಆಗೋಗಿರೋದನ್ನ ಯಾಕಪ್ಪ ಅರ್ಜನ್ ಅಂತ ನಾನು ಹೇಳಿದ್ಮೇಲೆ ಆಗೋದು. ಓ ಒಳ್ಳೆ ರಾಮಾಯಣಕ್ಕಾಯ್ತಲ್ಲ. 99 ಬೆಳಿಗ್ಗೆ ಆಗೋಗಿದೆ, ಇವಾಗ ನಾನು ಚೇಂಜ್ ಮಾಡಕ್ ಬರುತ್ತಾ? ಹಾ ಸಾಹೇಬ್ರು ಹೇಳಿ ಹೋಗಿರೋದನ್ನ ನಾನೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. 100 ಎಂಟ್ರಿ ಮಾಡ್ರಿ, ಎಲ್ಲೆಲ್ಲಿ ಇದೆಯಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತಮ್ಮ. 100 12 101 101 ಅಡ್ಜನ್ 102 12th ಎಲ್ಲ 12th ತಗೋಬೇಡಿ ಸರ್. 103 17 ಫ್ರೈಡೇ ಇರಬಾರ್ದು. 104 104 ಯಾರು ಅಡ್ಜನ್. 105 ಅಡ್ಜನ್. 106 ಅಡ್ಜನ್. 107
107 17th ಕೊಡಿ
ಸರ್. ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ರೆ ಆಮೇಲೆ ಸೆಕೆಂಡ್ ರೌಂಡ್ ಬರ್ತೀನಿ ರೀ ಸರ್. 108 ಯಾವುದು? 107 ಇನ್ನೊಬ್ರು ಯಾರು? ವಿಸಿ.
ವಿಸಿ ಪಿಟಿಷನರ್ ಗೆ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕು 17th.
17 ಆಯ್ತು, ಗ್ರಾಂಟೆಡ್. 108 ಅಡ್ಜನ್. 109 ಡಿಸ್ಪ್ಯೂಟ್ ಇದ್ರೆ ಸೆಕೆಂಡ್ ರೌಂಡ್. ಸೆಕೆಂಡ್ ಅವರು ಪಿಟಿಷನರ್, ನೀವು ಪಿಟಿಷನರ್, ಯಾರು ಕೊಡ್ಲಿ? 110 110 110 ಯಾರಪ್ಪ? ಹಾ ಹೇಳಿ. ಯಾವತ್ತು? 16 ಹಾ ಸೋಮವಾರ. 111 ಅಡ್ಜನ್. 112 ಆಗತ್ತಪ್ಪ. 112 ಅಡ್ಜನ್. 113 113 114 ಯಾರು ಸರ್? ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ರೌಂಡ್ ಹೇಳಪ್ಪ.
Serial number 97, sir.
ಒಂದೇ ಇರಿ ಸರ್, ಸೀರಿಯಲ್ ವೈಸೇ ಬರ್ಬೇಕಲ್ವಾ? 90 91 92 11th ಹೇಳಿದ್ರಲ್ಲ. 92 16 93 ಆಯ್ತು ಸರ್. ಅದೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಸರ್, ಅದ್ ನಾನ್ ಮಾಡಿದ್ರೆ ಆಗ್ತಾರ ಯಾರಾದ್ರು? 90 ನೆಕ್ಸ್ಟ್ ಯಾವ್ದಪ್ಪ?
97, sir.
ಬಂದೆ 97 17 ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಇಲ್ಲ ಸರ್, ನಾನ್ 17th ಅಂತ ಹೇಳಿಲ್ಲ ಸರ್, 11th ಗೆ
ಬೇಡ, ಇನ್ಯಾವ್ದಮ್ಮ ಹೇಳಿ ಬಿಡ್ರಿ. ಅವ್ರು ಯಾವ್ದಕ್ಕೆ ಹೇಳಿ. ಆಯ್ತು ಬಿಡಿ, ನಾನು ಸಾಹೇಬ್ರಿಗೆ ಹೇಳ್ತೀನಿ. ಈ ತರ ಮಾಡಿದ್ರೆ ಒಳ್ಳೆ ಕತೆ ಆಯ್ತಲ್ಲ. ಅವರು ಒಪ್ಪಲ್ಲ, ನೀವು ಯಾವ ಡೇಟ್ ಕೊಡ್ಲೆ ಮತ್ತೆ ನಾನು?
ಓಕೆ 16th ಕೊಡಿ ಸರ್. 16th
ಮೇಡಮ್, ನೀವು ಡೈಲಿ ನಮ್ ಕೋರ್ಟ್ಗೆ ಅಪೇರ್ ಆಗ್ತೀರಾ, ಯಾಕೆ ಈ ತರ ಮಾಡ್ತಾ ಇದೀರಾ ಗೊತ್ತಿಲ್ಲ.
ಸೊ ನಾವ್ ರೆಸ್ಪಾನ್ಸ್ ಸರ್, ನಮ್ಮೇಲೆ ಎಂಟ್ರಿ ಆರ್ಡರ್ ತಗೊಂಡ್ ಕೂತಿದಾರೆ, ನಮಗ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ.
ಸರಿ ಮೇಡಮ್, ಸಾಹೇಬ್ರು ಇಲ್ದೇ ಇರೋದ್ ನಾನು ಈಗ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಡೇಟ್ ಕೊಡಿ ಅಂದ್ರೆ ಡೇಟ್ ಅಷ್ಟೇ ಕೊಡ್ಬೋದಲ್ವಾ?
ಸರ್ ಸಾಹೇಬ್ರು ಅಂದ್ರೆ ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ವಿಲ್ ರಿಪೀಟ್ ಆನ್ 11th ಅಂತ. 11th ಕೊಡಿ.
ಈಗ 16th ಓಕೆನಮ್ಮ? 16th ಓಕೆನಾ?
16th ಕೊಡಿ.
ಆಯ್ತು, ಮುಗೀತಲ್ಲಮ್ಮ. ನೆಕ್ಸ್ಟ್ ಇನ್ಯಾರು? 109 ಇದೆಯಾ? ಇದನ್ನ ಸಾಲ್ವ್ ಮಾಡಕ್ ಆಗಲ್ಲ, ಸಾಹೇಬ್ರ ಹತ್ರ ಹೇಳ್ತೀನಿ. ಇಬ್ರು ರೆಡಿ ಇದ್ರೆ ಮಾತ್ರ, ಇಲ್ದೇ ಹೋದ್ರೆ ಆಗಲ್ಲ ಇದೆಲ್ಲ. 109 ಹೇಳಿ ಸರ್. ಆಯ್ತು, ಅಡ್ಜರ್ನ್ ಮಾಡ್ಕೊಂಡು ಸಾಹೇಬ್ರಿಗೆ ಹೇಳ್ತೀನಿ, ಇಬ್ರು ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ ಸರ್ ಅಂತ ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡ್ಕೊಡಿ. ಬೇಡ ಬಿಡಪ್ಪ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಇನ್ಯಾರು? 73 ಇನ್ನು ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟ್ರ್ ಇದೆ ಸರ್, ಅದ್ ಕೊಡ್ಬೇಕು. ಯಾಕೆ ಈ ತರ ಮಾಡ್ತೀರಪ್ಪ? 73 ಕೊಟ್ಟಿದೀವಲ್ಲ, 18 ಅವಲೇ ಸಾಹೇಬ್ರೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ? 12th ಬೇಕು ಅಂದ್ರೆ ಏನ್ ಅರ್ಥ? 90 ಯಾವ್ದು ಬರ್ಕೊಂಡಿಲ್ಲ, ಅದು ಹಂಗೆ ಪೆಂಡಿಂಗ್ ಇದೆ. ರೇ ಇವ್ರೆ, ಏನ್ ಮಾತಾಡ್ತಾ ಇದ್ದೀರಪ್ಪ? ಏನಪ್ಪ, ಏನು ಅರ್ಥವೇ ಆಗಲ್ಲ. ಸರ್ ಹೇಳಿ, ಯಾವ್ದು? ಲಾಸ್ಟ್ ಒನ್ 7 ಏನಪ್ಪ ಇದು? ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹೇಳಿದ್ದಾರೆ ಸರ್. 6th 11 6th ಕಾಂತರಾಜ್ ಅವರೇ 6th. ಇನ್ಯಾವ್ದಪ್ಪ? 7/6 ಸರ್ ಇಬ್ರು ಬನ್ನಿ, ನಾನು ಬರ್ತೀನಿ. ಹೇಳಿ ನೀವು ಹೋಗಿ ಮಾತಾಡ್ತಾ ಇರಿ. ನಮ್ಮಿಬ್ಬರಿಗೂ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ, ಯಾವ ಡೇಟ್ ಕೊಡ್ಬೇಕು ಅಂತ ಅವರೇ ಡಿಸೈಡ್ ಮಾಡಿ. ಯಾವ್ದಪ್ಪ ಹಾ ಏನಾಗ್ಬೇಕು ಸರ್? ಸರ್ ಸಾಹೇಬ್ರು ಹೇಳಿದಾರೆ, ತಿರ್ಗಾ ಯಾಕಪ್ಪ ನನ್ಗೆ ಹೇಳ್ತೀಯ? ಆರ್ಡ್ರೇ ಪಾಸ್ ಆದ್ಮೇಲೆ ಸರ್ ಜುಡಿಷಿಯಲ್ ಆರ್ಡ್ರೇ ಆಗಿದೆ, ಇನ್ ನನಗೆ ಹೇಳಿದ್ರೆ ಏನ್ ಪ್ರಯೋಜನ? ಅಂತ ಸಾಹೇಬ್ರು ಹೇಳಿದಾರಲ್ಲ, ಏನಂತ ಯಾರೇನ್ ಮಾಡಿದ್ರು ಏನು ಮಾಡ್ಕೊಳಕ್ಕಾಗಲ್ಲ ಬಿಡಿ, ಯಾಕೆ ತಲೆ ಕೆಡ್ಸ್ಕೊಂಡ್ರೆ. ನೆಕ್ಸ್ಟ್ ಯಾವ್ದು ಸರ್? ಸರ್ ಆತರ ನಾನು ಮೀಡಿಯೇಟರ್ ಅಲ್ಲ ಸರ್, ಸಾರಿ. ಯಾವ್ದಾದ್ರು ಸೆಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಮಾಡಿ ಕಂಪ್ಯೂಟರ್ ಮಾಡಿ ಎಂಟ್ರಿ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡಿ. ನಾನು ಸಾಹೇಬ್ರಿಗೆ ಹೇಳ್ತೀನಿ ಸರ್, ಅವ್ರ ಕಂಪ್ಯೂಟರ್ ಕ್ಲೋಸ್ ಮಾಡಿ ನೀವು ಹೇಳ್ತೀನಿ. ಕಂಪ್ಯೂಟರ್ ಇರೋರ್ಗು ಅವ್ರು ನಮ್ಮನ್ ಬಿಡಲ್ಲ. ಕಂಪ್ಯೂಟರ್ ಕ್ಲೋಸ್ ಮಾಡಿ ಸಾಹೇಬ್ರಿಗೆ ಕೇಳಿದ್ರೆ ಹೇಳ್ತೀನಿ. ಅವ್ರು ಕಿತ್ತಾಡ್ತಾ ಇದ್ದಾರೆ. ಹೇಳಿ ಸರ್ ಯಾವ್ದು? 109 ಅಡ್ಜರ್ನ್ ಆಗಿತ್ತು, ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು? ಸರ್ ಈಗ ನಿಮ್ಮ ಅದೇ ಪರಿಸ್ಥಿತಿ ನಿಮಗ್ ಬಂದ್ರೆ ಅವ್ರು ಅಡ್ಜಸ್ಟ್ ಮಾಡೋದ್ ಬೇಡವಾ? ಸರಿ ಸರ್ ಆಯ್ತು, ಒಂದ್ ದಿವ್ಸ ನೀವು ಆ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ನಿಲ್ತೀರಲ್ವಾ? ಅವ್ರು ಅಷ್ಟ್ ಕೇಳ್ತಾ ಇದಾರೆ ಪಾಪ. ಅವ್ರವ್ರೇ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅವ್ರ ಮ್ಯಾಟ್ರ್. ನಾವು ಹೇಳ್ದಷ್ಟು. ವಾಚು ಕಳ್ಕೊಂಡಿದ್ದೀರಾ, ಕೊಡುವಾಗ ನಿಮ್ಗೆ ಅಂತ ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ನಾನು ಏನಾದ್ರು ದಾಖಲೆ ನೋಡ್ಬೇಕಲ್ವಾ? ಅವ್ರು ನನ್ಗೆ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ ಅಲ್ಲಿಂದ ಇಲ್ಲಿಂದ ಅಲ್ಲಿ ಓಡಾಡಿದ್ರೆ ನಾನು ಏನಪ್ಪ ಮಾಡ್ಲೆ? ಈಗ ಯಾರ್ದು ವಾಚು ಅಂತ? ಯಾರು ಸೀನಿಯರ್? ಇದ್ರಲ್ಲಿ ಏನ್ ತೋರಿಸ್ತೀರ ದಾಖಲೆ ನಿಮ್ದು ಅನ್ನೋದಕ್ಕೆ? ಇಲ್ಲ ನಾನು ಪೊಲೀಸ್ ಸ್ಟ್ಯಾಂಡ್ ಅವ್ರು ಮಾಡ್ಬೇಕು, ವಸ್ತು ಅಲ್ವಾ? ಓಪನ್ ನಾನ್ ಮಾಡ್ಬೇಕು, ನೀವು ಮಾಡೋದಲ್ಲ. ಹಂಗ್ ಮಾಡಿ. 18th ಇಲ್ದೆ ಹೋದ್ರೆ ಅದಕ್ಕೆ ಪ್ರೊಸೀಜರ್ ಬೇರೆ. ಪೊಲೀಸ್ ಮಾಡಿ. ನಾನೇನ್ ಸಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ನಾಳೆ ಕೊಟ್ಬಿಟ್ಟು ಇವ್ರು ಬರ್ತಾರೆ, ನಂದು ಹೋದ್ರೆ ನಾನು ನಿಮ್ಮನ್ನ ಎಲ್ಲಿ ಹುಡುಕ್ಲೆ? ಇಲ್ಲ ನಿಮ್ದೊಂದು ವಿಸಿಟಿಂಗ್ ಕಾರ್ಡ್ ಕೊಟ್ಟೋಗಿ ನಾನು ಇಟ್ಕೊಂತೀನಿ, ಯಾರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ವಿಸಿಟಿಂಗ್ ಕಾರ್ಡ್ ಹಾಕ. ನಾವು ಪಾಸ್ವರ್ಡ್ ಎಂತದ್ದು ಕೊಡ್ತಾಳು ಮತ್ತೆ ಹೆಂಗಪ್ಪ? ಈಗ ವಾಚ್ ಏನು ಇದು ಬೆಲೆ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಪಾಪ. ಅವ್ರು ಯಾರೋ ಕೊಟ್ರು, ಆ ಕಡೆ ಇದ್ದಿದ್ರೆ ನನಗೂ ಅದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. ಅವ್ರು ನನ್ನ ಕೈ ಕೊಟ್ಟಿದ್ದು ಕ್ಯಾಮ್ರಾ ನೋಟ್ ಆಗಿದೆ, ಸಾಹೇಬರು ನೋಡಿದ್ದಾರೆ. ನೀನು ಐಡೆಂಟಿಫಿಕೇಶನ್ ಮಾಡದೆ ಕೊಟ್ಟೆ ಹೆಂಗೆ ಅನ್ನೋ ನಾನು ಏನ್ ಹೇಳಲಿ ಅಷ್ಟೇ. ಅದೇ ಪ್ರಾಬ್ಲಮ್. ಇಲ್ಲ ಅಂದ್ರೆ ವೇಟ್ ಮಾಡಿ ಸಾಹೇಬ್ರ ಹತ್ರ ತಗೊಂಡು ಹೋಗ್ತೀನಿ, ಸರ್ ಹಿಂಗಿದೆ ಅಂತ ಸಾಹೇಬ್ರ ಗಮನಕ್ಕೆ ತಂದು ಕೊಡ್ತೀನಿ ಅಷ್ಟೇ, ಇನ್ನೇನು ಇಲ್ಲ ಪ್ರಾಬ್ಲಮ್. ನಾನೇ ನಿಮ್ಮನ್ನ ಏನಂತಾರೆ ನಿಮ್ದಲ್ಲ ಅಂತಾನೂ ಹೇಳ್ತಾ ಇಲ್ಲ ನಾನು, ನಿಮ್ದೇ ಇರ್ಬಹುದು. ನಿಮ್ದೇ ಸರ್ ವಾಚ್ ಅವರ ಇದು ಒಂದ್ ಕೆಲಸ ಬೇರೆ. ನಮ್ಗೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರ ಅಂತ ಹೌದು ರೀ, ಎಲ್ಲ ಆನಲ್ಲೇ ಇದೆ. ನಿಮ್ ಯಾರು ಇಲ್ವೇ ಇಲ್ವಲ್ಲ? ಯಾರು ಅದ್ ಹೇಳಿ? ಇಲ್ಲಿ ವಿಸಿ ಅಲ್ಲಿ ಕಾಣಿಸ್ಬೇಕಲ್ಲ, ಬನ್ನಿ ಈ ಕಡೆ. ಇಲ್ಲಿ ಅದು ನನಗ್ ಗೊತ್ತಿಲ್ಲ, ನಾವ್ ಇಲ್ಲಿ ಮಾತಾಡ್ತಾ ಇದೀವಿ, ನಮ್ದು ಆನ್ ಇದೆ, ನಿಮಗ್ ಕೇಳಿಸ್ತಾ ಇದೆ. ಇಲ್ಲಿ ಇರ್ಬೇಕಲ್ವ ವಿಸಿ ಅಲ್ಲಿ? ಅಲ್ಲಿ ನೋಡಿ, ಅಲ್ಲಿ ನೋಡಿ ಸರ್, ವಿಸಿ ಅಲ್ಲಿ ಯಾರಾದ್ರೂ ಇದಾರ? ಅಲ್ಲಿ ವಾಯ್ಸ್ ನಮ್ದು ಇಕ್ಕೋ ಬರ್ತಾ ಇದೆ ಸರ್. ಇಲ್ಲಿ ಮೈಕ್ ಆನ್ ಮಾಡಿದ್ದೀನಲ್ಲ ನಾನು. ಎಲ್ಲಿ? ಅದ ನನಗ್ ಗೊತ್ತಿಲ್ಲಪ್ಪ. ನಿಮ್ಮ ಯಾವುದು? 12/3 ಏನಂತ? ಏನು ಯಾರಪ್ಪ 90 ಇನ್ಯಾರು ಬಾಕಿ ಇರೋರು? ಡಿಸ್ಪ್ಯೂಟ್ ಸಾಲ್ವ್ ಆಯ್ತಾ ಸರ್? ಒಂದ್ ನಿಮಿಷ ಹೇಳದ್ ಕಳೀಲಿ. ಒಂದ್ ನಿಮಿಷ. ನಿಮ್ ಪ್ರಾಬ್ಲಮ್ ಅದೇ ತರ ಅವ್ರಿಗೆ ಬಂದಾಗ ಅವಾಗ ಏನ್ ಮಾಡ್ತೀರಿ? ಅಂತ ದೊಡ್ಡ ಪ್ರಾಬ್ಲಮೇ ಸಾಲ್ವ್ ಮಾಡಾಯ್ತು. ಇದು ಯಾವ ಸಣ್ಣದು? ಆಯ್ತು ಬಿಡಿ ಸರ್, ಏನೋ ಒಂದು ಆಯ್ತು. ನೀವಿಬ್ರು ಮಾತಾಡ್ಕೊಡಿ. ನೋಡಿ ಇವಾಗ ಸಾಹೇಬ್ ಕರೀತಾ ಇದಾರೆ, ಏನ್ ಹೇಳ್ಬೇಕು? ನೀವು 12 ಕೊಡಿ ಅಂತ ಇದ್ರೆ ಅವರು 12 ಕೊಡಿ ಅಂತ 5 ನಿಮಿಷ ಕೊಟ್ಬಿಡ್ತೀವಿ. ಒಂದ್ 5 ನಿಮಿಷ
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಬೇಗ ಹೇಳಿಯಪ್ಪ. ನೋಡಿ ಈಗ ಅವ್ರು ಯಾರೋ ಬಂದ್ರ ಅಲ್ಲಿ, ಹಿಂಗ ಬಿಟ್ರೆ ನಮ್ಗೆ ಹೋಗಕ್ ಬಿಡಲ್ಲ. ಹೇಳಿ ಸರ್ ಯಾರು?
serial number 85 we are for the petitioners. ಅದೇ interim order extend ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಸರ್.
ಸರ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಲ್ಲೆಲ್ಲಿ ಇದೆಯೋ ಬ್ರೇಕಪ್ ಇಲ್ಲ ಅಂದ್ರೆ ಆಟೋಮೆಟಿಕ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಸರ್. ನೋ
ಸರ್ ಡೇಟ್ ಏನಾಗಿದೆ ಸರ್?
ಈಗ ಯಾರು ಕೇಳಿದ್ರಲ್ಲ ಇವರು ನಿಮ್ಮವರು, ನೀವು ವಿಸಿ ಅಲ್ಲಿ ಇದ್ರಾ?
ಇದ್ರಿ ಸರ್, ನಾವು ಅವಾಗಿಂದ ಟ್ರೈ ಮಾಡ್ತಾ ಇದೀವಿ.
ಯಾವಾಗ ಲಾಗಿನ್ ಆದ್ರಿ?
ಈಗ ಒಂದು 2 minutes ಬ್ಯಾಕ್ ಆಗಿದ್ರಿ. ಅವ್ರು ನಮ್ ಕೊಲೀಗ್ ಅಲ್ಲಿ ಇದಾರೆ ಅಂತ ನಾವು ವಿಸಿ ಅಲ್ಲಿ ನೋಡ್ಬಿಟ್ಟೆ ನಾವು ಅವ್ರು ಫೋನ್ ಮಾಡಿದ್ವಿ.
ಈಗ ಅಂದ್ರೆ ಮುಗೀತು ಬಿಡಿ. 12/3 ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ. ಹಾ ಹೇಳಿ, ಇದೊಂದ್ ಸಾಲ್ವ್ ಆದ್ರೆ ಆಯ್ತು ಪಾಪ, ಅವ್ರು ಸಾಲ್ವ್ ಮಾಡ್ಬೇಕು.
Why is he
ಅವ್ರ್
shouting?
ರಾಜಕೀಯ ಯಾರು ಗೊತ್ತಿಲ್ಲ. ನೀವ್ ಎಷ್ಟು ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಸರ್? ನೀವೆಷ್ಟು ಹೇಳ್ತಾ ಇದ್ದೀರಾ? ಇಲ್ಲ ನಿಮ್ಗೆ 16th ಆಯ್ತು, 12th ಆಗಲ್ಲ. ರೀಚ್ ಆಗೋದಾದ್ರೆ BC ಅಲ್ಲಿ ಬಂದಿದೆ. ಆಯ್ತೇನಪ್ಪ? ಅವತ್ತು ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಆರಾಮಾಗಿ ಮನೇಲಿರಿ. ಇನ್ನೇನು ಅವತ್ತಕ್ಕೆ ಇವತ್ತೇ ಒಪ್ಕೊಂಡ್ರಲ್ಲ ಅವ್ರು. ಆಯ್ತು. ನಿಮ್ಮ ಅಣ್ಣ ಅನ್ಕೊಂಬಿಡ್ರಿ, ಮುಗೀತಲ್ಲ ಕೆಲ್ಸ. 12th ಈಗ ಕರ್ಕೊಂಡೋಗಿ ಕಾಫಿ ಕೊಡಿಸ್ರಿ ಅವ್ರಿಗೆ. ನೀವು ಹೇಳಿ ಡೇಟ್ ಕೊಟ್ಟಿದಾರಲ್ವಾ? ಯಾರು ಇವತ್ತು ಯಾವ ಮ್ಯಾಟ್ರಲ್ಲಿ ಇತ್ತಪ್ಪ? ಸರ್ ಅದ್ರಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಅಂತ ಇದೆ, ನೀವು ಅಡ್ವೊಕೇಟ್ ಇದ್ದೀವಿ ನಾವು ಅಂತೀರಾ? ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 35 ಗೋವರ್ಧನ್ ಅಂತ. ಈಗ ನನ್ಗೆ ನಾಳೆ ಯಾರು ಬಂದು ಕೇಳಿದ್ರೆ ನಾನು ಯಾರಪ್ಪ ಫೋನ್ ನಂಬರ್ ಹೇಳಪ್ಪ, ತಪ್ಪು ಕೊಡ್ಬೇಡಿ ಅಷ್ಟೇ. 9980 3366 9980 336601. ಹೆಸರು ನಿಮ್ಮ ಹೆಸರಾ? ವಾಚ್ ಯಾರಪ್ಪ? ಯಾವ್ದ್ರಿ ನನ್ನ ಕೆಲಸ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೆಲಸ ಅಲ್ಲದೆ ಪೊಲೀಸ್ ಕೆಲಸ. ವಿಶಾಲ್ ಆಯ್ತು, ಅದೇನಾ ವಾಚು? ಆಯ್ತು.